Well, good morning, everybody, except the Red Sox fans. No, I'm kidding. I'm just kidding. Welcome to you guys, too. Welcome to you guys, too. I'm going to pay for it. It's fine. It's fine. I talked my shit. Got to take my payback, so feel free to let me have it in the comments. Let me have it. You can't say anything worse to me than having to watch that fifth inning. So we're even in the series, guys. Tonight's it. Tonight's it. Oh, man. I thought we were getting a NOLA start last night, but no, the NOLA start is tonight. So I feel really good, but I'm going to temper my comments somewhat about baseball today. Well, we're coming back with more of Lieutenant Tully, and so far, you know, Lieutenant Tully is the only one who seems to have had anything at all to say about Trooper Proctor's text messaging. The kinds of things he's saying about the suspect, about his investigation, the fact that he's spilling all this confidential stuff to his friends who are not in law enforcement, the fact that he's making jokes about searching for nudes. I mean, if it's a joke, he says it's a joke, but who knows what we can believe from him. Joking about searching for nudes with his supervisors who think it's funny. And yeah, so far Tully is the only one who has penalized him at all by giving him that admonishment. Told him he was very displeased and then sent it up the chain of command. And so I gotta wonder, thinking about this, what exactly was he displeased about? What part of it was he displeased about? I wonder if we're going to hear about that on Cross. Was he displeased at the name calling? Was he displeased at the prejudging the investigation? Was he displeased that he got caught and that he dragged these other people, these other members of the state patrol, supervisors even, into his little mess? What exactly was he mad about? I gotta wonder. Gotta wonder. No, they won't go there on Cross because he'll just say, oh, they were unprofessional, below the standard of what we expect from our troopers. And he won't get into details about, you know, the fact that you have decided from day one you're not going to look at the homeowner because he's a Boston cop, and her, you know, you're gonna get her. You're gonna get her. She's gonna catch some serious charges. Because of course the compelling evidence led them to that conclusion. Why? Because trust me, bro, because they say so. They really do. They really say so. And the jury is sitting over there going, are we going to get to see any of this compelling evidence? Have you thought of maybe showing that to us? So as far as direct goes, the rest of this direct, I don't really know what to expect from Tully because I'm not entirely sure what other involvement he had. I don't know if he had any other involvement really besides this SERT search. And so I'm really expecting the Cross to focus on just a couple issues. I think the fact that he is one of the evidence clerks is kind of important, because he's already set up this sort of explanation for why we saw all of those items getting booked into evidence on February the 4th, 6 days after they were collected, right? The clothing from the hospital, we're suspecting these plastic pieces from the SERT search because everything that went to the crime lab had a 2/4 February 4th label on it. Still awfully curious about John's phone, right? Supposedly got to Trooper Proctor there on day one. He kind of set up this explanation about how, well, you know, only a few people have access to the evidence system, and so they're the ones who have to log everything in. Kind of suggesting that, like, well, maybe it just doesn't happen if somebody's not there. So I'm curious about the staffing of this evidence room. Why would you leave the evidence room unstaffed? Why would you leave it unstaffed? That doesn't make any sense. That's kind of a priority, to have somebody there to be able to secure evidence in cases. But even if you do, even if you do understaff it, you don't have it, you don't have somebody there 24/7, you're still one of them. You're still one of the people who can do that. You can do that. And you were there at that station, at that Norfolk DA's office, the night of the night of the SERT search, the night of the 29th. You were probably even part of that, tete-a-tete, that recap, that meeting that Trooper Proctor talked about at the end of the day, where everybody just kind of put their heads together and got all their information and stuff. Because, it's a group thing when it goes terribly, terribly wrong. When it goes great and you make a right call, you're going to take the credit for that. But no, when things go badly, it's everyone. It's everyone's fault. So he was there. Why on earth didn't he book all this stuff into evidence right then in the secure room so that there would be no questions about things like who had access to the plastic, who had access to the clothing, who had access to all of this stuff? And then the other thing that I would expect to hear about, since he was in charge of that SERT search, he's the senior guy on scene. He's the one that's keeping the evidence log, tracking everything, taking the photos. It's his search. Who are those mystery people that we heard about from Lieutenant O'Hara? 3 mystery plainclothes people that just happened to be there. I mean, if they're plainclothes, first off, I'm not sure, how did you know they were law enforcement? He didn't know who they were. How do you know these are plainclothes police and not just rando civilians hanging out there? I don't know. I don't know how you tell that. They're plainclothes. They're in normal clothing. But then you are the search guy, so it's your scene. It's not just your search, it's your scene, and you need to control that scene, right? You can't have random people wandering in and out of that scene while you're conducting your search. So very common, normal procedure with a search like this, you keep track of who is coming in and who is going out of whatever the area, whatever the area is. And so you keeping track of who's over there? I don't know. Maybe he'll just explain, if they didn't actually go into that 5-foot by 6-foot area that they were searching, then it doesn't matter. They can go ahead and just mill about watching somewhere out there, and you'd have no concern. Wouldn't even ask, "Hey, what's up, guys? Who are you? What business do you have here?" Maybe he recognized him. I don't know, but I'm very curious about the identity of these three mystery plainclothes people. I mean, what do we suspect? We suspect it's CPD, right? Because they're not supposed to be there, and yet they couldn't keep their fingers out of this investigation. So, yeah, this is the guy I would expect to know. I'd expect him to know that kind of thing. So other than that, don't really know what to expect from old Brian Tully. I think we're done with the forensic theater, the contamination theater, right? The gloves that we're gonna pull out of our dirty suit pocket and then use to rub all over the different individual items that you had in those secured evidence bags. These guys never heard of changing. You change your gloves. You change your gloves in between handling items of evidence. That's how you prevent contamination. That's the way you do it. It does nobody any good if you put gloves on and then use the same gloves to touch absolutely everything on the scene. But that's what these guys are doing over and over and over again right in front of us. Gloves on, handle the outside of the bag, handle the scissors, handed to them from the court reporter, putting their hands all over the wooden parts of the stand, all over the bag, inside the bag, on the items, on the other items. I mean, it's theater. It's not good theater. This is like daytime soap level CSI stuff. Just pretty ridiculous. This guy also had training in, made a point to call out his training in the use of cell phone information in investigations, particularly in death and drug investigations. It seemed to be his focus. So it's possible we could get some questions about that, because you would expect there's quite a bit of information that one could have gotten from John O'Keefe's cell phone, besides, of course, just looking around for ring videos, that would help to sort out what his final moments were. And I'm talking very specifically about GPS data. GPS data. GPS data is pretty precise. Pretty precise. I mean, you see all kinds of different calculations for exactly how precise it is, but you're often talking, 10 feet. And there's definitely more than a 10-foot variance from that curb where Karen Reed's SUV was parked and inside that house at 34 Fairview. So you might expect, if you were interested in knowing if John O'Keefe went inside that house, you'd be looking for GPS data. One of the comments that I've seen about the phone and the data, and I remember from back, I think it was Brian Albert's testimony, he talked about there's kind of a dead zone there at his house as far as cell service goes, and that's not not uncommon, just for a whole variety of reasons, how the towers are configured, what the topography is of the area, and what the atmospheric conditions are can affect cell service and stuff as well. But GPS doesn't work off of the cell network. The cell network is land-based. GPS is satellite-based. So you don't typically have the same types of problems with GPS signaling that you often have with cell signaling. And so that also means you can be putting out GPS data, GPS information, even if your cell phone isn't connecting to the cell network, even if you can't make a phone call, even if you're not going to ping off a tower and they can't necessarily get that info, you can often still get GPS info. So I don't know if they got any of that or not, but I would certainly expect them to have looked. I would expect them to look. I mean, there's tons of apps on people's phones that will pick up location information, GPS information. And I don't just mean these things like the Life 360s and the Stravas and things like that, Google Maps that are specifically there to pick up location stuff. If you got location services on in your phone, then a lot of your apps are going to be picking that up, because that's part of what they use to then target your advertising, to shoot you which ads you need to be looking at based on where you are and where you've been going. It's one of those things that happens that can just be, I don't know, I find it a little alarming sometimes. It seems like today something crosses your mind. You haven't thought about it for years, and the next thing you know, your phone is trying to sell it to you. It's crazy. Okay, it's some weird stuff sometimes. But location services is how some of that information gets collected and gets filtered through and processed, and then reserved up to you in the form of things that you should buy. So I would expect them to be looking for location information on his phone. And I would want to know, did they? Did they? Why are they looking at Ring camera video on John's phone? This again goes back to the same security issue as with Karen's phone. This is not how you handle a cell phone. You don't sit there with their phone and thumb through it. You do your extraction. You do the extraction, and then you look through the extraction to see what is there that's of interest that you can find. What's within the scope of your warrant, right? Your entire phone is not within the scope of a search warrant. That is an overbroad warrant. Warrants have to be targeted. They have to be focused on specific items of evidence that are likely to be found in a particular location. So, I mean, why are they thumbing through his phone? Did they just extract it? I mean, that's not what it sounds like. But I don't know. I don't know. Maybe it was. It's just that there's no reason, if they did an extraction report, that DeChico and Proctor couldn't both, couldn't be looking through it at the same time. He couldn't rely on DeChico and then go back and look himself. I mean, I don't know. But I do know you'd have to get into that cell phone if you wanted to delete videos. You couldn't do that from the extraction report, could you? You'd have to be in the app to be able to do that. If you're going to change data, alter things, create new things, make things vanish, yeah, you got to do that from in the phone. So that's certainly a reason why one might be thumbing through the phone rather than just reviewing the extraction report like normal police officers conducting an investigation that has integrity would be doing. They'd be looking at the extraction report. So maybe we can ask Tully about some of these things, some of these judgment calls. And that might fit in with, I could see a lead in there challenging him on, so you reprimanded Proctor over these comments. You made it clear that you were very disappointed in him. He's been a bad boy. So bad. Now go back out there on the street and do more police work. What exactly were you mad about? Were you mad about what he was revealing about how this investigation was going to unfold and the fact that it was not going to look at anybody but Karen Reed? It was going to nail Karen Reed. That's what the investigation was about. And so if you look at the decisions that were made in that light, it might make some sense. Might tend to corroborate, if you were trying to avoid seeing things that might challenge your theory that Karen Reed hit him with her car and he never went inside the house, some things you might avoid looking at might be things like the GPS data in the phone. So did they look at the GPS data in the phone? I don't know. Maybe Tully's not the guy to ask for that, Proctor seems like the guy to ask for that, right? He's the lead investigator. Maybe Guarino's the guy to ask. It's hard to tell with all the little hot potato that's getting played now, the little pass the buck. No, that wasn't me. That was Guarino. No, that was Tully. No, that was somebody else. A lot of people getting thrown under the bus right now. You gotta kind of wonder why. Why are they scrambling? Why are they scrambling? Why aren't they all running to take credit for this fine work? This compelling evidence that they gathered and put together. What, they're not proud of that? Weird. So I could see getting a little kind of what is normal to do given your training. Go ahead and elicit that from Tully. You use cell phone data to solve crimes. So here's some way that John's cell phone could have helped solve the crime, right? You could have looked at his text messages. You could have looked at his location data. Did you do those things? Don't even necessarily have to ask him, did you do those things? You just wait for the state to put on that they did. Just get from this guy that's the kind of data that's available and that's what you should do in an investigation. And then just wait for the state to not put it on. Point out to the jury, yeah, they didn't do that. Didn't do that. We even kind of highlighted it, kind of signposted it back there with Lieutenant Tully. Hey, phone data, things you should look at. Did you look at them? Did you look at them? I don't know. Suppose I can't rule out that they did in fact do it. Suppose I can't rule out that they did actually, look at GPS data. Guess we'll have to wait and hear. We'll see. I saw this come up, so I wanted to go ahead and address it because it's quite timely, right? Would it have been better for Proctor to plead the fifth for the prosecution, less of a disaster? That's a tough one. That's a tough one because the jury is going to assume the worst. If he pleads the fifth, then that means he doesn't testify. Why? They all want to know why. Why does the guy, the point of the spear, the case agent, the lead investigator? Let's not play word games. He's the lead investigator. He's the one who's running the show. Coordinating, yeah, that means you're getting the input and you're making the decisions about where to go with it. Why is he not testifying? There's no way that they aren't going to be wondering that. Oh, guys, it looks like we're on. Let's go ahead and bring her up.
All right, good morning, counsel.
So I will come back to this
morning,
this comment
jurors.
here. Talk about
I
that a
have to
little
ask you
bit
those
more.
same three questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said
They
yes.
did.
or
It
nodded
fell apart in the fifth
affirmatively.
inning. We
Did
were ahead
anyone
4-0,
happen to see,
and then
hear,
it just
read
fell
anything about
apart,
this
and
case?
it got really ugly.
Everyone
Never
said
came
no.
back from that. So it was a bit
Can you
painful.
have Detective
But it's
Lieutenant
okay. There's
Tully, please?
one game left in the series tonight, so. And even the best teams in baseball have to lose sometimes. You can't win every single game. You're still going to lose like a third of games. So,
You tell me, sir, you ever change the court and jury in the case down here, and you the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Whenever you're ready, Mr. Lally.
Good morning, sir. Good morning. Again, if you could just please state your name and spell your last name for the jury.
Brian Tully, Tully.
Now, Lieutenant Tully, you were testifying yesterday. You were testifying in some part about a search that you did in conjunction with the SERT team at 34 Fairview on January 29, 2020, right?
Yes.
And at any point in time, did you or any other member of your unit conduct any search of the residents at 34 Fairview Road?
No.
And why not?
We had no reason to believe there'd be evidence found within the home of 34 Fairview Road.
Now, Lieutenant, if you could you inform the jury a little bit about sort of search warrants as far as residences go and what is required in Massachusetts for you to conduct a search warrant?
objection.
So we haven't heard the question.
That was the question. Tell us about it. He invited a
I thought
narrative.
it was you informed the jury about search warrants and then what?
If I interrupted
Can you
you,
repeat your question?
I did, Your Honor, yes.
Okay. So it's sustained then.
thank you.
As far as, Lieutenant, over the course of your career, you've conducted search warrants of people's residences, correct?
Yes.
What do you need to do?
A search warrant, consent, or exigent circumstance.
And as far as a search warrant
is that
concerns,
it?
what
Well,
do
there's
you-
more, but
what is needed or what is necessary in order for you to get a search warrant?
Objection.
Jody, tell Timmy to be quiet.
Tell who to be quiet.
So I'm going to allow him to build a foundation here. So the objections are overruled.
As governed by the Fourth Amendment of the U.S. Constitution and Article 14 of the Massachusetts Constitution, law enforcement is required to get a search warrant if we're going to invade someone's privacy. In order to obtain a search warrant, I need to gather facts that I swear an oath and affirm that are true and accurate, that there is probable cause, which means more likely than not that a specific piece of evidence will
Oh,
be
it
found in
does
a
mean more
specific
probable than
location
not?
and it's related to a
doesn't,
crime.
but-
So I need to check those boxes in order to
overstating
obtain a
that.
search warrant through the trial court.
And what, if any, information did you have related to specific evidence of a crime in relation to the interior of the residence of 34 Fairview Road?
I didn't have any. When thinking about residents and search warrants and evidence, I need to put the evidence inside the house. And so I don't believe that Mr. O'Keefe entered the home. So I had no nexus to the house.
And what, if any, evidence did you have that Mr. O'Keefe had ever entered the home at 34 Fairview Road on January 29th or on any other day?
I don't. On the contrary, I have evidence that he was outside, but I don't have anything putting him inside the residence.
Now, you're aware that, or you
But what if he
testified
looked at his
yesterday that
GPS?
at some point while you and the SERT team were conducting the search at 34 Fairview, that Sergeant Mechanic and Trooper Proctor were following a tow truck with the defendant's vehicle from Dayton to the Canton Police Department, correct?
Yes.
And in reference to taking the vehicle to the Canton Police Department, how was that decision arrived at? What, if any, discussion or what, if any, other options do you have?
So Sergeant Mechanic and I had conversations. It was ultimately my decision of where the vehicle was going to go. And so we need to find a location that was secure, indoors, and preferably heated. And so we start going through checklists of what's available. So you start thinking, obviously, of state police facilities. So between Dayton and Canton, where our office is as well, you have the Foxborough Barracks, which was, I worked out of the Foxborough Barracks. The garage was probably not appropriate for that large vehicle to get in there. It's an old building. I worked at the State Police Barracks in Milton. That's even worse with a smaller garage that's attached inside of an older building. So the Canton Police Department was the next step. It was kind of checked all those boxes. It was inside, it was secure, and
So we
it was
just
heated.
overlooked the conflict. That wasn't a rule out.
Now, over the course of your career, specifically within the homicide units of the detective unit of the district attorney's office, approximately how many investigations have you led or been a part of in relation to? Let me first ask you this: as far as your unit is concerned, how is it that, from a staffing perspective, how is it that an investigation is conducted as far as certain roles, or can you speak a little bit about sort of the roles that different people within your unit play with reference to an investigation, just in the general sense?
Within the unit, we have different sections. We have the homicide section, narcotics section, and special investigations. So each is kind of broken up into that. Obviously, the homicide section will undertake homicide investigations, but we work as a team. So there'll be situations where you may need an all hands on deck just to get some people out there. So the narcotics folks will help with homicide investigations and vice versa. The homicide people will help with narcotics investigations when needed.
Your Honor, may I just have a moment?
Yes.
You got nothing else, Lally? That's it.
Now, specifically when it comes to a death investigation, there's someone who's assigned as what you call a case officer, is that correct?
Yes.
And can you explain to the jury what the role of the case officer is and what, if any, other sort of supervision there is with reference to that case officer?
The case officer is essentially the central collection point for the investigation. So they are the person that would gather the evidence, the records, hold those records, and then somebody needs to be held accountable for a to-do list or something to do. Supervisor would go to that one person. as well as the district attorney's office would know who to contact about a certain case, and then we'll go from there. Obviously, that case officer usually is a rank of trooper, especially when you're talking about unattended deaths. They have a sergeant and 2 lieutenants that are supervising them in that realm.
And as far as interviews are concerned, what, if any, sort of policy is there with regard to troopers and how many would be involved in the interview, if any witness?
We would always have 2 people present, either a trooper and a local detective or 2 troopers. Just one ask questions, one take note taking. It's just good practice.
And with respect to this investigation, the locals, as far as the Canton Police Department, was not something that you utilized, correct?
Correct.
And again, I know you testified a little bit about it yesterday, but if you could just reiterate or expound upon sort of what
No
your
interviews, just
discussions were with the
stored
chief
the
as far
murder
as
weapon
Canton
there.
Police Department's involvement in this investigation going forward, following the early morning hours of January 29th.
Our conversation circled around in the early hours about the homeowner of 34 Fairview, which was Brian Albert, has a brother, Kevin Albert, who was a detective with the Canton Police Department. And so where we were, we had essentially zero information about the investigation. We wanted to remove any appearance of conflict by not having Kevin Albert or any of his coworkers involved in the investigation.
Was that in the investigation in its entirety, or the interviewing process, or how was that sort of delineated, if at all?
Definitely no interviews. They were not involved in any discussion. Essentially the entire investigation.
Mm-hmm.
And as far as the case officer is concerned, is the case officer someone who, particularly in a homicide investigation, is as far as a decision regarding charging, is that something that the case officer would be tasked with?
No.
Now, turning our attention back to your testimony yesterday, there were items that you had retrieved from search on January 29th, correct?
Yes.
And as a precursor, if I could ask you sort of, over the course of your career, specifically within the homicide unit with the district attorney's office, about how many death investigations, homicide investigations have you been involved in?
I would say in excess of 600 unattended death investigations that I personally investigated. That's not counting those phone calls the calls I end up declining that I'd mentioned yesterday. In addition to that, I probably have either worked or supervised 75 homicides. And then getting back to the unattended deaths, I've supervised countless since I've attained the rank of trooper and sergeant and lieutenant.
And with respect to your training and with respect to your experience, how many of those investigations have involved injuries which included abrasions?
Probably 10 to 20% of them.
And if you could, at least from your understanding, if you could explain to the jury what your understanding of what is an abrasion.
Objection. Sustained.
Medical stuff. Trying to back up the use of that term.
With regard to the items that you recovered on January 29th, there was one piece of clear plastic you testified yesterday had something that you termed as stippling on the outside, correct?
Yeah, I may have used the word dimples, but yeah.
Now, with respect
It's
to
not stippling.
Mr. O'Keefe, at some point, did you have occasion to view photos of Mr. O'Keefe from the Good Samaritan Hospital?
Yes.
And with regard to the items that you recovered, what, if any, significance did you observe between those items and the injuries that you observed to Mr. O'Keefe?
The injuries to Mr. O'Keefe, I noticed the abrasions had a certain pattern on them. And I know that when a blunt force object is involved in causing an abrasion, the characteristics of the object that comes in contact with a person will often leave the characteristics on that person
really?
in the form of an
You're feeding
abrasion.
us some bite mark bullshit right
And
now.
with respect to this specific case, as far as any items recovered on January 29th and your observations of Mr. O'Keefe, what, if anything, did you observe
Oh,
of any
please.
significance in
Bev's going to
relation to
allow this.
I'd be comfortable in saying that the marks on Mr. O'Keefe are consistent with.
Objection.
Sustained.
Uh-huh.
Now, sir, if I could turn your attention.
He was about to give us some bite mark bullshit. picks up the characteristics of the item? No, it doesn't, because your skin is soft and it deforms.
Two other
the body
members
deforms.
of your units are troopers
It is
by
the
the name of
junkiest
Trooper
of
Dunn
junk
and Trooper
science.
Moore, is that correct?
Yes.
And on February 2nd, 2022, are you familiar with them retrieving some video in relation to this investigation?
Yes.
And specifically from the town of Canton, did they retrieve video from there?
Yes.
And specifically, what location did they retrieve video from?
From the Canton Public Library at 786 Washington Street.
And are you familiar with them speaking with a gentleman by the name of Mr. Jutras?
Yes.
And he's an IT person with the town of Canton.
He is.
And as far as the timestamp with regard to the video that was retrieved from the Canton Public Library, what, if any, information do you have in reference to that?
Whenever we retrieve video, we want to ensure the timestamp is accurate, because as we've learned, businesses are not always great about updating the timestamp. So that's always top of mind when we collect video. Mr. Jutras ensured us that the timestamp on the video was consistent and in real time.
Now, the following day of February 3rd, you familiar with Trooper Moore retrieving some additional surveillance video?
Yes.
And where did he retrieve that video?
From Temple Beth Abraham in Canton at 1301 Washington Street.
Now, as far as those two locations, as far as the Canton Public Library and the Temple Beth Abraham, are you familiar with where they are in relation to each other?
Yes.
Both located on Washington Street, is that correct?
Yes.
And about how far away from each other are they?
About a mile and a half.
Now, with reference to the Temple video, what, if any, information did you receive in regard to the timestamp on that video?
That was also accurate.
Now, from each of these respective locations, what time frames was Trooper Moore in one instance and Trooper Moore and Trooper Dunn in the other instance? What time frames of video did they retrieve from each of those respective locations?
From 12 a.m. midnight to 1 a.m. and from 5 a.m. to 6 a.m.
And why was it that those were the time frames, based on what you learned to that point in the investigation, why were those the time frames that the troopers were looking for?
We had reason to believe that those were the times that Miss Reed's vehicle was traveling in and around that area.
And we'll get to that a little bit more in a moment, but as far as reason to believe that Miss Reed's vehicle was traveling in the area around those times, what, if any, information did you have to base that on?
We had statements and video from the Waterfall Bar and Grill, also on Washington Street, a little bit further down, and the car departing in that direction. We had information about a car that matched her description arriving at 34 Fairview at a certain time, shortly before 12:30 a.m. And so, like we always do, we do a video canvas and look for video cameras from that first known point, which would be the Waterfall Bar and Grill, to the residence of 34 Fairview, and then from there, from 34 Fairview to 1 Meadows Ave, which was the home of John O'Keefe.
In reference to the morning hours between 5 and 6 a.m., the later morning hours between 5 and 6 a.m., what, if any, information did you have in relation to Ms. Reed's travel at that time?
So we had learned through interviews that she was calling people as early as 4:45 in an effort to locate Mr. O'Keefe, and a statement that she had left the house shortly after 5 a.m. We then know that she arrived at the McCabe residence on Country Lane after 5:30. So we're trying to account for the movements of the vehicle for that 30-minute block.
Now, in reference to phone calls, you've had occasion to review information related to the defendant's phone.
Yes.
Now, you mentioned that about 4:45 in the morning, she made phone calls trying to ascertain, or allegedly trying to ascertain the whereabouts of Mr. O'Keefe. Is that correct?
Yes.
Prior to those 4:45 a.m. phone calls, were there other phone calls that the defendant placed?
Yes.
And to whom did she place those calls and about what time?
Starting at 12:33 a.m. to 6:03 a.m., there were 53 phone calls from Ms. Reed to a phone number associated with John O'Keefe.
And in addition to those phone calls to Mr. O'Keefe's phone, what, if any, other calls did the defendant make prior to those 4:45 a.m. calls?
There were phone calls to her family members, to Jennifer McCabe, Kerry Roberts, Cameranos. Those are the ones that off the top of my head. I have the notes in front of me if I want me to refer to them.
You all right to witness bank?
Yes.
Would you like me to continue, ADA Lally?
Yes.
After 6:03, when Mr. O'Keefe was found, there are a number of calls to members of John O'Keefe's family.
No, the phone calls to family members of her own, the defendant family members, those were specifically to her mother and her father, is that correct?
Yes.
And did those phone calls precede the phone calls to either Ms. McCabe or Ms. Roberts or anybody else earlier that morning?
On the call detail records, they don't appear, but I know the phone dump has other information.
Your Honor, may I approach?
Yes.
Lieutenant, turning your attention back to the videos we were speaking about, showing you with this, just ask you if you recognize that.
I do.
And what do you recognize that to be?
It is surveillance video from Temple Beth Abraham.
May I approach again, Your Honor?
Yes.
I won't proceed to introduce the witness in the next exhibit.
No objection.
Thank you.
So now they're treating this guy like he's the lead investigator.
May I approach again, Your Honor?
Yes.
I mean, he didn't have anything to do with this, did he?
When you were done the document, you recognize that, sir?
I do.
And what do you recognize that?
It is a map I created with icons of the town of Canton.
And how did you create that map, sir?
Using Google Earth as the mapping software, I placed icons on locations within the town of Canton that are relative to this investigation to provide better context and illustrate the area that we're going to be discussing.
May I approach again, Your Honor?
Yes.
Great.
I
So
won't
he
proceed to
wants some
introduce the
tips.
next exhibit.
No objection.
Thank you.
Exhibit 573.
And Your Honor, may I return exhibit 573 to the witness?
Yes.
Your Honor, with the court's permission, if I could publish that to the jury at this time?
Yes.
Lieutenant, do you have the laser pointer there before you? Okay.
I do.
So using that laser pointer, if you could direct the jury's attention to the icons that you inserted in reference to various points of relevant locations, as well as any sort of routes of travel or roadways depicted in this particular.
So each icon is a house-shaped icon that I had placed at different locations. The first one is red in color. It denotes where 34 Fairview Road is. Starting at the bottom, there is a pinkish color one that is the location of the Waterfall Bar and Grill. Just north of that, you'll see a brown one, which denotes the Canton Public Library. Following up this street here, which is Washington Street, you'll come to Temple Beth Abraham, which is denoted by the blue icon there. And then off to the right is One Meadows Lane with the green icon.
Now, as far as, and if you could just use that laser pointer again to know where the temple is.
It is the blue icon in the center of the map.
The temple seems to me like the only one
located in reference to specific roadways.
you would drive past to get from Fairview to One Meadows
Yes.
Ave.
And so what if any roads intersect with Washington Street around the location of the temple?
Chapman Street
That's
is the street that
Chapman down
runs
there,
in this
yeah.
direction towards Washington Street. So
You'd go down to Chapman,
again,
you'd
the
take
Washington Street is a
all
street
the way
here.
over to Meadows,
It continues
and
and
you'd go
stays
down.
Washington Street as it turns slightly east in that direction.
And as far as available points of directionality or ways to travel roadways from the area of the temple, it intersects in the area of Devon, is that correct?
Yes.
And so as far as available routes of travel from Temple to 34 Fairview, if you could note those on the map.
If one was at the temple and were to travel to 34 Fairview, you could continue up Washington Street, take the left onto Dedham Street, which is that street you just mentioned, a left onto Cedar Crest, and to enter that neighborhood down here. One could take a left and
So you
come
could avoid
down
Temple
Chapman Street
altogether to get to
and
One
take the
Meadows.
right to enter the
that
neighborhood
wouldn't
in that direction
be-
straight onto Fairview Road.
Peculiar at all.
And if you're approaching sort of from the Chapman Street side of Fairview Road, as you come down Fairview Road, which side of the road would 34 Fairview be on?
Left.
And similarly, if you're approaching from the Cedar Crest side of Fairview Road and turn on Fairview Road, which side of the street would 34 Fairview Road be on?
Right.
Thanks. Now, with respect to each of these videos, as far as the Canton Public Library video and the Temple video, these are exterior cameras, is that correct?
Yes.
And sort of orientation-wise, where do they focus on or where are they pointed at?
The ones that we focused on were the ones that captured Washington Street.
Now, are you aware of another location
Why?
right around the area of the Temple Beth Abraham called Cassie's?
Yes.
And that's essentially like a convenience store, is that right?
Yes.
And were you able to, you or other troopers able to retrieve video from that location as well?
I don't believe so.
Now, Your Honor, with the court's permission, if I could publish a portion of the video from the Canton Public Library, which is marked as Exhibit 110.
Yes.
Okay.
And Ms. Gilman, if you
Pretty sure we
could,
already
from the
saw
first,
this,
video.
Because we saw all that bare grass. Yep. How it
From the
should
time of
have
the video,
looked
I'd ask you to go to about
when
12:50.
John landed on the ground. Should have looked like that.
I'm sorry, 15 or 50?
50, 1-5. Now, again, for orientation purposes, Lieutenant, if you could, using the laser pointer, just describe to the jury sort of what we're looking at here directionality-wise and what you observe in this video.
The main street in the video is Washington Street. The Waterfall Bar and Grill would be off to the right-hand side, and Temple Beth Abraham would be off to the left. The intersecting road we're looking at here is Sherman Ave, I believe.
And if one were to take that right, if you're coming from the right of the screen to the left of the screen on Washington Street heading towards Sherman, and you were to take that right on Sherman, where does that take you?
You would head towards the neighborhood that One Meadows Ave resides.
Now, were you also able, over the course of the investigation, did you have occasion to look at surveillance video from the Waterfall Bar and Grill itself?
Yes.
And from that video, were you able to determine a time at which Mr. O'Keefe was leaving from that establishment?
Yes.
And what, if any, observations as far as time, or what, if any, observations did you make as far as what Mr. O'Keefe was doing or had with him when he left the office?
When he left shortly after midnight, he was holding what appears to be a clear glass container.
And do you recall which hand he was holding it in?
His right.
And specifically, that was about 12 or 11 a.m., is that correct?
Yes.
And Ms. Gilman, if you could, I'm going to ask you to press play here and then pause again at 12:15.
So we're hearing some words, right? Not quite sure why we're hearing these words, but I think if the Commonwealth gets some words out there, the jury might mistake that for having a case and a point. Yes, we know he was holding a glass. What does that have to do with this
Looking up at the
video?
screen now where it's paused at 12:15:58, Lieutenant, what, if anything, do you observe there?
I observe a large black SUV here on Washington Street.
And the large black SUV that you observed, is that consistent with what you've observed of the defendant's vehicle?
Yes.
And
Is it consistent with other
describe
black
to the jury
SUVs?
as far as when I asked Ms. Gilman to press play, what is that vehicle going?
I don't know.
It's going to continue north on Washington Street through the intersection on Sherman and continue north on Washington Street.
And what, if anything, is sort of in that directionality as it continues off of the screen to the left?
Be heading towards Temple Beth Abraham.
Gentlemen, if you could. Ms. Gilman, you can pause it there. Now, with respect, Your Honor, with the court's permission, if I could publish portions of the Temple video,
Yes.
and just as a continuing, my intention would be to sort of go back and forth if that's all right with the court.
Okay.
So
Yes.
Lally's establishing for some reason that, you know, she did in fact drive him from the waterfall to 34 Fairview, which I'm pretty sure
And
we
one moment,
already
John.
know.
Yes.
But let's really hammer it home. It's on video that she took John there.
And if you could pause there, thank you. Again, for orientation purposes, Lieutenant, if you could describe using the laser pointer there as far as what we're looking at in this particular camera angle and shot, and as far as the roadways that you use.
This is an exterior camera from Temple Beth Abraham at 1301 Washington Street. Where it's paused now at 1201, I believe is the timestamp, you see a vehicle. Here, that vehicle's traveling on Washington Street. We are
my
now on the
God,
other
this is
side of
supposed
Washington
to- we're
Street
supposed to be
looking
able
at
to
it than we were
identify
from the
Karen's
library.
car from that.
So the south and towards the waterfall and the library would be off to the left. North would be off to the right.
And Ms. Gilman, if you could fast forward to
Ridiculous.
1217.
This is 2011 to 2016 white Hyundai Elantra kind of bullshit right here.
If you could pause it. Now, as far as the time concerns, the video from the prior video from the library was about 12:15 a.m. when you saw the vehicle consistent with the defendants pass by that location.
Yes.
And so as far as this time that's up here now, approximately 12:17 or so, or somewhere within that minute between 12:17 and 12:18, is that consistent with the time it would take to travel from where the library is on Washington Street to where the temple is on Washington Street?
Yes.
And from this particular time period around 12:17, between the minutes of 12:17 and 12:18, what, if anything, did you observe with reference to, of significance with reference to this investigation on this portion of this video?
At approximately 12:17 and 56 seconds, you'll see a large black SUV travel from left to right on the screen, which would, again would be northbound.
And again, left to right on the screen.
Will we see that, or will we see some vague lights moving past in the dark?
Screen as far as of any significance to this.
As you continue north on Washington Street, you would, I believe the next intersection on the left is Dedham Street, which one could take to get to 34 Fairview Road.
And Ms. Gilman, if you could, and I would ask you again to pause at 12:17.
Riveting. We see some lights go by. Some lights. No real detail on these vehicles.
And again, Lieutenant, directing your attention to the screen, and if you could, using the laser pointer, direct the jury's attention to what, if anything, of significance you observe in this portion of the video at 12:17:56 from the temple.
A large black SUV traveling northbound on Washington Street.
And the
You
large
say
black
so.
SUV, is that consistent with the large black SUV?
We already saw
that you
what
observed in the
shadowing
prior
can do
video
with
to
that,
110 from the Canyon Public Library?
That
Yes.
shoe
Is that also
photo.
consistent with what you observed as far as your personal observations of the defendant's vehicle?
Yes.
Gentlemen, if you could please press play. Gilman, you can pause that, take that down, please. Ms. Gilman, if I could ask you for the Canton Public Library video again. And from this, I'm going to ask for from the second video.
Okay, now we
Lieutenant,
got
direct
some
your attention
snow.
to up on the screen. This is the Canton Public
Not a
Library
lot.
video
Look at
again.
those
if you
bushes.
want
There's a
that.
couple inches
Yes.
down
And
there.
as far as, this is the time frame that you were talking about before, between 5 a.m. and 6 a.m.
These were
that
the
troopers done.
whiteout
And
conditions.
more retrieved from Mr. Jutras, correct?
Yes.
And with reference to, as far as the conditions outside at this particular time between 5 and 6 a.m., what, if anything, do you observe in this video?
The ground is now covered in snow.
And Ms. Gilman, if I could ask you to fast forward to about 5:11 a.m. and pause it there.
We saw in that Temple Beth video how the roadway is still wet. It's bare because it's warm. It's a heat sink. The snow hits it and it melts
Now,
until it gets
Lieutenant,
cold
from
enough
this,
and enough
portion of
accumulates.
this video from the
that it
Canton
can
Public
stick.
Library, what, if anything, of significance
that's
did
where
you
the tail light
observe,
would be.
in this portion of the video
On
relevant
bare,
to this
wet
investigation?
ground.
You observe a large black SUV take a left from Sherman Street onto Washington Street, heading south.
And as far as the directionality from where that vehicle came from and the directionality where that vehicle is headed toward, what, if any, of the locations of significance are located in those areas?
So again, Sherman Street or Ave goes straight to One Meadows. So if one were to travel from Meadows Ave, the residence of John O'Keefe, to this location here, you would come down Sherman and you could take a left onto Washington Street to head south.
And as far as south on Washington Street, again, off to the right of the screen, what, if any, locations of significance in this case are located in that direction?
The Waterfall Bar and Grill.
Now, as far as the black SUV that you observe in this video, is that consistent with the black SUV you observed in the Temple video from 12:17 a.m.?
Yes.
Is it also consistent with the black SUV that you observed in the library video from 12:15 a.m.?
Yes.
And is it also consistent with the defendant's black SUV?
Yes.
Now, with reference to, are you familiar with Mr. O'Keefe's home having ring cameras affixed to it?
Yes.
And are you familiar with a video from those ring cameras depicting the defendant backing the black SUV out of Mr. O'Keefe's garage at approximately 5:07 a.m.?
Yes.
And from that, as far as distance or time it would take to travel from Mr. O'Keefe's residence to this intersection covered by the Canton Public Library, from 5:07 to 5:11, now depicted on the screen, is that consistent with the time it would take to drive that, particularly given the conditions?
Yes.
And Ms. Gilman, if you could, please press play. Ms. Gilman, if you could pause that. Now, Ms. Gilman, if you could fast forward to about 15 and 30 seconds.
So the passenger light went by, but we didn't get to see it.
Pause there, please. Now, Lieutenant, between these timeframes of 5:11 a.m. and 5:15 a.m., at any point in time, do you observe the black SUV traveling back in the other direction?
Yes.
And specifically, around 5:15 and 51 seconds, what, if anything, did you observe on this video of significance or relevance to this investigation?
A large black SUV will appear on the screen on the right-hand side and travel to the left-hand side, which again would be traveling north on Washington Street.
Now, as far as, again, directionality, north on
This is
Washington
what I'm
Street,
wondering,
left
too.
street would be towards the temple.
We
is that
don't have
correct?
to be
Yes.
guessing
And
if
as
this is
far
her
as
on these
the
videos, because you can get all of
operation
this
as far as
from
directionality
a
is
modern
concerned,
Lexus with a
what you
nav
observed,
system, with
in this area
connection
from
to the phone, a
5:15 a.m.,
Bluetooth
is that,
connection to the phone,
consistent
all
with
that
what you
stuff.
observed on the Canton Public Library video earlier at 12:15.
Yes.
What, did they
And
not
again,
like the
as far as
info
black
that they got
SUV
there?
that you observe in this, it's consistent with
'Cause
all
she
the
didn't
other
go to
black
34
SUVs you
Fairview?
observed in the video and the defendant's video, correct?
Yes.
And Ms. Gilman, if you could press play.
Nice small little plow there, creating a nice little snowbank. See right there?
And Lieutenant, if you could, using the laser pointer you have before you, direct the jury's attention to where you observe the black issue.
That's supposed to be her
Here on
car with
Washington
that
Street, near the
extremely red
intersection.
taillight back there.
Again, using that laser pointer, if you could just indicate to the jury as far as directionality where this vehicle is going to head on the street.
North would be to the left-hand side of the screen, towards Temple Beth Abraham.
So if you could press play again.
Not seeing a problem with that tail light.
If you could pause there, Ms. Gilman, you can take this. Now, Ms. Gilman, if I could ask for the Temple Beth Abraham video again. Your Honor, may I have just one moment?
Yes.
You can pause there, Ms. Gilman. For the record, this is from the Temple Beth Abraham video. This is from the period of 5:10 a.m. to 5:20 a.m., which is the second video listed down within those. Now, Trooper, with regards to this video, at some point around 5:18 a.m., what, if anything, did you observe of significance or relevance to this investigation from that period of video?
A large black SUV travel left to right on the screen.
And again, as far as directionality, where would that vehicle be coming from and where would that vehicle be heading toward?
The left side of the screen would be in the direction of the Canton Public Library and the Waterfall Bar and Grill. Off to the right, again, would be the intersection with Dedham Street, which one could take to 34 Fairview.
And as far as directionality, with reference to the earlier video from 12:17 a.m. from the Temple Beth Abraham, is directionality consistent in this video with what you observed at 12:17 a.m.?
Yes.
Now, Ms. Gilman, if you could play from 5:18.
So they want to say she went back to 34 Fairview before she went and got Jen McCabe and Carrie Roberts.
And Lieutenant, what, if anything, do you observe
What do we
in
see
this portion of the
blobs
video
with a
relevant to this
very
investigation?
red
A large black
taillight.
SUV traveling north on Washington Street.
And again, is that large black SUV that you observe here consistent with the large black SUV you observed in the prior videos and also consistent with the defendant's vehicle?
Yes.
And Ms. Gilman, if you could please press play again.
That's ridiculous. Okay.
Thank you, Ms. Gilman.
That
You can
could,
take that.
is Karen the only person with the black SUV?
Mr. Officer, we can have the lights back on. Now,
Yeah, without her vehicle or phone
Your Honor, if I could step a
GPS,
moment.
Sure.
this is meaningless.
Now, Lieutenant, through the course of your investigation, are you familiar with what time it was that the defendant, approximately what time it was that the defendant arrived at Ms. McCabe's home?
5:35 approximately.
And Ms. McCabe's home is located on Country Lane, is that correct?
Yes.
Now, from the
Why isn't
directionality
that on your
of
map?
that vehicle in the 5:18 a.m. Video, as far as timing is concerned, 5:18 to about 5:35 or so, is that consistent with the time it would take to drive from that area of the Temple Beth Abraham to Ms. McCabe's residence on Country Lane?
No, not if you were to drive directly there.
And so to that point, as far as what about that time doesn't match up? Is it too short, too long, or something else?
It would take you much quicker to get there. It's about 1.5 miles from Temple Beth Abraham to Country Lane, you would continue north on Washington Street and just take a left into the Country Lane neighborhood. So the time to travel, 1.5 miles.
And from sort of the distance between either that Temple video and either 34 Fairview Road or Country Lane, were you able to find, locate, or retrieve any surveillance video in those areas that would capture the vehicle?
No.
Now, as far as you had mentioned earlier in your testimony, when we were talking about the earlier 12:17 a.m. Portion from the Temple Beth Abraham video, the directionality of that black SUV, both in the 12:17 and the 5:18, where is Fairview Road in relation to the directionality of the SUV that you observed?
That SUV could take a left onto Dedham Street and then a left on a Cedar Crest to enter down to Fairview Road.
And from your knowledge of the area as far as travel is concerned, would from 5:18 to about 5:35 or so, would that allow for sufficient time to go from where it's viewable on the Temple Beth Abraham video for the vehicle to then travel to 34 Fairview Road and
They
then
had
travel
to build this
12
case on
Country
could
Yes.
because they don't have did. You have her phone, dude. Don't bullshit us. Did her phone go to 34 Fairview?
Now, I believe you had mentioned earlier in your testimony that at some point there were call detail records that were obtained in reference to the defendant's phone.
Yes.
And can you explain to the jury, as far as, let me ask you this first, with regard to call detail records and with regard to phones in general, what, if any, specialized training have you received
We already
or
know,
have you given
Lally.
in reference to those areas?
You already know he's been trained.
I've received over 200 hours of training relative to obtaining and using call detail records and cell phone data in furtherance of criminal investigations. Most recently, I've given talks and seminars about the topic.
Did she
I've
ping off
testified
towers in
in
Canton?
numerous courts around the Commonwealth about the topic.
Are you going to feed us that?
Now, can you explain to the jury sort of call detail records, what they are and how you would use them as far as utility in generally speaking in reference to investigation?
Call detail records are business records held by cell phone companies, specifically to this matter, that are created in the normal course of business. Typically, you would think about in a billing context. So if you think of your own cell phone bill, it would contain information like the date and time a communication occurred, the other phone number in which you communicated with, the duration of the call, that sort of bits of information. Obviously, as we're doing a criminal investigation, it's helpful to know with whom someone was communicating. Additionally, the cell phone companies memorialize other bits of information specific to what we refer to as CSLI, cell site listing information. They tell us the antennas that were used during the communication, usually just in the form of the first antenna and the last antenna. There are other engineering records that we can obtain that can be helpful when trying to determine where the handset, the cell phone was at any given time.
And the handset that you refer to is essentially the phone itself, correct?
Yes.
And with relation to the handset and its connection to antennas or towers, can you speak a little bit about that based on your training and experience?
They're going there.
To,
they're going to give us pings instead of GPS.
How a handset sort of communicates with an antenna and how it gets to a specific antenna.
Cell phone companies place antennas all around to help facilitate communication. You can think of a cell phone as really a two-way radio. It's sending and receiving radio waves. So in order to facilitate that, cell phone companies place these antennas all around. Traditionally, you can think of them on a tower, but they can also be placed on the side of buildings or disguised as trees or just on top of light poles. So they're all around, but you don't quite know it. As far as how the handset communicates with the antenna, there are different variables that go into that. Now, the cell phone wants to connect to the antenna with the strongest signal. The best predictor of a strong signal is distance. So the further a radio wave travels, the more it's going to degrade and not be as strong. But there are other factors that can degrade or reduce the strength of a radio wave, specifically an obstruction. If you're in a basement of a building or standing behind a large brick wall, the radio waves aren't going to penetrate that as well. But even things like precipitation or foliage on a tree can also hinder it. And you think about rolling hills here in Massachusetts in tall buildings, they can also disrupt radio waves.
As far as that sort of disruption of radio waves, are you familiar with certain areas that get sort of termed as a dead zone?
Yes.
And can you explain what your understanding of that term is as it relates to what you've been talking about as far as the handset communicating with the antenna?
I would define a dead zone as an area where there's not good cell phone coverage. So the antennas are not covering that area for whatever reason, obstruction, the density of the tower. Oftentimes, well, an antenna can only handle so many cell phones at a time. That's an idea that we coin or refer to as load. So there's only a certain number of devices that can handle an antenna. My best analogy of that is Gillette Stadium. I've worked at Gillette Stadium detail many times. We have roll call for Patriots game early in the morning. I take my post. I have strong functionality in my cell phone. As hundreds of thousands of devices are now entering the area around Gillette Stadium, the functionality of my cell phone reduces as more devices are using the antennas in that area.
Now, with respect to the cell phone companies themselves, they create or utilize this data for their own business purposes, correct?
Yes.
And can you just briefly explain a little bit about sort of what the cell phone companies would be using this kind of data for as far as what you're talking about, connections to antennas and towers?
It's a company who wants to make money, so it's going to memorialize things to bill their customers appropriately. They're also required by the FCC to keep for a certain period of time certain records because they are a communications provider. So there are some requirements.
So he's setting up to
regulatory
explain
that they need to,
why she
fulfill.
didn't ping at 34
Now,
Fairview.
as far as the information that you're able to glean from these call detail records, I believe you've spoken a little bit about, but as far as what, if any, limitations are there with reference to the information you're able to glean from the records?
Well, the overarching one is I can only get what I get. So whatever the company sends me, that's what I can use in my determinations. Kind of the next step is when we're talking about antennas, I will never, well, I'll have difficulty saying exactly where a cell phone was when using an antenna. I can make generalizations that the phone is going to be in the area of the antenna, but I would never, with just that specific information, be able to tell you exactly where it is. I can look at other records, like the engineering records, where, especially now with 4G and 5G technology, the cell phone providers need to know how far away a handset is from the antenna in order to facilitate that communication. And they keep those ranging records for me. So if I can obtain those records, I can then place a much narrower area where a cell phone would have been during a time period.
Now, in reference to this investigation, you the search warrant that Trooper Proctor did with regard to call detail records for Ms. Reed's phone, correct?
Yes.
And were you able to, or did you have occasion to look at those call detail records?
Yes.
Your Honor, may I approach?
Yes.
So they've set this up to be not a
Your Honor,
lot.
may we approach just sidebar
Not
briefly?
a lot. Just a bunch of phone calls to John between 12:30 and 6 in the morning or whatever. Like when she's looking at him, like when you might call somebody, try to get an answer from their phone. Yeah, so when he's talking about the engineering records, oh, now I'm spacing on, because I'm not an engineer, and I'm spacing on the names for things. But what he's getting at is that one of the pieces of data that they record is the time between the signal, right? The time it takes for the signal to get between the tower and the cell phone. And electromagnetic waves travel at the speed of light, so you can then use that to calculate the distance of the phone from that particular tower. From there, you have the angle that the tower, sends out a signal from. It's a wedge, and so you can get basically an arc from that type of information that would tell you, okay, the phone had to have been somewhere along this arc at this distance from that tower, in order to connect with that tower, you know, with the time frame of that signal. Yeah, don't you like this? It's really good when they want to nail someone, and it's just very, very limited when it doesn't give them the information that they want to get, right? We already know they were going to get Karen Reed no matter what. It didn't matter what her cell phone records were. So if the cell phone records don't corroborate their theory, we're going to hear all about the limitations of this type of technology. Now, I don't know what the cell service network looks like in Canton, Massachusetts. We've talked about it a lot in Moscow because it's extremely rural. Very
Yes.
not dense cell phone coverage.
Sir, I'm showing you a
But this
four-page
is-
document, just actually looked at a couple of minutes.
This is the East Coast of the United States. I don't know how far exactly we are from Boston, okay? I mean, it certainly looks rural, you know, compared to Boston.
Do you recognize that document, sir?
Yes.
What do you recognize it to be?
It is the subscriber information for the phone number ending in 9554.
But
And
I
through
just
the
have a
course of your
hard time believing
investigation,
that
as far as that
they don't
phone
have
number
much
ending in
greater density.
9554, who, if anyone, did you find that number to be associated with?
The defendant, Karen Reed.
Now, with respect to the documents before you, that has
I should say it
some
looks more
listing of account
suburban, not
information,
more
is that
rural.
correct?
It doesn't
Yes.
look rural.
And
It
who
looks
is listed
suburban.
as the subscriber for that account with phone number ending in 9554?
Karen Reed of 481 Gilbert Street in Mansfield, Massachusetts.
And are you, through the course of your investigation, familiar with that address, 481 Gilbert Street?
60
Yes.
miles from
Is that the
Boston,
residence
then
of
there
the
are
defendant?
towers
Yes.
in Boston that can
Mayor
reach
Pro Tem.
Canton.
Yes.
I'm going to introduce in a minute.
Okay. And along the interstate highways and stuff like that,
574.
there are towers from Boston that can reach Canton.
I'm actually going to see counsel outside that in just a minute.
Just gonna ask.
It's a suburb and lots of towers. So yeah, if there's lots of towers around, this changes the dynamic a lot because you're not stuck with looking at the connection with a single tower. What happens is a cell phone is frequently connecting with multiple towers at the same time because it's evaluating the signal strength. It's deciding basically which one it's going to route the call through. And so when a cell phone can connect with 3 or more towers at the same time, then you can triangulate the location because the way that we describe that you can get that arc from the time of the signal and so forth. You can basically just map those arcs, right? All 3 arcs for one tower, and there's going to be a point where they intersect. And that's where you can place the phone is at that point. So when you have multiple connections with the cell phone, you can get much, much more precise location information from the CSLI data. It's very different than, you know, whatever inference you're trying to draw off of a connection with a single tower. So that's the whole point about the cell tower density. If they got a whole bunch of towers over here that it can be connecting to, you have a much greater chance of being able to triangulate the phone. Kyle says the absolute best you can do is a 250-foot radius. That could be. I don't know exactly what the limitations are. Again, I just know you're going to be able to get more precise with the triangulation than with a single ping. But even 250 feet isn't bad. That would put you near the entrance to Fairview, right? Probably put you on the road near the house.
Now, Lieutenant Tully,
Did we mark that, Madam Court Reporter? Thank you. So that's 570.
574.
4.
All right, go ahead, Mr. Lally.
thank you, Your Honor. Now, as far as the information that you receive with reference to call detail records, is there a section called the records key?
Yes.
And can you explain to the jury what a records key is and how you use that in order to facilitate or read the records?
The records key give us the definitions of terms that are used in the record. So the record comes usually in the form of a spreadsheet or PDF. You'll get columns and rows. The columns will be named certain things, and those titles are often specific to the company. So I want to make sure that I'm reading and understanding what the data is.
Now, I believe you alluded to it earlier in testimony, but just for the jury's edification, if you could describe to the jury what your understanding of the term as far as cell site listing information and how that's used in an analysis of call detail.
So CSLI, as it's referred to, has that billing information, time, date, duration, other phone number, and it has the antenna used during the communication. So just as it says, it's a cell site, which is the other term for antenna, as I usually use.
Now, sir, through your training experience, are you familiar with the term in reference to this type of material called ranging data?
Yes.
And can you explain to the jury what you understand that term to mean and how it's used in interpretation of call detail records?
So the ranging data goes back to the engineering reports I had mentioned earlier that can provide more information. They can tell me the antennas that were used during communication. It can tell me the range in which the handset was away from the antenna. So now, opposed to just kind of making general determinations where a handset was near an antenna, I now have a range. So I will plot the location of the antenna, measure out that distance, and draw an arc with that radius of the distance on a map. And I can make an assumption that the handset is somewhere on that arc. The ranging data is also helpful because the user does not need to be actively using the phone in order for a record to be created. Right? The billing record is going to be a phone call made or received, text message made or received. A cell phone as it sits today is still communicating with the antenna. You're getting notifications, it's checking email, it's updating, and because it's utilizing the network, your cell phone provider is capturing that data and it's generating a record, even though unbeknownst to the user.
Okay, so to that point, or illustrative of that point, so if I'm standing right here with the cell phone in my pocket, not using it, not turning it on, not activating it in any way, that cell phone is still doing some sort of communication with the closest or some antenna within the vicinity?
Yes.
Now, you're also familiar with a term called UTC or Universal Time Code?
Yes.
Can you explain to the jury what that term means and how it relates to these types of records?
So UTC, or now known as Coordinated Universal Time, is the time zone along the prime meridian. So if you think of the globe, you got longitude and time zones. The prime meridian is a spot that runs through Western Europe and Western Africa. That is the line in which all time zones around the world are predicated. And UTC will be a time there, and it's not determined by daylight savings time either. So all those time zones, like I said, around the globe are predicated on that. Because it's one standard time in a globe, a lot of records will come in UTC time, and you have to make the conversion. And they will provide records specifically to a cell phone, what time it was locally, but it will tell me what the UTC time was. So for me to figure out what the time was locally during the time of the communication, I got to do the conversion.
We understand time zones.
And to
It's
that
not
point,
that
as far as the
complicated.
conversion is concerned, what type of conversion are we talking?
Here on the eastern side of the United States, it's -4 hours during the summer and -5 in the winter.
Now, as far as these records are concerned, what if any, I believe you spoke a little bit as far as the arc and plotting, but if you could expound upon that as far as explain to the jury what it is exactly you're able to do with the information from the call detail records as far as a visual
As far as a
representation.
directionality from Temple
You
Beth.
said two things there, so I want to make sure I answer the question
Where
right.
is
You
the
mentioned
prime
ranging data,
meridian?
but CSLI. So specific to the engineering report in ranging or CSLI?
Let's first start with CSL.
So with the CSLI, I will place on a map the location of the antenna. And I mentioned load a little bit, but that load factor determines on how dense the antennas will be from placed by the provider. So if you think of an urban environment, there's more cell phones, there's more devices that need antennas. So the locations of the antennas will be more dense. I've seen them as close as 100 yards away from each other in an urban environment. You come out to the suburbs, there are less devices. The companies are going to put less antennas because they don't want to put them up where they don't need to. They're going to be further away. So in Norfolk County, the antennas are placed anywhere from 1 mile to 4 or 5 miles apart.
And so there would be a difference as far as the amount of antennas, the amount of towers, like say in the town of Canton versus downtown Boston.
Yes.
And again, I think it's pretty clear, but which
again,
of those two, as far as
range of
downtown
those
Boston,
towers
and
from
town of Canton would
Boston?
have more antennas or more towers
Very
for cell phone
feasibly reach
connection.
Canton. 10 miles.
Downtown Boston would have more.
And so with relation to the number of antennas or towers that a handset or cell phone could connect to, what, if any, relation does that have to geographic location, or what you're able to glean in reference to geographic location from the call detail?
So once I place the antenna on a map, I will look at where the other antennas are, and I can make a general determination that the cell phone was closer to that antenna than other antennas. Again, there's the caveat,
Yeah,
and I'll say it
that's
up
a
front,
big-ass
is that there are
caveat.
other
That is not a good
mechanisms that
assumption
could
at
prevent
all.
it from connecting to the closest tower.
No.
But generally, it's going to connect to that closest tower. Now, there are redundancies built into the system. If an antenna goes down because of it gets struck by lightning or it needs service, there are other antennas nearby that can cover an area.
Now,
Atmospheric conditions.
with respect to the CSLI data, we were able to do that in this case as far as plotting that on a visual representation on a map.
Yes.
Madam Mayor Approach.
Yes.
So showing you, I believe it's a 10-page document, just ask you to review that, look up when you're finished.
And the location you plotted is to what degree of certainty within how many standard deviations, officer?
And do you recognize that, sir?
Yes.
What do you recognize that?
It is a series of maps that I created depicting the records obtained from that number ending in 9554.
And that's plotted onto sort of a Google image or a Google Earth image?
I use Google Earth to create the maps. I then take a screenshot and place it typically in PowerPoint in order to make it look nice.
May I approach, Ron?
Yes.
Commonwealth is introduced and admit collectively, isn't it? Is it?
No objection, Your Honor.
575. Thank you.
May I return that to the witness, Your Honor?
Yes.
May I have a moment, Your Honor?
Yes.
So, Lieutenant, directing your attention to the second page there, and Your Honor, with the court's permission, if I could publish this to the jury.
Okay.
Guess we're going to find out. We get to see.
Lieutenant, do you recognize what's depicted now up on the screen?
Yes.
And again, what do you recognize this to be?
It is a map that I created using the information from the call detail records or CSLI from that account.
Okay.
And from what time period of call detail records are we looking at in this particular representation?
From 12:33 a.m. to 12:34 a.m. Again, I had done the conversion for the purposes of making this exhibit. So if one were to look at the call detail records, you may see the UTC time. For the convenience, I've done the conversion for the purposes of the exhibit.
Now, sir, if you could, using the laser pointer, before you direct the jury's attention to what, if anything, of significance you've plotted out, of course, into this visual
So
representation.
in this minute,
So first,
Did
we're
he
looking
do
at
the
the
minute
area
by
of the town of
minute?
Canton. I've placed different landmarks again to
12
give
to 1.
context to what we're talking about here. You see 34
5 to
Fairview Road
6.
as a yellow house icon, 1 Meadows Ave, Canton as a darker color, and the Waterfall Bar and Grill as another icon. Now off to the left, just west of Route 95, which you'll see running here, you'll see a red triangle, which I use consistently as the antenna, and a series of letters and numbers next to them. So next to them is the numbering system that Verizon assigns to that antenna. So in this instance, we're looking at ENB, which is the antenna acronym, and specifically 57171.
To be clear, as far as that mark.
Right there on the interstate.
The ENB ID.
That antenna is going to connect to like every cell phone in Canton.
That is the antenna that the handset.
If
or
it's a
the defendant's cell
powerful-
phone is connecting to
powerful
that,
antenna.
correct?
Yes, and I always try to
Give
be
you
clear
coverage all the
that
way
that is
over
the
there to
antenna.
this
That's
other
not where I'm
highway.
saying the handset was.
So the handset is somewhere in that vicinity based on your training experience, is that correct?
Yes.
Ms. Gilman, if we could have the next slide.
Where is the coverage
So what
area
time period
that
are we
he's
looking at in this
supposedly
particular-
identifying?
12:35 to 12:37 a.m.
And again, if you could, using the laser pointer before you, direct the jury's attention to what, if anything, of significance or relevance you depicted in this representation.
So those same icons appear as about the locations relative to this investigation. You'll see another red triangle here close to Route 95, which is NEB ID 57286. And during this time period, the handset associated with this account communicates with that antenna.
That's what we're
And
getting.
from
The handset
locations,
communicated with that
significance
antenna.
and relevance,
What's the range of that
as far
antenna,
as,
sir?
NEB ID 57286, which of them is it closest to in this?
It's just north of 34 Fairview Road.
And now, if I could direct your attention to the next, Ms. Gilman, if I could have the next slide.
What's the coverage area? This is completely meaningless without the coverage area
And
of the
Lieutenant, what
tower.
time frame are we looking at in this slide?
This
He's
comes
trying to
from
use it
one
to show
call that occurred at
movement.
12:38
He's trying
a.m.
to say it was closer to this one than
And-
this one than that one. And that's how we track it. But you cannot do
As
that
far
with a
as,
single ping.
if
For
you
all
could,
the
again,
reasons he
using
talked
laser
about,
pointer, direct the jury's
There's
attention
different
to what
reasons
any,
why a cell phone
other
will connect to a
locations,
tower.
You identified or signified in this representation.
Proximity is
Again,
is
same
a
icons
correlate,
for the south to
but
bottom.
not-
The antenna is
definitive
located
one.
here at the intersection of Route 93 and 138, and it's ENB ID 57021.
And of those locations of interest that you signified within this slide, where is ENB ID 57021 in relation to those?
If you think back to the previous slide, so now we've moved a little bit further east. Here's Fairview Road, and here is One Meadows Ave.
And if I could direct your attention to the
Take me
next slide,
off real
if I could
quickly.
have the
That's
next
at
slide.
12:38. Okay.
And Lieutenant, what time frame are we looking at in this?
12:39 a.m. to 5:08 a.m.
And again, if you could, using the laser pointer, direct the jury's attention to what, if any, locations of significance you note in this slide.
So there were a series of calls during this time period. They all used this antenna here, ENB ID 57199, which is south of Meadows Ave.
If I could direct your attention to the next one. If I could have that one, please.
They're seriously going to say she
Lieutenant, what are we
connected to the
looking at as
tower
far
to the
as,
north
timeframe in
to
this
prove
particular
she
slide?
went to Fairview
There
in
was
the
one
morning?
entry in the call detail records at 5:16.
And again, using the laser pointer, we could direct the jury's attention to what, if any, locations you denoted within this particular slide.
I'll start with the antenna that was used, which was 57259 here in downtown Canton, just north of the Waterfall Bar and Grill.
If I could direct your attention to the next slide, sir. If I could.
Yeah, if you don't have
Lieutenant, what
GPS
time frame
data,
is that depicted in this slide?
5:19 a.m.
then pings are going to be what you have to work
Again, if
with. You have
could,
what you have.
Using the laser pointer, direct the jury's attention to where
And the point is
antenna
not that ping data
that's
is
the
like always
antenna
trash.
connected to
It's
at
just
this
that there's a
point,
wide
what
range
is closest.
Slightly further
of
south
how
than the
good
previous
it
one,
is.
it's
It just depends on the
57199,
circumstances. And
directly
this
south of One Meadows Ave.
Connecting to a single tower information is about the lowest quality of information that you can derive from CSLI data. It connected to a tower
Now,
tells you extremely little except that the phone was in the range of that tower. So you need to be mapping out the range of the tower to show us where
and
within
Lieutenant, what
that
time frame are we
range
looking at in this?
could the phone
5:20
be
a.m. to 5:37 a.m.
and still connect to that tower.
And again, if you could, using the laser pointer, direct the jury's attention to where the antenna is and what, if any, of the locations you observe it, where it is in reference to those.
I previously mentioned this one here at the intersection of Route 93 and
I'm just going to
138.
take myself
It's
off while
ID
this map is up here so we can
57021.
see the times.
It's north of those locations I had mentioned earlier, the 34 Fairview and 1 Meadows Ave.
And next slide. What time frame are we looking at in this, sir?
It's one entry at 6 a.m. from the record.
And if you could, again.
When we
using
know
laser
she
pointer
was, like,
directors,
at
attention
Fairview.
to the Antenna and where it is in relation to locations of interest in this slide.
It is located just north of the Waterfall Bar and Grill in downtown Canton.
And the next slide, sir. What time frame are we looking at in this slide, sir?
6:03 to 6:57 a.m.
And again, using laser pointer, if you could direct the jury's attention to which antenna the defendant's cell phone is connected to at this
Yeah,
point. where it
Jackson's
is
not
in relation
objecting
to
because
location.
this stuff doesn't matter. He's going to be able to pick all of this apart.
During this time period, the cell phone will bounce back and forth between two antennas. So I did lump them together and place them on one map with this time frame here. So you will see two antennas. One is this one here, just west of Route 95, which is 57171. The other antenna is north of 34 Fairview, which is 57286.
Now, sir, as far as the locations that you observed from looking at the CSLI information from the defendant's phone, any relationship did you note with them in relation to what you had observed on each of the respective videos from the Canton Public Library and the Temple Beth area?
It's consistent. As with anything in our investigation, we want to get corroborating information. So the best corroboration about the location of a handset is to obtain video, receipts, anything else with a timestamp and a location that we can corroborate the location of a handset.
And with respect to information that you had received as far as the defendant's whereabouts, what, if any, consistency or corroboration was there between witness accounts of the defendant, including the defendant's own statements, as far as where she was and what you retrieved from the CSLI?
Objection.
Ask it differently, Mr. Lally.
Throughout the course of the investigation, were you made aware of path of travel attributed to the defendant, both between the hours of between the times of 12 a.m. and 6 a.m.?
Yes.
And the information that you obtained from the CSLI records, was that consistent with what you knew as far as the location of the defendant?
Objection.
Ask it differently, Mr. Lally. The objection is sustained.
With respect to what you knew as the path of travel from
Oh, God.
Of the defendant.
Yeah, see, he's trying to go
the
path of travel.
information that you
They
obtained
didn't
from
show
the
us
CSLI,
anything that we
what,
would
if any,
need to know
relationship
to
was there
establish a
between
path of
that
travel.
and the path of travel you knew?
This is trash.
Objection.
This is absolute trash.
It's consistent.
Consistent
Now, sir,
with the path of
as far
travel.
as the as far as the ranging data, what, if anything, were you able to do with the ranging data in relation to a visual depiction of that?
Similar to the maps we just saw using Google Earth, I made a visual representation of what the records display, specifically where the antenna is. But I took that additional step to measure the distance out from the antenna that's depicted in the records and draw a semicircle line depicting where that range would lie.
May I approach the witness, term?
So single pings, he gave us arcs.
Pages. Ask you to look at that in high definition.
His face is redder than his tie right now. What is the matter with him? Does he know how bad this is? Is he sitting up there aware that he's
Do you
bullshitting
recognize
all of
those
us?
documents, sir?
Yes,
What do you recognize those?
the series of maps I created using the ranging or engineering report.
May I approach, Your Honor?
Yes.
Commonwealth will seek to introduce in a minute as the next exhibit.
No objection, Your Honor.
Bit 576. Thank you.
Your
I
Honor, may I
mean, his
return them to the
ears look
witness?
hot.
Yes.
They look
I'm looking
like
for
if you
submission,
touched them, you'd burn
like
yourself.
Wait, jury has now been marked as 5 seconds.
Okay.
Now, turning your attention to the second page of what's now been marked as Exhibit 576. Is that what's up on the screen? What you have before you as Exhibit 576, the second page in, is that what's up on the screen, Lieutenant?
Yes,
Now, if you could, again, what time frame are we looking at here?
12:17 a.m.
And
You hardly
again,
see
sir,
anything.
if you could, using the laser pointer,
Three
describe
first,
the jury
three
what's
last.
depicted in this particular slide.
So 2 locations that are, again, as a frame of reference, 34 Fairview Road in Canton and the Waterfall Bar and Grill are depicted with icons. You'll notice a red lollipop would be the best description icon here. And next to it, you see a number and the words either first or last. This one, 3, first or in last. If you were to go back to the record or the ranging report, you would go to line 3, and that's where you would find this record. So it's just an easy way to cross-reference the map with the documents. With these ranging reports, it gives me the range that the handset was from the antenna at the beginning of the communication and at the end of the communication. So that's the first range and the last range. That's why we're using those words. You'll notice a line that goes straight out to the semicircles. That line denotes what's called the azimuth, and I've failed to kind of describe what an azimuth is. So as antennas are placed in these locations, they're pointed in a direction. Now, they're not typically a
What time is this?
360-degree antenna.
12:17.
Some are, but mostly they're not. They're pointed in a direction and have a beam width. Rule of thumb, and as you'll see with the records with Verizon, it says typically it's 120-degree beam width, because they'll place 3 around a circle and you get 360 degrees. So with this record here, I know what the azimuth is. I then draw a semicircle in each direction. I'll go beyond that 120 degrees just to give deference to maybe it was on the outer edges of that. So I want to give the tie to it was maybe further away. So that's what's depicting on the map.
Now, with reference to this semicircle itself, if I could ask, is the semicircle that is being drawn, what does that exactly denote as to the location of the handset itself?
The report is telling me that the handset is somewhere on that semicircle. So the phone could be anywhere from here on the semicircle all the way around to there on the semicircle.
And within what?
So again, it's not denoting sort of that the handset of the phone is within the confines of the semicircle, but actually on the line that you've drawn.
Correct.
To what degree of precision?
And if I
Plus
could
or minus
ask
how
you
many
the
feet?
Next slide, Ms. Gilman, the next one, please. Now, with reference to what's up on the screen now, Lieutenant, what time frame are we looking at here?
5:18 a.m.
And again, if you could, using the laser pointer for you, draw the jury's attention or direct the jury's attention to what, if anything, of significance you observe in this slide.
So the 2 icons are, again, appear on the map: Waterfall Bar and Grill, 34 Fairview Road. Here is that red lollipop, which is the antenna that's used during the communication. The azimuth, or the direction in which the antenna is facing, is depicted on there, and 2 semicircles. The first one and the last one. As a frame of reference, I failed to put the Temple Beth Abraham, which would appear right here.
Now, from this, what's depicted in these last 2 exhibits, as far as what you're able to plot out from the CSLI and the ranging data, what, if anything, what, if any, significance did that have as far as in reference to the investigation and the handset of the defendant's phone?
It's important to figure out the movements of someone that we're investigating for a crime. So these ranging records really narrow down the scope of they're somewhere around this antenna to it's possible they were somewhere on this line. Again, these records are just depicting where the handset
they
was,
were
but
somewhere on
as
this
we all know,
line.
we all travel with our cell phone within arm reach.
And again, it's in reference to this ranging data in the last 2 slides here, what, if any, relationship did you find that to have with Other information being videos and witness statements that you obtained during the course of the
Consistent.
investigation.
So as we previously showed, Temple Beth Abraham, which would be located here, just south of this intersection here, depicts a large black SUV traveling north on Washington Street. That SUV is similar to the defendant's. And with this record here, a phone
I'm
associated with the
looking forward to
defendant was
Karen
somewhere
Reed's
on
phrenology
this arc
examination.
at that exact same time.
That's how we know she's a whack job.
Thank you, sir. May I have a moment, Chairman?
Yes.
May I approach just to retrieve, Your Honor?
Yes.
So that's the best you got, is at 5:18, she was somewhere near Temple Beth. You didn't put her at 34 Fairview that morning. You didn't put her at 34 Fairview the night before. Did you do any of this with John's phone?
Thank you, sir. I have no further questions, Your Honor.
Oh man, that was pathetic. Wow. Talk about some junk.
Good morning, Lieutenant Tully.
Good morning.
I'm not going to go in any particular order, so forgive me if I bounce around just a little bit. You indicated that on direct examination this morning that you didn't seek a search warrant for 34 Fairview, the interior of 34 Fairview, correct?
Yes.
To your knowledge, nobody under your supervision sought such a search warrant either, correct?
Did anybody
Correct.
ask for
You
consent?
explained that in your mind, there was no probable cause to seek a search warrant for the interior of the home, is that right?
Yes.
But you also admitted that you didn't seek consent for which you don't have to have probable cause if you get consent, correct?
Correct.
You could ask me right now, hey, Alan, can I look at your cell phone? If I say, sure, you do your thing, right?
I could.
But for a court to order that I hand over my cell phone, you got to get a search warrant, sign an affidavit, and get a court to agree with it, correct?
Yes.
You've applied for myriad search warrants in your career, I'm guessing.
Yes.
Very experienced, correct?
Supposedly.
And I expect that there have been circumstances, Lieutenant Tully, in which you sought a search warrant and the judge says, no, I don't think there's enough here, correct?
Yes.
You don't get in trouble for that, correct?
With whom? No.
With the court.
No.
Well, it's not illegal.
It's not illegal.
You don't get sanctioned for it. You don't get your pay docked because you don't get a search warrant based on an affidavit, correct?
Correct.
So there's no real sanction in seeking it if you in good faith believe that there's a reason to seek it, correct?
Outside of the time that it takes to author it and put it together and go to the court, yes, there's no sanction.
Of course. But in a homicide investigation, you're not going to fail to do certain investigative tasks because it takes time. You're going to do what is necessary for the investigation, correct?
Yes.
Of course. You indicated that you did not believe that there was information sufficient that y'all had at the very initial stages of the investigation to seek a search warrant or to ask for consent, correct?
Yes.
But you did know the following. In the initial moments of the beginning of the investigation, you were aware that John O'Keefe had been invited to a party inside a home, correct?
Yes.
You knew that that home was located at 34 Fairview.
Yes.
You also knew that John O'Keefe arrived at 34 Fairview, correct?
We believe so, yes.
You also knew at the time that he had been, for want of a better phrase, partying with the individuals who were inside the home, correct? Expected to meet at the house.
They were at a bar previous to that, yes.
You're aware that a drinking glass was found in the yard attendant to or close to, adjacent to where Mr. O'Keefe's body was
Good,
found.
the drinking glass.
Yes.
That drinking glass had been broken, correct?
Yes.
You're aware that drinking glasses are commonly found inside homes, right?
As well as bars.
As well as bars, right? But at that point, you didn't know. It's just a broken glass, correct?
It's a broken glass, correct.
And you never verified.
You also know that he was found without a coat on.
It was a waterfall
Yes.
glass.
Are coats normally worn outside or inside?
It's user's choice.
Fair enough. 18 degrees, you would
User's
expect
choice.
if someone was outside, they'd have a coat on, correct?
I'm the kind of person that wears shorts throughout the year. I'll often go without a jacket.
All right.
Oh, aren't
The
you a
true
tough guy?
Bostonian.
Yes, sir.
He didn't have any coat, gloves, scarf, nothing like that.
Correct.
He had no winter gear on whatsoever, correct?
Correct.
Under ordinary circumstances, and you may be the exception, but under ordinary circumstances, if someone was out in 18-degree weather, you might expect they would have some winter garb on, correct?
Objection.
Sustained.
You would also,
He thinks he's
you
got
certainly
hot
would expect
legs.
that if
That's
someone
why he
took their
wears
coat,
shorts
their
all the
glove,
time.
their hat, their winter gear off, you might leave it inside the house, right? Rather than outside the house.
Objection.
I'll let you answer that, Detective Lieutenant.
It's probably predicated on where you take it off.
Right.
And your relationship to the location.
Right. Reasonable assumption might be the winter gear might be inside the house.
Objection.
Is that a reasonable assumption, Detective Lieutenant?
No, Your Honor.
It's not reasonable that he would have his jacket inside the house? You wouldn't just assume that?
Well, using the term "the house," you talking about any house? 34 Fairview?
Correct.
No, it's not reasonable.
All right. You
Yeah,
didn't think it was
completely
reasonable at
not
the time.
reasonable. Absolutely no way
Still
he went
don't.
inside
So
that
even
house.
ask, could he have had a jacket off inside the house? And I'm talking about at the time, the initial stages of the investigation.
Who am I asking this question to?
So I'm asking if you believe it was reasonable if a man is found 30 feet outside the front door of a home and he's got no winter gear on whatsoever, that perhaps he came from inside the home, not
The
having
home where he
donned
was
his
supposed to be
winter gear.
going to party.
Objection.
Can you answer that, Detective Lieutenant?
It's not reasonable, given other information I had.
You also
'Cause
know
you
that
were
he didn't have a
told.
shoe on, correct?
Yes.
Where might you look for the shoe if you didn't find it out by his body? initially?
So when the narcotics guys you're investigating tell you, no, sir, there's no
Well,
drugs
the
in
question's
this
not
house,
accurate to
you
the
say, oh,
facts we
I
had at the
guess it would
time.
not be reasonable.
Well, the fact
To
you
go
had the
inside
initial
then.
stages, I'm talking about just after 6:37, 7:30 in the morning, when the investigation was beginning. During those times, you didn't have any information about where the other shoe was, except he just didn't have a shoe on at the hospital, correct?
We didn't know there was a shoe not accounted for until after noontime.
So when you did find out that there was a shoe unaccounted for, one place to look might be outside, correct?
Yes.
And another place to look might be inside the home, correct?
We looked at the former and we located it there.
You also are aware that a body is being dragged by the shoulders, could easily lose a shoe.
Objection.
Sustained.
Have you ever experienced a homicide in which a body is dragged and you're aware of a shoe being pulled off while the body's being dragged?
Objection.
I'll allow that.
I don't have experience with that.
He's never dragged the
Certainly not
body
outside
himself.
the
He
realm of
leaves that for
possibility
Burke.
as a professional investigator.
It's possible.
You're also aware that, at least initially, it appeared from accounts that John O'Keefe may have been involved in a physical altercation, correct?
Possible.
As a matter of fact, that was reported by one of your subordinates, Yuri Buchanan, to the medical examiner's office, right?
As a possibility, yes.
As a possibility. And you're aware that your other subordinate, Trooper Proctor, according to certain information he had gotten from first responders, also believed that a physical altercation was possible, as well.
It was possible, yes.
Okay. And you also knew that the house would be a normal location to have other individuals who might have been involved in that physical altercation.
Objection.
Can you answer that, Detective Lieutenant?
An altercation could take place anywhere.
Exactly.
And people can often travel from the location of the altercation miles away to another location.
Or they could travel 30 feet outside as well, correct?
Yes.
Okay. In the early morning hours of, well, let's say the hours following your Massachusetts State Police initiation or engagement in this investigation, you became aware of Brian Higgins, correct?
Yes.
That name was bantied about as a potential witness in the investigation, correct?
Yes.
And you're aware that Brian Higgins indicated that he saw a tall, dark-haired man enter the home after he arrived, correct?
I'm not aware of that.
And the reason you're not aware of it, Lieutenant Tully, is because nobody bothered to interview Brian Higgins until February 10th, right?
Objection.
So in that form, then be sustained. Ask it differently, Mr.
When was
Jackson.
Brian Higgins first interviewed?
February 7th?
7th, 10th?
Th-
Yeah, in February, not January 29th, certainly.
Correct.
Although he was known to be inside the house, correct?
Yes.
So had you known that, had you had the information, for instance, that Brian Higgins admitted to having seen a tall, dark-haired man walk in the house, that might have changed the complexion of your investigation at that time.
Objection.
Can you answer that, Detective Lieutenant?
In the off chance that Mr. Higgins presumably had said something like that, I would certainly need more information describing this person. I would ask a series of questions to narrow it down to make sure that this person was John O'Keefe.
Right, exactly. That would just be a normal part of the investigation. You just take evidence A and link it to evidence B to evidence C. That would be the normal way to do an investigation.
We would normally follow the evidence. Correct.
But in point of fact, nobody did seek a warrant to go inside the house, correct?
Correct.
Nobody did seek to have a forensic team go inside the house and look,
Correct.
and nobody asked for consent.
Correct.
I want to ask you about the Sallyport video, if I could. Did you obtain a copy of any video surveillance footage from Canton Police Department?
Yes.
Okay. If you can, tell me which footage you obtained and where. And there's several videos, Lieutenant, that it can be confusing. So if you could be as detailed as possible, explain what footage you gathered and when you gathered it.
Most recently, and the date escapes me, but it's within the last couple of months, I had contacted Chief Helena Rafferty of the Canton Police Department and asked her to burn another copy or create another copy of the Sallyport video during a certain time period on January 29th to ensure that the video that we had received previously was all of the records responsive to that request.
And you found out that the video that you received earlier was not, in fact, completely responsive because there was a video left out, right?
I didn't do a one-to-one comparison. I just had made the request.
Ultimately, you did receive a video of the interior of Sallyport, correct?
Yes.
And can you tell me, did you look at that? Did you review that video?
Quickly, not the whole thing.
Okay. Was there anything of note about that interior video? By the way, let me ask you another question, Lieutenant Tully, just to clarify. There's a very grainy, dark, almost black picture of the interior, correct? You've seen that one?
Yes.
Or excerpts of it?
Yes.
And that video is missing some pretty significant time frames throughout the video?
I didn't review the whole thing, but I'm aware of that video existing.
Fair enough. Then there's another video that's pretty clear, right?
Yes.
Okay, I'm asking you about the clear video. Did you make any note about anything unusual about that video?
No. But again, I didn't really review it.
You didn't review it with any detail?
Correct.
Did you make a note that that video was inverted?
I did not.
Did you make a note about the timestamp on the video either being correct and properly positioned or inverted?
No.
Did you give that video to Trooper Proctor?
I believe I gave it to Sergeant Buchanan.
Sergeant Buchanan, and then what did Sergeant Buchanan do with it?
Reviewed it.
Okay. Is that somehow uploaded onto the Massachusetts State Police computer system somehow for safekeeping?
No, we'll hold it within the DA's office on that server. You know, it's not touching the MSP.
Okay, so it is uploaded on some sort of server.
We will memorialize it somewhere, yes.
Did Chief Rafferty give it to you on a thumb drive or a disk, or how was it physically provided?
I don't know. I didn't receive it. She dropped it off at the office. I remember a thumb drive.
You remember a thumb drive, all right. And then it's uploaded onto the system, and the case officer would have access to that system?
Yes.
Okay. And in this case, that would be Trooper Proctor.
Yes.
Time for
Did you
some
notify Trooper
supplemental
Proctor,
subpoenas.
when I say immediately, reasonably quickly, after you received, or after you got notice that the video had been dropped off by Chief Rafferty?
I informed Sergeant Buchanan.
Okay, and do you know, as you sit here, you may not, as you sit here, do you know if Sergeant Buchanan reasonably quickly informed Trooper Proctor that that video existed?
I don't know when or where that notification was made.
as you sit here now, you are aware that Trooper Proctor is aware of that video and had access to it?
Yes.
Yesterday, there was some testimony about taillight pieces that were found at the location, correct?
Yes.
May I have just a moment, Your Honor?
Yes.
I'm saying they're going after the police
Your Honor, may I,
system. Now that they've been told they have a foundation, they can potentially go and subpoena the police department IT to get a record, a log of the server, and when the file was first uploaded, any modifications to the file and so forth.
May take a minute.
So they can get more information about the form of this. Now, I would think that even someone as dumb as a rock like Proctor wouldn't modify this on the law enforcement laptop.
before I get
Right,
to
he'd
the,
take the thumb
the
drive
evidence back, may I
and
inquire?
put it on a
Thank
different
you.
computer,
Before I get to the
modify it,
evidence
and
back,
then
one
re-upload
more,
it.
or maybe a couple
So
more
that's what
questions
you'd be
about the
looking
Sally Port
for.
video. You indicated that you received additional video from Chief Rafferty that once she dropped it off, you said within a couple of months.
Yeah. Additional that package. Yes.
What was the original Sally Port video that you received? In other words, what were you following up on?
What you had previously described as a grainy black-ish video.
Okay, and so just to be clear and close that loop, when did you receive that video, if you can tell us?
Which one? The grainy one?
The great,
Earlier in the investigation.
a year ago, 2 years ago?
I don't recall.
Okay. Do you believe it was pretty early on in the investigation?
I don't recall.
That's what he just said.
Do you know what the mechanism was that you received that one? If Chief
Well, I got
Rafferty
it
is
from
the one
Rafferty, so it
that
was
gave
after
over
Burke
the
retired.
clear video, how did you get the grainy video?
I don't know.
Was it you that received it, or do you believe that you commissioned Trooper Proctor to go get that video?
It would have been a task for Sergeant Buchanan or Trooper Proctor or someone else from the unit.
So the reason you don't know is because you didn't personally do it.
Correct.
Yesterday, you testified that it's obviously your responsibility as not just the chief of the unit, but as the evidence officer to maintain and protect the integrity of the physical evidence that's found under your supervision, correct?
Yes.
You indicated that you took photographs of the items that were recovered on that initial SERT search, and you took those photographs in place where they were found, correct?
Yes.
With the exception of one of the photos, you indicated that it had been moved by a shovel, and then you instructed the individual put it back down where it was found, and then that's the point at which you photographed it, correct?
Yes.
You took an establishing shot, then a closer shot, and then I think even a third close-up shot, correct?
Yes.
And you indicated pretty clearly yesterday what the evidence that you found at the scene was a red plastic taillight piece that was recovered first, then 3 feet or so to the south of that, the shoe was recovered, and then 1 to 2 feet south of that, another red plastic piece, and then a clear plastic piece next to that, correct?
Yeah, you get the last two inverted. It's clear, then red. But
Inversion, it's becoming a theme. Sorry about that. So clear piece,
So I'm going to strike that comment.
Good one,
clear
Alan.
piece, and then a red piece next to the clear piece.
yes.
3 pieces of plastic in total and a shoe.
No, there was with the clear piece, there was 2 pieces with it. So clear plastic, multiple pieces of the clear plastic.
Okay, so yesterday when we saw the photographs that you testified to, there was 1 piece of clear plastic that was photographed, right?
2.
Didn't the photograph have 1 sort of arc-shaped clear piece of plastic that you described as having did you say dimples or stippling?
Yes, I think I said dimples.
Okay. What was the second photo?
The next photo that was displayed was the second piece of clear plastic taillight.
So in fact, that would be 4 pieces of plastic.
Yes.
Okay. But yesterday you testified that you found 3 pieces of plastic, and in your report, you reported that you found 3 pieces of plastic, correct?
I didn't number the piece of plastic, if I recall my report correctly. I said we found clear plastic. And as I displayed out of the bag, there was 2 pieces of clear plastic that we...
but there was only a photograph of one,
No, there wasn't.
and your report says 3 total pieces of plastic, doesn't it?
No.
Let's take a look.
Hope he's right.
Do you have your report with you, Detective Lieutenant?
Not that one, Your Honor.
Okay.
So he's trying to show he left the details fuzzy with what was found, when and where. And then I think he'll get to the ceiling and the logging into evidence. And why on earth did DeChico do that? They seem to have all these different systems for keeping track of the documents. When we get to break, I'll tell you about how I would do this kind of stuff for trial. I would make a witness binder.
Jim.
I would have tabs for each of my witnesses, and then any exhibit that might potentially relate to that witness, all their reports, etc.
The juror's time, I can use my time wisely.
Sure.
All right, jurors.
So we're going to go
we'll
ahead and take the recess now.
All rise for the court, please.
They would go ahead, so I would go ahead and then just, you know, when I have that witness up, I have the binder, I have everything that relates to them in that particular binder. So I know when it's Tully, I've got all of Tully's reports in here. As you can see and as I've shown, I tab things. I'm a bit of a fiend when it comes to tabbing things.
Thank you, Your Honor.
So I'll go through and I'll have notes, you know, all over, little tabs on the report about, you know, things that I've already seen. I think this is significant. This is a fact that may need to come up in cross or whatever. I'll have all of those tagged in there so I can just flip right through and find right where it is. Organizing stuff for trial in a case like this where there's just such a massive volume of documentation.
Hey there, Karen Reed, trial watchers. This is a long.
It is really just a huge part of the trial preparation, okay? Like, as much as just familiarizing yourself with all of it and knowing what you actually have and what's there, having it in a system where you can locate it like that for moments like this, when you need to be able to refer to it, you know, on a moment's notice. That's a big part of the challenge of being a trial lawyer, just being organized. So I hope he's right about what he put in his report. I don't even remember the photographs from yesterday. Did we see one or did we see two? I don't know. He says he took 2 photos. Do I have any of that in my notes? I mean, I don't know. I don't know that I would have written it down. No, I think I just have a photo of the piece of the red plastic. Photo of a piece of clear plastic was 127 and 131 was red plastic. So yeah, I think Jackson's right. They only displayed 1 photo. It doesn't mean they only took 1 photo. Of course, he could have taken more, and Lally decided to, you know, only introduce the 1. So if that's an issue, that could come up on redirect. Well, I'll tell you some of the stuff that's jumped out for me about this testimony from old Trooper Tully here. Oh boy, did his description of probable cause jump out at me? Did that ever jump out at me? He said it's a more likely than not standard. He said it's a more likely than not standard. Yeah, funny how when you didn't get a warrant, you make it sound like it's a lot harder to get a warrant than in fact it is. It is not a more probable than not standard. In fact, the court's been very clear that it's not a numerical, it's not a preponderance or anything like that. I went and just because I've had to brief this so many freaking times, what the probable cause standard actually is, I was able to go ahead and look it up really quickly, pull out some of that language. So here's the U.S. Supreme Court in Texas versus Brown. The court frequently has remarked probable cause is a flexible common sense standard. It merely required that the facts available to the officer would warrant a man of reasonable caution in the belief that certain items may be contraband or stolen property or useful as evidence of a crime. It does not demand any showing that such a belief be correct or more likely true than false. A practical, non-technical probability that incriminating evidence is involved is all that is required. And similarly, another U.S. Supreme Court case, Illinois versus Gates. The Supreme Court says the task of the issuing magistrate is simply to make a practical, common sense decision whether, given all the circumstances set forth in the affidavit before him, there is a fair probability that contraband or evidence of a crime will be found in a particular place. And the duty of a reviewing court is simply to ensure that the magistrate has a substantial basis for concluding that probable cause existed. So they very explicitly say it does not have to be more likely true than not. That's not the standard. So then, while I'm Googling this, I happen to find transcript of a audio training material or podcast or something, I don't know, that was produced by the Federal Law Enforcement Training Centers. Okay? The guys that train federal law enforcement, talking about the probable cause standard and what it means. And they're trying to dumb it down, make it as simple as possible. So here's what this guy says. So the question is, the courts refer to various levels of proof ranging from no proof at all, like a mere hunch, up to proof beyond a reasonable doubt, which is the level of proof necessary to convict someone of a crime. Now help me visualize these levels of proof and where probable cause might lay. Here's what this trainer for federal law enforcement officers says. Solari. Okay, well, I've seen it sort of depicted visually a lot of different ways, and the way I kind of like is to consider a staircase. And at the very bottom of the stairs is sort of the base of the staircase. There are no facts here. That's mere suspicion or hunch. No facts, maybe just a gut feeling. If you go a step higher, then you find sufficient facts to justify what we call reasonable suspicion. Each of these higher steps is supported by facts. The higher up you go on the staircase, the more facts you have. So again, that first step is reasonable suspicion. One step higher, and you find probable cause, again supported by facts and circumstances. Above probable cause, you find what's known as preponderance of the evidence. Preponderance of the evidence is a standard of proof that has to be met to hold the defendant liable in a civil action. This essentially means more likely than not. So whoever can bear their burden of proof to 51% versus 49% in a civil case wins the case. Federal law enforcement officer who trains federal cops puts probable cause at below preponderance, below more likely than not. And that is, consistent with what the case law says. So it is not a more likely than not standard. It's just reasonable belief that the evidence of the crime could be found inside. Now, I like how Jackson did this argument. I like it very, very much because I have to say, I'm not 100% convinced that they had probable cause here. You do have to do it based on what the facts and circumstances were that they knew at the time. And so, they didn't. Everybody in the house told him, no, he never came inside. What sort of proof do you have that he went inside? Well, I love how Alan Jackson just built that circumstantial case that he went inside. Because now I'm leaning a little bit more towards, you know what? Maybe they could have established probable cause. Maybe they could have gotten that warrant because he was unclothed, right? Not dressed for the weather at all. The drinking glass alone, basis to get a sample of what the drinking glasses are in the house. Yeah, pointing out he was, obviously, circumstantially, we know that he was there partying with those people. He was specifically invited to the house to go there. We know that he got there. We know that Karen Reed drove off and he wasn't with her. So, reasonable suspicion to believe, facts and circumstances sufficient to warrant a man of, reasonable caution in believing that the evidence could be inside. Yeah, it's looking pretty good. And then when you top that off with he was beat up, the guy was beat up. His injuries looked like he'd been beat up, not like he'd been hit by a car. Okay, now you got a lot more reason to think this had something to do with the people inside the house and what was going on inside the house. So I really like how Jackson built that case because, if you get off of this idea that it needs to be a more probable than not standard, which it does not, and the law is crystal clear, and he's just, Tully is flat out wrong. He's inflating it now because it's convenient for him to do that. Once you get off of that, it's looking pretty good. And so what's Tully's answer? No, it's not a reasonable assumption at all, given what I knew. What did you know? You knew what you were told. You knew what you were told. You knew that Brian Albert and Jen McCabe and Matt McCabe, who are interested in the situation, told you he never went inside. That's what you knew. And so I ask again, this narcotics detective, how many times when you ask somebody, you got drugs in your car? Huh? You got drugs in your car? And they say, no, officer, I have no drugs in my car. How many times you go get a warrant anyway? How many times? No, there's no drugs in my house. No. Nothing like that. No, just because you've seen cars coming and going in little 5-minute intervals and people doing little hand swaps at the door. No drugs inside. How many times have you gone and gotten a warrant anyway? We know you've gone and gotten a warrant a whole bunch of times when somebody's told you, oh, you're not going to find any evidence inside. That didn't happen. What are we supposed to believe that criminals always volunteer their criminal activity now? You need some type of admission to generate probable cause to violate their privacy, to intrude on their privacy. Nope. I am calling major bullshit on that one. That is just not a good. It's not a good position for him to take. Not reasonable for me to think that he went inside. The nice thing about reasonable is it's an objective standard. The reasonable person standard is not a real person. It's a fictional, reasonable person. And so every single person on the jury gets to evaluate it for themselves. And they get to compare that to what Lieutenant Tully thinks is reasonable. What do you think they're going to come up with? What do you think? You think they're going to agree with that? Yeah, totally reasonable assumption. Totally reasonable assumption. Kind of doubt it. But so, let's say they didn't have probable cause. Let's give it to them. Let's say they didn't. Let's say they never got it. Let's overlook the fact that part of the reason why they never got it is because they didn't ask those questions. They didn't go looking for it, right? You think when police want to generate probable cause that's a big problem for them? No, it's not. But let's just give them the benefit of the doubt. And they didn't have probable cause. They couldn't have gotten a warrant. You can always ask for consent. You can always ask for consent. Always. You mind if I take a look inside your car? Yeah, I do mind. As a matter of fact, I do mind. And don't consent to that. Even if you have nothing in your car, never, ever, ever consent to letting police into one of your private areas. Even if you have nothing there, you have nothing there. Don't do it. It's just not prudent. It's just not prudent. Make them jump through the hoops. Make them jump through the hoops. You can always ask for consent. And they didn't even bother to do that. Didn't even do that. This law enforcement officer who, You know, this fellow Boston police officer who owned this home, who assures you John never came inside and nothing happened. Surely he'd be happy to let you in and rule that out, right? Because you can rule it out, and then there's no issue about where John was or what he did. This whole empty period where ostensibly nobody saw where he was after Karen dropped him off and left, before he was found on the lawn outside, you could rule out that anything happened in the house. Just go in and look around. Take a look at their drinking glasses. See what they got. Never bothered to go get one from the waterfall. They just decided it's a waterfall glass and went with that. The fact that they never found the other broken pieces to the glass, that didn't bother them. Well, where would those be? Where would those be? Because, of course, if this crime happened the way the Commonwealth described it, they'd be right there. They'd be right there underneath him with the rest of the broken glass. Where else would it be? Where else would it be? Did it apparate? Like Chief Berkowitz out of the Canton Police Department Sullyport? Did it just apparate away? Yeah, I am getting a lot closer to this side of, you know what, maybe they did. Maybe they did have PC to get in that house. Maybe they did. They just, didn't want to. They didn't want to, and I don't think there's any question that they avoided getting, solid stuff that would establish probable cause to get in the house. They didn't want it. They didn't want it, so they didn't go looking for it. The ping stuff is just laughable. The ping stuff, it's just laughable. It's just laughable. The range of the tower is going to be, X feet plus or minus whatever the margin of error is. There's a margin of error for any measurement. Any measurement. Okay, if only because there's human error in being able to track down, being able to exactly replicate it, the limitations of the instrumentation, and then when you're dealing with things like electromagnetic waves that can be affected by things like sunspots, solar activity, atmospheric conditions, you're going to have a range of possibility of what that location is. We get none of that. We get none of that. I mean, when you're talking about, we discussed this, I think maybe better than Tully did, not to pat myself on the back too much, but the what he's describing, and I still can't remember, it's something about a repeat. I can't remember the technical name for this measurement that he's talking about, that it measures the time of travel of the signal between the cell phone and the cell tower. But these transmissions are occurring at the speed of light, and they're occurring over what are relatively short distances. Okay, speed of light being measured over a few miles is, you're going to see a bigger difference than a speed of light measured over, a distance of a few inches. So the smaller the measurement for something like that, the less precise it can really be, just because you're dealing with such a massive speed. You need to get into fairly large distances before that difference is going to be, really large. So you're talking about very, very small differences in measurement. That's part of what factors into your range of error as well. How precise can you actually be with the speed of time, the speed of light, and being able to calculate that with human instrumentation over short distances? So none of that, just here's some arcs on a map, and her phone was somewhere near here at certain select times, 5:18 a.m. and 12 something, 12:14, 12:17. Trying very hard at 518 to put her back at Fairview, huh? They're trying to say she went to Fairview before she went and went to Jen McCabe's house. So let's think about this for a second, okay? Couple of possibilities here. First off, no, she didn't. Possibility number one is no, she didn't. You would have her GPS data if she did. I'm not going to believe that this is a 2021 model year Lexus SUV, a very luxury car, and it's not going to have a sat-nav system in it. It's not going to have location services like that. You know, in the old days, it'd be OnStar, you know, the OnStar system where it, you know, your car gets stolen and they're able to track it. It will have like literal location trackers in the car, theft prevention, things like that. You're going to try to tell me this SUV doesn't have any of that stuff that you could access, because it's going to tell you a lot more specifically where that car was than, well, I see something that looks kind of like a dark SUV on a camera in the area where I really want to see a dark SUV on a camera. Like she's the only person in Canton who drives a dark SUV. Are we for real? Are we for real? I mean, it's just silly. Option number one, she didn't go there. Of course she didn't go there. And they're trying to fabricate a narrative that she went there because the other data that you would expect to show that she was there doesn't show she was there. Alternative number two, she did. She did go to 34 Fairview. She did go to 34 Fairview first. So then what are our options? Option number one, she didn't see John. She didn't see him there. What does that mean? What does that mean? When did John land out there anyway? Because we see from these library videos, the snow he was lying on, that he was found on, where his blood dripped on top of when they recovered him, looks a lot more like that 5 a.m. video than it does like that 12:30 video, doesn't it? The bear grass, he wasn't on bear grass. His blood dripped on the snow. Down. They had to blow away the snow to be able to trace down the blood. His body has compacted the snow. He's on top of the snow. So she didn't see him at 5:18 a.m. at Fairview. What does that mean? Maybe he wasn't out there yet. Maybe he wasn't out there yet. Maybe is this why Jen McCabe is making a bunch of frantic phone calls that morning? Option number two that the Commonwealth wants us to believe is that she did see him. She drove by 34 Fairview at 5:18 in the morning and she did see him. Okay. So she knew he was there. But she still continued. She still continued to Jen McCabe's. Still went, according to Jen McCabe, insisting that they go to 34 Fairview to find him. Why? They're trying to say it's like some kind of consciousness of guilt that he was there, but then why would you take them there to find him? Why would you still be calling his phone? They're really committing hard to this, trying to generate an alibi type of theory, trying to feign ignorance. You know, not that she was in fact ignorant of where he was and what condition he was in, but that she was just pretending. She was just putting on a good show. But I have a problem with that, because the safest thing to do would be to go home and go to sleep and do nothing. Why would you be up at 5 a.m. running around trying to look for the man that you murdered? Trying to get people to help you look for the man that you murdered, that you knew you murdered, and you knew where you left him. And why are you taking people straight there? Why are you leaving angry messages on his voicemail? I mean, we talked about this yesterday. Why would you leave an angry message? If you're generating an alibi, you're trying to feign ignorance, you're trying to pretend I wasn't involved. If you're going to leave a voice message to pretend I don't know what happened to him. I really do know, but I need to leave something to cover my tracks. It's going to be, John, I just love you so much. You're the best thing that's ever happened to me. It's not going to be, I hate you and you suck and I, whatever else we're going to hear in these messages. I wish I'd never met you. Wish we'd never gotten involved. It's not going to be stuff like that. That makes absolutely no sense. It's not going to be that. It's going to be, John, I just can't wait till you get home. Won't you hurry home to me, John? So, I mean, to me, however you lay this out, this theory of Karen Reed going to 34 Fairview at 5:18, whether she did it or she didn't do it, whether she saw John or didn't see John, none of it really works for me. Okay? None of it is really making sense as far as a coherent theory of what happened. And so my inclination very much is to just tend to think, no, she didn't, because they would have had a better way to put her there if she had GPS on her phone, GPS from her car. Instead, we're playing with arcs from pings. We're not dealing with triangulation. We're not dealing with something reasonably precise. We're talking about large ranges of error. He never mapped out what the range is for this tower. He never told us how precise is this measurement, this arc, what's the range of error for that. He never told us any of that. So I expect Alan Jackson is going to get into some of that. I saw a lot of people in the comments wanting to know, why is this cop testifying to this? He's not an expert. Oh, welcome. Welcome to the land of police officer expertise, where they go to a training over a weekend and now they're an expert based on their training and experience. A lot of these guys who have a high school degree and went to a training are now experts in this kind of stuff. Happens all the time. Happens all the time. This is in the discretion of the judge to decide if she thinks he's qualified based on it. And they almost never say law enforcement isn't qualified to render this type of opinion. If he's been to a training on cell phone forensics, they're going to let him testify as an expert. So this is why then there's a massive amount of pressure on defense to get their own experts. This is why public defenders need their own experts, because you have cops up here who don't know anything but went to a training testifying as experts to a jury. So yeah, you need to be able to review that. You need to be able to evaluate it. You need to be able to debunk it a lot of the times. All right, so we're back.
Memorialization of things that are found of note during a search, correct?
Yes.
And the way that you normally would memorialize something like that would be in a police report, correct?
That's one method, yes.
You might have personal handwritten notes
I
that
might.
would attend a search, correct?
Yes,
You might videotape part of it or all of it,
I could.
and then you could photo document it as well.
Yes,
But ultimately, the circumstances surrounding how something was found or what was found at the time is best done in a memorialization in a police report, correct?
that is one method, yes.
And that is the official record of what was done at the time and who did it, correct?
Yes,
And you did, in fact, draft a police report as it pertains to the search that was done by the SERT team on January 29th, 2022.
yes.
May I approach, Your Honor?
Yes.
If you would take a look at the face page of that and tell me if that looks familiar to you.
It does.
Is that your report that you utilized? Is that the report that you wrote, rather, not utilized? Is that the report that you wrote documenting the search that was conducted that we've testified to?
He
in front of
found
this
it.
Jury.
Yes.
What's the date of that report?
February 10th, 2021, which was a typo, should be February 2022.
Okay, so February 10th, 2022 was the date that you memorialized the information about the search, correct?
Yes,
Obviously, that was much, much closer in time than today, correct?
yes,
Or yesterday, correct?
correct.
If you turn to paragraph 3, could you review that paragraph and tell me after you review it, if that refreshes your recollection about exactly what you indicated was found by you and the SERT team on January 29th, 2022.
My recollection of what was located remains the same. I do see that the report states that it was a piece of clear plastic.
Okay. So, in fact, your report says that at approximately 17:45 hours, which is what time?
5:45 p.m.
The SERT team located, quote, a piece of red plastic, correct?
Yes.
And then it goes on to say it was consistent with brake-like material from a motor vehicle, right?
Yes.
And if you look down a couple of other sentences, you talk about the shoe that was then recovered, correct?
Yes.
Then if you look at the second to the last sentence, a few feet south from the sneaker, a piece of clear plastic consistent with clear lens of a motor vehicle was located, correct?
Yeah, the quote is a second piece of red plastic. Yes.
Well, actually, the sentence before that, sentence just above that, starting with a few feet south.
Yes.
It reads, a few feet south from the sneaker, a piece of clear plastic.
That's not what it says. Would you like me to read it?
Oh, I'm reading it. Sure, read it.
Okay. The sentence is several feet south of the clear plastic.
Lieutenant Tully.
Sorry.
Sentence above that. Before that.
A few feet south of the sneaker, a piece of clear plastic consistent with clear lens of a motor vehicle was located.
Right. So in your lexicon, a piece means singular, does it not?
Yes.
If you meant pieces, you would have written pieces. You're educated, correct?
Allegedly.
So clearly, from this report that was memorialized on February 10th, you indicated that a piece of clear plastic was located consistent with clear lens from a motor vehicle, right?
That's what it says.
Okay. Then, well, it's not just what it says, it's what you wrote.
Correct.
Right. Then the next sentence, which is the sentence you were about to read, go ahead and read that for me as well.
Several feet south of the clear plastic, a second piece of red plastic was located.
Okay. Simple math. According to your report on February 10th, a piece of red plastic was found first. Then a piece of clear plastic was found. Then a piece of red plastic was found thereafter, correct? According to that report.
Yes.
Then you go on in the following paragraph to reiterate, just to clear up any doubt about what was found. And the last sentence reads, the sneaker and 3 pieces of plastic were secured as evidence, correct?
Objection.
See, overruled, I don't know. What's the objection?
Form.
No, I'll allow it.
Is that what it says?
Yes.
Okay. Then yesterday, you were asked to open these 2 evidence envelopes, correct? The evidence bags.
And there's more.
Could I take a look?
Oh, of course, yes. May I approach you on that?
Yes.
Like maybe somebody messed
Sorry.
around with the pieces of
570,
plastic and
571.
put some of them in different bags and stuff? Because they weren't sealed up on January 29th and initialed by you, were they?
Those are the bags that you opened yesterday, correct?
Yes.
You indicated yesterday in front of the jury, you didn't indicate, you pulled out 2 pieces of clear plastic, did you not?
I did.
Okay. That was in bag, I want to say that was in bag 570. Why don't we do this? Can you please open, with the court's permission?
7.5.
Can you please open
But yes.
bag 570? I'm sorry, exhibit 570 in that bag, and just look inside.
I didn't bring gloves with me, Your Honor.
I think there might be some on the stand
Oh,
there
thank you, Your
inside
Honor.
that.
I didn't bring gloves with me. Oh man, these guys. Like you give a shit. You're not using them correctly anyway. What does it matter if you bring them or not?
Attorney Jackson, could you just repeat your request again, make sure I have it correct?
Of course, Lieutenant. Let's start with 570.
Okay.
I don't remember which one it is, so if you could just open it and look inside and describe for us which items are inside that bag.
So 570, the description is pieces of red hard plastic taillight cover contained inside this bag.
Look down in there and tell me, do you see red plastic pieces?
Yes.
Okay. Yesterday, you pulled out 2 pieces and indicated that was what was contained in the bag, correct?
Correct.
Take another closer look.
As I take a closer look, there are 2 pieces and there is a very small fragment that remains in the bag.
Can you pull that?
As I take a closer look.
Can you show that to the jury? Okay, you can go ahead and replace that. So in total, Lieutenant Tully, how many pieces of red plastic are in that evidence bag?
As we sit here today, there are 3.
Thank you. Go ahead and close that. Open up the second bag. I'll go ahead with the court's permission. May I approach?
Yes.
Thank you. Your Honor, may I?
Yes.
If you wouldn't mind, the next bag is Exhibit 571, is that right?
Yes.
Could you please open that and let's go through the same process? Just look inside and tell us what you see.
Inside 571, there are 2 pieces of clear plastic.
Let me go and replace those. May I approach?
Give us
Thank
the
you, Lieutenant.
seals, Jackson.
Those 2 bags are supposed to represent what was found by the SERT team on January 29th, 2022, correct?
Yes.
Like how we accepted that
There's 5
characterization.
pieces of plastic, 2 red, sorry, 3 red, 2 clear, correct?
As we sit here today, yes.
My question, Lieutenant Tully, is where did the other pieces of plastic come from?
Be more specific? Which pieces?
Where did the extra 2 pieces of plastic come from in those evidence bags?
Well, it appears to me that small fragment I pulled out may have potentially come from the larger piece. The
I
other,
think that, just to clear that up, you believe, as you sit here, that smaller piece was broken off from one of the larger pieces?
Does it
again,
match?
I'm making a big assumption here at your request.
Uh-huh.
Okay?
So, yeah, that's what it appears to me by looking in the bag.
And by the way, Lieutenant, this isn't a trick question. I'm not asking you to assume anything. You were there and you recovered the pieces. And you described recovering 3 items of evidence, correct?
No.
Didn't you just read in your report? I'll read it again, last sentence. The sneaker and 3 pieces of plastic were secured as evidence.
That's 4. That's 4.
Sorry, I said
3
items
pieces of
evidence. Items
plastic.
plastic.
Here he
Let's-
is
let's
with that
leave the
being
sneaker out of our
smart,
discussion.
like Buchanan.
You were the one that conducted the search, correct?
The SERT team conducted the search. I was
You
present.
analyzed the search.
Yes.
You were there photographing the things that were covered in the search,
Yes.
and ultimately you were responsible for bagging those items up, correct?
Yes.
There are 5 items in that bag, or in those 2 bags, right? Just the plastic.
Correct.
And yet your report very clearly says there were 3 items of plastic evidence recovered at the scene, correct?
Yes.
So my question, once again, is where did the extra 2 items come from? The pieces of plastic.
Well, as memorialized on the bag, it says pieces of clear plastic. So I'll take the hit that my report does not properly memorialize it. But I would argue that the
take the
handwritten
hit.
notes on the bag that are contemporaneous to the collection of the evidence would be more accurate, as is in my memory of 2 clear plastic things being collected. Now, as to the 3rd piece, again, I'm making an assumption, but it appears that that is a small piece that was separated from the other 2 pieces.
You don't know that that small piece separated from the other 2 by being broken off, do you?
No, I don't.
Just a guess on your part, right?
It's a guess. The bags were, out of our custody at the crime lab for a period of time. They had done an analysis. We did an evidence review with you, yourself, and the defense counsel on December 1st of last year, where we pulled all the evidence out. It was memorialized by your investigator, and it was put back in the bags.
You didn't see our investigator snapping pieces off the plastic, right?
He did not.
Crime lab did it.
I want to shift gears for a second, Lieutenant, and talk a little bit about the cell records that you testified to. Specifically the Verizon call records that you testified about. During your training, the 200 plus hours of training that you had, you've learned how to read Verizon records to determine cell towers that are used in your investigation, correct?
Yes.
You were also taught how to read Verizon call records to determine the sector or the side that a cell tower is pinging, for lack of a better word, called a cell face, correct?
Yes.
All right. One of the May I approach? No?
Yes.
Thank you. May I, Lieutenant? One of the documents that you rely on pretty heavily is ultimately it's a call record that gives you certain information provided by whoever the carrier is, Verizon, AT&T, T-Mobile, whoever, right?
Yes.
Do you recognize the document that's in front of you or the portion of the call record that's in front of you?
It appears to be a portion from the call detail records we referenced earlier.
Okay. My questions about this are relatively simple. There is a sector number that provides information that describes the directionality, if you will, of the target phone number, which part of the cell tower that target phone number or that target device was facing, correct?
Yes.
In your maps, did you include any of the cell face data about which portion of the cell tower was pinging vis-a-vis the phone that was being tracked?
No. Can I explain why I made that decision?
Please do.
When the trouble with depicting and making exhibits when relative to cell phone records is you don't want to make the map too complicated. So as I describe it to the jury, I want to make sure that the record is clear. Now, I don't typically will use the sector as part of my maps. I would argue that it gives greater deference to the defendant because the phone could be anywhere within a 360-degree area of the antenna opposed to a narrower 120-degree area around that antenna. So for the purposes of making a clear depiction, I typically will not use sector unless it's absolutely important to show that a handset was in a specific location.
And so you did not include the sector information on the maps that you provided, both to Mr. Lally, which you showed to the jurors and provided us, correct?
Yes, as relative to the CSLI ones, yes.
So in point of fact, according to the map at least, wherever that little triangle is, that red triangle that you use to denote the cell tower or the antenna, the responsive phone, the device, would be anywhere on a 360-degree azimuth from that antenna, correct?
Yes.
Good one, Vicky.
I want to ask you about the one map that was related to 5:20 a.m. to 5:37 a.m. Remember that?
Not off the top of my head.
Okay. There were several maps shown.
This looks like he's setting the stage for something that his own expert is going to bring up. They're going to point out one of these things doesn't work because of something you didn't include.
That's a copy of a page of an exhibit that's already been marked and entered into evidence. You recognize that?
Yes.
And that's a copy of your map that you did dealing with ENBID 57021, correct?
Yes.
And the time frame was 5:20 a.m. to 5:37 a.m. Is that right?
Yes.
All right. And by the way, do you know what ENBID stands for?
No, that's why the legend key is helpful. It's node is the NB, but I'm unsure on the E.
Evolved Node B Identifier, right?
Is that a question? Yeah, that's possible. Yes.
It is my question.
Okay.
Refresh your recollection. That's what it means.
I'd have to look at the key again, but that sounds right.
So an evolved, if that's what it stands for, an evolved Node B Identifier, and then a series of numbers after that is simply sort of the proper name for a particular tower.
Correct.
No two towers have the same ENBID, correct?
Correct.
Okay. With regard to, and I'm just going to call it ID 57021, do you see what appears to be, on your map, what appears to be the cell tower that is associated with that ID number, 57021?
Yes.
Okay. And there's one address that's denoted on your map, correct? Is that 34 Fairview?
No, there's multiple.
Okay. What are the other addresses that you noted on your map?
One Meadows Ave and Waterfall Bar and Grill.
Okay. May I approach you?
Yes.
If I could hand you another map, does that appear to be a Google map?
Yes.
Does that generally track the map that you created, the darker map you created? Meaning it's the same basic scale?
It is not the same scale.
How much different is that scale?
The one you handed me is a zoomed in version of the map I created.
Okay. You recognize it as being a true and accurate reflection of a Google map that's just zoomed in a little bit on the same basic area?
As you just described, it appears to be Google Map
Okay.
creation.
And you see two addresses that are denoted on that Google map?
Yes.
What are those two addresses?
34 Fairview Road and 12 Country Lane.
And as you look at that Google map with both of those, given your experience with both of those addresses, those appear to be denoted accurately on that
She was
Google
on the
map.
way to Jen's house.
It does. I would note that you can't see the roads really on this map that you handed me.
Understood. I'm not going to ask you a question about
It's
the
kind of it's a white blur, so it,
Okay. But does it look like that's where 34 Fairview is and that's where 12 Country Lane?
but yeah.
Okay.
General
Then I'm gonna ask you
orientation.
for the third item that's denoted on the map, and that is the cell tower 57021. You see that denoted on the map?
Yes.
Does that appear to be generally accurate in terms of the spatial location of where that cell tower is?
Yes.
Move through the admission of that item, that document.
Objection.
Lally object because he doesn't know what else to do.
Thank you.
Sounds like she just overruled that without saying anything at all. Like we're just going to ignore his objection.
Thank you. Taking a look at that exhibit, would
He
you agree
authenticated
that
it.
the cell tower 57021 is significantly closer to what's denoted as 12 Country Lane, the McCabe residence, physically as a crow flies, than it is to 34 Fairview?
I would not characterize it as significant.
How would you characterize it?
That it is closer.
Okay. May I comment, Sean?
Okay.
Take a look.
By 1.4 miles.
Take a look at the upper portion, upper right portion of the map that I just highlighted. What does that denote?
The cell tower that we previously mentioned, 57021.
Okay. And then there's a line it's a straight line from that cell tower down to this location. What is that location?
It's denoted on this exhibit as 34 Fairview Road.
Okay. And you see a legend indicating scale.
More than twice
How
as
far
far
back?
away,
I see
but that's not
I
significant.
see numbers and miles written on there.
Does that appear to be reflective of given your understanding and your experience with this location or these locations, does that appear to be a relatively accurate delineation of the distance between the cell tower and that location, and that address?
I don't know the distance between the cell tower and the address off the top of my head.
Would you agree that it's around 2 miles?
It's roughly 2
You're right,
miles.
2.5 times
Then I'm
more,
going to ask you to take a look at
140% more.
proximity, cell tower on the top of the screen, and then the address at 12 Country Lane. You see those two items denoted on the map?
Yes.
And do you see the approximate distance between those two items?
See it on the map?
All right. And does it appear to you that the distance from 12 Country Lane looks like it's less than half the distance to
Less than half.
34 Fairview?
I wouldn't characterize it as it appears to be less than half.
How would you characterize it?
My
It is
understanding of
less
that
than
area,
half.
I would say it's at least a mile between those two locations, as the crow flies.
Okay, meaning between the cell tower and 12 Country Line,
Yeah,
right?
Yes.
And it indicates approximately a mile, correct?
it does indicate that.
Okay. And the other location indicates approximately 2.4 miles, right?
It does indicate that.
All right, so would you agree that a mile is less than half of 2.4 miles?
I would agree a mile is less than half than 2.4.
You can take that out. You also noted that there were two cell towers much closer to 34. There are two cell towers much closer to 34 Fairview than the 57021, correct?
Keep staring
Yes.
at those
And
bags.
as a matter of fact, you already noted that for the jurors that say at 6 a.m. or 6:05 a.m. and thereafter, when it's clear that Ms. Reed was at 34 Fairview, she found the body of John O'Keefe, that her phone was relaying to those two towers, bouncing back and forth, correct?
Yes,
Those two towers are 57171, correct? Sorry, I don't need to test your memory like that. I can. There we go. May I approach?
Yes.
This is just his grand jury stuff, the same stuff that you should. I'm just going to give you that packet, Lieutenant. Like I said, it's not a memory test. If that helps refresh your recollection of the name of the two towers closest to 34 Fairview.
Are we getting a little lesson here in how police cherry pick evidence to present demonstrative exhibits like this?
Do you have that in mind?
yes, sir.
Get a
Okay,
little
so the two
lesson?
towers closest to 34
If he had mapped
Fairview
all
are
the towers
57171, correct?
on his
Yes.
maps,
And 57286, is that
we
right?
would have seen
Yes,
And both of those towers
which ones she was
picked up
closest
Ms.
to
Reed's
at all these
signal
different times.
at 12:33 a.m. and again after 6:03 a.m., correct?
you asked me about 1233, so it's okay, I'm going to refer back in the exhibit,
Of course.
and that is correct. It hit the 57171.
And then after 6 a.m., it was also picking up, bouncing, I think you said bouncing back and forth between 57171 and 57286.
Yes,
Both of those towers were picking her up.
yes,
Importantly, though, between 5:20 and 5:37 a.m., neither of those two towers ever picked up her phone or any signal from her phone, correct?
correct.
So based on those facts, it's far more likely that Karen Reed was actually at Jennifer McCabe's, and on her way to Jennifer McCabe's at and around 5 a.m. than going to 34 Fairview, correct?
Objection.
Sustained.
she won't let him get there.
May I approach just to retrieve?
Sure.
That's ridiculous. He's the one who drew the conclusions anyway.
I just want to make sure that.
Should have asked if it's consistent.
Oh, I'm sorry, that goes with that, I believe.
He's trying to say it's
Oh,
consistent with her lane
you
of
handed me that.
travel, but
Here's
it's
the marked item.
unlikely, isn't it? Given your own
There were two other documents you had handed me
Predicates
previously that
here.
are not marked.
Thank you.
that the closest tower is probably the one she's connected to.
I just want to touch very briefly on the ranging data, the RTT records. What does RTT stand for?
RTT.
Depends on who
return
you ask from
time.
Verizon, either range to tower or round trip time.
Have you
Yeah,
ever
round
heard of
trip
real-time
time.
tool?
I have,
Okay, so that's the RTT has several acronyms, but real-time tool is one of them, correct?
yes,
The RTT data is what you earlier described as a ranging data or access distance, correct?
I didn't use the term access distance, I know that Verizon may, but I said ranging.
So it's just in common vernacular, it's the distance from the tower or from the antenna to where the signal is going, correct?
Yes,
All right. May I approach one more time?
Yes.
Could you please review that and tell me if you recognize what's depicted on that document?
I recognize it to be one of the entries from the RTT report for the account we're talking about.
I'm sorry. And it's around 5:18 in the morning, correct?
Yes,
Okay, and you utilize this report or portions of this report, including this entry, to come up with your data especially as it relates to ranging data, correct?
Yes,
Do you see the column on that document called cross duration sex, right? Procedure duration sex.
I do.
What does that mean?
That is the amount of time in which this communication occurred.
Okay. Am I correct in understanding that the length of time for the RTT event is calculated in seconds, correct?
It is.
All right. Do you see the row in the exhibit that indicates the time 5:18 a.m.?
Yes,
And do you see a column that's labeled procedure start time?
yes,
And right next to it, there's a procedure end time, correct?
yes,
Are those the start times and the end times that you earlier testified to in front of the jury about the event in question at 5:18 a.m. or thereabouts, the start of the interaction or the communication with the device and the end of the communication with the device?
yes.
When you say communication with the device, what does that mean? What are you referring to?
It-
A phone call, a text, something?
We don't know. As I testified to, the ranging reports will create entries even unbeknownst to the user. So I have no information with this record before me about what the user was or was not doing with the phone.
But your testimony is that those two arcs that we saw, those respective arcs that we saw, your testimony is that this RTT data, in your view, establishes that she was on the device, not she, but the device was on the first arc at the start time, and it was on the second arc at the end time.
I'm going off the ranging that they give me.
And then you created those two arcs. I'm just trying to make sure I understand what the definition of those two arcs are in your map.
The definition comes from the first distance and last distance, which is denoted on this exhibit you have in front of me here.
Okay, and the first distance is
I thought we were
what?
0.82 miles.
triangulating-ish
Okay.
with the two
And the
towers.
second distance is, from memory, I think it's 0.97?
Correct.
That's a difference of what? We do the math.
1.5 miles.
0.15 miles, correct?
Excuse me, yes.
Okay. And do you see the procedural duration column indicated on that document?
I do.
Okay. And the procedure duration column indicates 0, doesn't it?
Yes.
However, if we look very closely at the start time and the end time, they're not actually the same times, are they?
Correct.
There's a difference in those two times. Can you tell the jurors what that difference is?
It is 4 thousandths of a second.
0.004 seconds, correct?
Yes.
And you testified that you believe that the start and end distances for the RTT event in question indicate two different locations for that device. In other words,
Over
the start time
0.004
it was on the
seconds.
first arc, the end time
She went
it was on the
0.15
second.
miles.
You don't know where on the arc, but somewhere on those two arcs.
Using the ranging data, I created a map, and
Understand?
that's what I
Yeah,
did.
we know.
Okay. And so the device would have
You're
moved
explaining
from
the
the first
map
arc
now.
to the second arc, correct?
Yes.
Right. You're familiar with,
So
obviously,
she went over
the
a tenth
formula
of a
to
mile
determine
in
speed
4
using
thousandths of a second.
distance and time, correct?
Yes.
All right. Can you calculate for us the speed that the device would have traveled to go from the first arc to the second arc over a distance of 0.15 miles in 4 thousandths of a second?
Not off the top of my head.
Okay. Let me see if I can help. So distance,
Do the math for him.
sorry, speed is calculated as distance divided by
Look
time.
at that
right?
expression.
Yes.
If you divide 0.15 miles by 4 thousandths of a second, you come up with 37.5 miles per second. Would you agree?
Objection.
Sustained.
Can you do the calculation in your head?
No, sir.
You need a calculator?
I would.
Your Honor, if
I'd like to see counsel at sidebar, please.
What's wrong with this, Bev? What's wrong with this? Witness isn't allowed to use a calculator to do basic math, or do we need some foundation to establish that this is this is arithmetic. This is not the fancy calculus you need to do to map out, cell tower stuff. No, this is arithmetic. This is stuff we learned in grade school. It's okay, he needs a calculator. I need a calculator too. I can't do math in my head. Jeff, Jeff can do math in his head, okay? The man is a walking abacus. It's absolutely insane. I have no idea how he does it. It amazes me every time he can just pop out, you know. I'm sitting here struggling to come up with a number, and it's just like that, just right on the tip of his brain. It's okay that he needs a calculator. I would also need a calculator, but yeah, this is legit. This is legit because the whole point is for his theory to work, for it to be consistent with what he testified to. We have to account for the movement over the time that's reflected in the records. And is that feasible? 37.5 miles per second? If we convert that into hours, we can do that math too. That's also simple arithmetic. 37.5 times 60 would give us miles per minute times 60 would give us miles per hour. And I get 135,000 miles an hour she would have been going.
So Tully, do you happen to have your cell phone with you?
I thought you were going to ask the other question first with your numbers.
I can. Let me ask you, so you don't have to sit there with a cell phone in front of you. Let me ask you if you would agree with this, that 0.15 divided by 0.004 is 37.5.
I'd have to write it out. I'm not sure. I'm sorry.
If you had a calculator in front of you, could you do it?
I could.
You don't have your cell phone with you.
I do not.
With the court's permission, I've got mine right here. I can turn it on. Or my co-counsel has one.
How about, can you use Madam Court Reporter's cell phone and do that? She's closest.
Yes, Your Honor.
Thank you.
Use Madam Court
Thank you,
Reporter's
Madam
cell phone.
Court
We're really
Reporter.
throwing Madam Court
If you
Reporter
could
under the
divide
bus and all this, aren't we?
0.15 by 0.004, let me know what you come up with.
37.5.
So that would be, given the fact that the distance, as calculated, as indicated on that record, the distance is 0.15 miles over the course of 0.004 seconds, right?
No, I would push back as to when the distance was being created. That's the first distance and last distance.
Correct. What you indicated was the cell phone or the device was on the first arc during the first time, and the start time, and on the second arc at the end time. All I'm asking is some basic math. So you would agree that if the calculation we just did, or you just did, is 0.15 miles divided by 4 thousandths of a second, that is 37.5 miles per second, to stay consistent, miles per second, correct?
But I don't agree with the premise of the question. So
You don't have to agree with the premise of the question. I'm asking you about
Just
the
do the
math.
math
Oh, the
first.
math is correct, yes.
The math is correct. Right? It's miles per second, correct?
Yes.
Based on that calculation. In order to get to miles per minute, you multiply it by 60, correct?
Yes,
Can you do that for me, please?
Madam Clerk.
Let's get to the 135,000 miles an hour. Let's do the math first. And now you can explain why you think that doesn't work.
The question again, sir, I'm sorry.
Yes. Multiply
Boy, and here we thought that
37.5
ludicrous
times
mode in the
60
Tesla was so
would give us
impressive.
miles per minute. What is that number?
2,250.
And if we wanted to go to miles per hour, which we're more familiar with, multiply it by 60 again, wouldn't you? And what's that number?
1,035,000. Excuse me, sorry. 135,000.
135,000 miles per hour, correct?
Yes,
So you would agree, if the premise is moving from the arc, the first arc, moving 0.15 miles to the second arc over the course of 0.004 seconds, the device would have to be traveling 135,000 miles per hour, correct?
in your question, you said 1.5 miles travel. It's 0.15 miles. You corrected me. I'm going to throw it back at you, sir.
Fair enough, fair enough.
All right.
Okay. 0.15 miles over the course of 0.004 seconds, the device would have to be
That didn't
traveling
land, dude.
135,000 miles per hour. It's basic math, correct?
While I agree with that, I would push back. That's probably not what the record is indicating.
You would agree that that is physically impossible, correct?
For a cell phone, yes.
Right. And you would also agree that since that's impossible, you're not suggesting to this jury that the device moved from arc 1 to arc 2 in 4 thousandths of a second. That can't be what you're suggesting.
I'm not suggesting that.
Okay. fact, what actually makes more sense is that the signal was moving to and from the device at light speed, 186,000 miles per second.
It does. Radio
waves move at what?
speed of light.
Speed of light, 186,000 miles per second, right?
Yes.
Okay. If, as you indicated on direct examination, if that return signal, the bounce, is in any way refracted, meaning it takes a deviation, and it's not straight because of something like, I don't know, weather, precipitation, or snow, then it would take longer to get back to the intent, correct?
That's fair.
And that could be what's reflected in that map and the distance of the two arcs. Isn't that correct?
That's not my experience with these records.
But you do agree that in fact the device, as you indicated earlier, moved from arc 1 to arc 2 from the start time to the end time. That's impossible.
No, I'm saying that the records reflect that the first time the distance was created, marked, and the second time the distance was marked, that's what's represented on the map.
Right, but you said that those are reflective of the start time and the end time, which is 4 thousandths of a second apart.
No, I don't know that's when these distances were created.
But
It
that
doesn't
is what he
say
said.
start of procedure distance. It says first distance, last distance.
Actually, it says, see if I got the copy of what I just gave you. I don't. Can I approach?
Yes.
Procedure start time, 5:18 and 19 seconds, 0.154, right?
Yes.
Procedure end time, 5:18, 19 seconds, 0.158, right?
Yes.
That's the difference. May I approach one more time?
Yes.
That's the difference. And that's the 4 thousandths of a second difference, correct?
Yes.
And on direct
Yeah, when it
examination,
started,
you
when it
said the
ended.
start time and the end time are how you calculated the two different arcs,
No.
correct?
No.
Are you changing your testimony?
No, the map says first and last, as reflected in the record, first distance and last distance. So one could hold the map and this record next to each other and figure out how I determined those locations depicted on the map. It doesn't say start and end time. It says first and last.
Right.
But the data
But-
says start and end.
You said that it was the beginning of the communication and the end of the communication, which are both reflected on that document, Lieutenant. The
Yes.
start time and the end time. I understand what you're saying about the distance, 0.15. Nobody's arguing about that. You're saying, you said on direct examination that the distance was a difference between what time the first arc occurred and what time the second arc occurred. And there was a distance between it. And your testimony was the device moved from the first arc to the second arc. Just said it, right?
I'm saying the device moved from the first arc to the second arc, yes.
And it would be impossible to do that in 4 thousandths, correct?
A cell phone, yes.
You did, one last issue, and I'm gonna deviate from the cell tower stuff. You got information during the course of your investigation.
Just showing
That's-
off here why I married this man.
An eyewitness placed a Ford Edge in front of 34 Fairview in the early morning hours of January 29, 2022, correct?
I'm familiar with that.
As the supervising investigator, by the way, you were familiar with the fact that the eyewitness placed that Ford Edge see if I can start that over. The eyewitness indicated that the Ford Edge was placed there sometime between 2:30 in the morning and 3:30 in the morning, correct?
I'm familiar with that.
All right. As the supervising investigator, did you do anything to investigate the circumstances of that Ford Edge being placed in front of 34 Fairview sometime between 2:30 and 3:30 in the morning?
Yes.
What did you do?
Well, we determined the veracity of that statement, and we want to make sure that the person who gave it is consistent and accurate and had a good vantage point of it. I have concerns about.
By the way, were you satisfied
Oh,
with
so
that?
a lot
No.
more than you
Why
did
not?
to determine the veracity
Well,
of
the
McCabe and
person has given the
Alberts.
statement multiple times, and it appears to have changed over those times. It also appears that the person observed this vehicle from a distance, and also the identification of a Ford Edge seemed highly suggestive the way that I had read the account of it. If I had done that as a police officer, this court would throw out that identification.
Oh, would they?
So
I kind of doubt that.
did you find
Anti-Bev.
out? Anybody in the Albert family, for instance, on the Ford Edge?
I don't recall off the top of my head if somebody,
Did you look at automobile registration records?
I did not know.
Did you task anybody else to look at automobile registration records?
I believe Trooper Proctor and Sergeant Mechanic had investigated that.
And do you have any idea what that investigation revealed?
I don't.
Did the Alberts own the Ford Edge?
I don't know as I sit here.
They did own the Ford Edge, didn't they?
Objection.
So the objection is sustained.
But nothing was done further that you're aware of to investigate the circumstances of that Ford Edge being seen and placed in front of 34 Fairview, right where the body was found, between 2:30 and 3:30 in the morning, right?
An investigation into the reliability of that witness was conducted.
So you just decided, and that investigation, quotes, is, I didn't believe him, right?
No.
Yes.
Whereas Jen and Chris and Brian,
Mr. Lally, anything?
that's
briefly.
it. Nothing about the seals on those bags. Maybe we'll just get that in closing. Doesn't give him a chance to explain it.
So as far as that last line of questioning, as far as the witness in the Ford Edge, you mentioned that there were several different stories, correct?
Yes.
Several different versions of the statement.
Yes.
And what were those different versions?
The first was that this person saw a Ford Edge in front of 34 Fairview. The next one that I can recall is that the person stated that they were not on Fairview, but on Cedar Crest, some distance away, looking at this vehicle in a blizzard. Person also self-reported that he was colorblind, and he was operating a larger motor vehicle. The third story was a concern about the time. The third story was as he arrived, the Canton police had the street blocked off at about 4 a.m. and he places this Ford Edge outside the residence at a time before that. So we know through our investigation that the Canton police didn't arrive till shortly after 6 a.m. So the witnesses' times are off as well.
As far as the, what you
I don't
termed
hear
as the highly
inconsistencies
suggestive
there.
ID with the Ford Edge, can you explain what you mean by that?
As I
hear,
read the report,
more detail being elicited.
The investigator had asked
Funny,
the
that's how the
person,
read technique works.
First,
like
the
we've been talking
question,
about
they
from day
stated
one.
that there was a vehicle in front of 34 Fairview Road. The witness was then brought outside, and the investigator allegedly pointed to a motor vehicle that was in a parking lot, and it said, "Is that it?" And the witness said, "Yes, that's it." And so it's suggestive in the fact that it would be a single photo identification, which,
have you ever done
as
a
a
show
police
up?
officer, I would
Ever
not
done a
give
show
somebody
up?
one thing and be suggestive.
Is this the guy
it?
who
'Cause
did it?
as the courts have ruled, that's highly suggestive, and the person's more likely to adopt that description of whatever they're describing, opposed to if you use other methods.
Now, when you were being asked on cross-examination about certain distances from the house at 34 Fairview to the area where you had recovered items, repeatedly you had been asked about a distance of 30 feet, correct?
I did.
From the items that you recovered in the area that was described to you as where Mr. O'Keefe's body was located shortly after 6 a.m., is that 30 feet from the house?
No, where the items were a little further on the edge of the property, so it'd be closer to 40 or 50 feet.
And as far as where Mr. O'Keefe was located with reference to the curb, with reference to the street, how close was that?
From the curb, reports was about 10 feet from the curb.
And so the evidence was a lot closer to the roadway, a lot closer to the curb than it was to the house, correct?
Objection.
Sustained is defined.
As far as what, if anything, did you find significant between the location of the evidence in relation to and Mr. O'Keefe in relation to the roadway versus in relation to the house?
The pieces of evidence were physically on the roadway, on the pavement, or the curb.
Just one question as it applies to the Sally Port video from the Canton Police Department, are you aware of sort of how those videos were recorded as far as when they stopped, when they started?
Not off the top of my head, no. But the ones we have in possession, no.
As far as, and I'm sorry, let me ask the question probably a little more succinctly, but with reference to, are you familiar at all with the camera system at the Canton Police Station?
Vaguely, yes.
As far as, do you know whether or not it's motion active?
The Canton IT director stated that it was motion.
So the objection is sustained.
So let me ask you, are you aware that the cameras are motion active?
Objection.
As to form, it's sustained.
What, if anything, are you aware as to how the cameras report?
Objection.
I'm going to allow it.
What, if anything, is the magic cure-all?
You are muted.
We haven't established his basis of knowledge. How does he know? Who told him? Somebody told him. This is backdoor hearsay. This is what they call bootstrapping. Because he doesn't know. Did he buy the system? No. Does he maintain the system? No. Does he have the documentation for the system? No. He collected the video and somebody told him stuff, at best. Why don't we bring back the IT guy, Mr. Jutras? Why don't we ask him? Did he maintain those videos? Maybe Canton Police has their own IT person.
You are unmuted.
Lieutenant, when it came to the Sally Port video, at some point you did review them to some extent.
Yes.
Now, over the course of your review, what, if anything, did you note in reference to time? Was it sort of one long consistent, or did it jump?
It jumped.
And based on that, what, if any, conclusions did you draw as to how that video recorded?
It appeared to be motion activated. As these jumps occurred, it appeared to be triggered by motion.
Now,
Yeah,
with reference
the
to the items
operating in the
that
middle
were
of their
recovered on
motion.
January 29th during the SERT team search that you were present for, in addition to your police report, how, if at all, were they memorialized?
On the exterior of the paper bags that they were contained in.
And when was that done? Before or after February 10th, when your report was written?
Objection.
Ask it differently, Mr. Lally.
When was the memorialization on the evidence bags done in relation to when you wrote the report?
Passive.
I'll allow it.
When was it done?
The difference would be the notes on the outside of the bag happened at the time of collection, and then I wrote my report 11 days later.
So, as far as your memory, as you sit here and testify today and yesterday, as far as the items that you took out of the bag, are those the same items that you recovered or were recovered by the SERT team on January 29th?
Yes.
Now, the
Would somebody
information
just show
from
us
the
the
call
bag?
detail records that Mr. Jackson presented to you, there was essentially two little columns, correct?
2 rows, yes.
Because the crime lab
Um,
photo
and
showed
Was
DeChico
that
sealing
for the
that bag
entirety
on
of
February
what you
4th.
reviewed as far as the call detail records? in
Why
relation
was he
to
doing that?
Generating the slides that were depicted to the jury?
No.
And I'm sorry, may I approach you?
Yes.
May I see the exhibit? I'm sorry,
These are not marked.
the mark.
Which one?
Whatever the last one was, Mr. Jackson. Yes, thank you. May I approach the witness, John?
Yes.
Showing you now what's been marked as Exhibit 577 with reference to what Mr. Jackson had given you earlier. Lieutenant, from what's depicted on there, what, if any, issues do you have with the depiction on that exhibit?
Like I mentioned, it's difficult to get a good sense of what we're looking at because the roads don't really appear on here. If they do, they're light and faint. There are, the large black line kind of intersects with a lot of them, with the words of them. At the bottom, it looks like it's written map scale next to a scale, but I can't attest to the veracity of that. Those would be a couple problems I see.
Now, with reference to
Because it's measuring where the crow flies, it
slides
doesn't
that you
matter.
created, with the different time frames, not just the one single time frame. Again, the times that you observed, or the location of the handset, of the cell phone, of the defendants that you observed from the call detail records, were they consistent with other pieces of evidence that you had, whether it be video and or witness statements?
Yes,
And that would be consistent with the location of the defendant, correct?
yes.
Nothing from
Now-
Jackson about GPS.
You were asked some questions about speed and distance traveled. And you indicated that you did not agree with the premise of Mr. Jackson's question, correct?
Yes.
Can you explain to the jury what it was about the premise or what it was that you did not agree?
So while I agree it would be impossible for the phone to travel at that distance, I disagree with the premise that the procedure that was being captured here and the distances may not be at the same time. So there may be the distance could have preceded the procedure, and the end distance could have been after the procedure. There are other ways to capture that information. Again, all I'm doing, and I'm at the mercy of the records,
The data could have been
is
something other
illustrating
than
them.
what the
I
records
then take
reported.
the next step in order to corroborate that information, ideally through video and other location-based information.
Now, in relation to speed, is that something that you've done in other cases with call detail records?
Yes.
And you mentioned that you weren't able to do it here or didn't do it here. Can you explain why not?
By speed, do you mean route of travel or?
Yes.
So if I have a more robust set of records, so again, we're at the mercy of Verizon here. We only got a limited number of records from the ranging data. With other cases, if the phone is much more chatty with the antenna, if there's more lines of communication, I've seen lines of communication as frequent as every couple of seconds or less than a couple of seconds. As I map those out, I can make more of a determination of maybe the route of travel of the cell phone. So as I put the first arc, I'll then place the second arc on a map and say to myself, how could a handset get from the first arc to the second arc? And I'll have a number of possibilities. I will then lay out the third arc. Okay, how could a phone get from the second arc
Like you
to the
showed
third
us
arc
and
and
testified
repeat
to
that
in your
process,
direct,
narrowing down the
this
different
was consistent with
possibilities.
her
And
route of
oftentimes
travel.
I'm able to determine the route of travel, send investigators down to that route, and we find corroborating information.
And again, why was
Mm-hmm.
it that you weren't able to do that with this information that you received from Verizon in this case?
We received a limited number of entries in this record.
And what, if any, relationship does that have to sort of the area or the geographic location as far as the town of Canton is concerned and the number of antennas there?
Is Verizon the only company that
Well,
maintains
as
towers
respective to
there?
the number of records, it's a larger area the cell phone could potentially be.
So in no way in your testimony, in your slides or anything else, are you suggesting that the device or the handset or the defendant's cell phone was traveling at that speed, correct?
Correct.
So could you explain to the jury again exactly what those arcs mean and what you are explaining with reference to?
Those records have a start distance and an end distance. I take those distances, place them on a map, starting where the antenna, there's also in that record, states it is. Draw a distance from that antenna, draw an arc at that distance with the radius being the distance that's on the record, and have an arc that's in excess of 120 degrees.
You also asked some questions about whether causing some sort of interference or something in relation to the recording with regard to antennas or which antenna a device might connect to. You indicated that was not your experience with these types of records. Can you expound upon that?
The greatest predictor of what antenna a cell phone is going to use is distance, because like I said, the farther the handset is away from an antenna, the more degraded the signal is going to get. So that's the best predictor. But like I mentioned earlier, there are things that can disrupt a cell phone signal, which would cause a handset not to connect to the closest antenna. And that can be physical obstruction, precipitation, elevation, an antenna goes down for whatever period, for whatever reason, causing it to connect to another antenna that is technically further away.
And so from your review of the
So
call
in other
detail
words, a
records
single
and
ping
from
tells
your,
you
mapping
nothing
from
certain
those,
about
various
location.
timeframes contained within the slides we'll send to the jury. What, if anything,
Tells you
can
it's
say
within the
from
range of that
material
tower.
in reference to the other evidence collected as to the location of the defendant's cell phone during those relevant times?
Well, relevant, I'll zero in at 518. I would suggest that the defendant, her vehicle, and the cell phone were on Washington Street outside of Temple Beth Abraham at that time. That's one thing that I would be comfortable suggesting.
May I have a moment, Trump?
Yes.
Based on what might have been a black SUV being on the street outside Temple Beth.
Thank you, sir. Nothing further, Your Honor.
Jackson?
Very briefly, Lieutenant Tully, do you still have, I think it's 578, exhibit 578?
I have 577.
Is,
578 is not marked yet.
oh, it's not? Where's the RTT record? Is that 577?
I have RTT records that are not marked in front of me.
May I approach?
Yes.
Move to admit.
Slow.
Objection.
Right. So let's mark it for identification, Milton.
Marking it for identification only.
Just have the witness identify it.
Understand. Sorry, and that was letters.
Triple K.
Thank you. You're looking at triple kilo, correct?
Yes, sir.
All right. When you created the arcs on your map, you also put on the map 5:18 a.m., correct?
Yes,
Where'd you get that number?
from the procedure start and end time.
So you did use the procedure start time and end time, correct?
To denote the time, but not, yeah, to denote the time on the slide, yes.
And the event, correct?
Yes,
All right, so the 5:18-19, I'm sorry, 5:18 and 19 seconds, and then, I don't have it in front of me, but 0.154, I think. Is that right?
yes,
That was the time that you used to establish that the device was on the first arc, correct?
no, I didn't use it to establish the arc, I used the distance to establish the arc, and I placed the time on the slide.
What time, Lieutenant Tully?
5:18,
The time that Verizon gave you as the start time, correct?
yes, they're both 5:18.
So there's a start time and a start distance from the tower. In other words, the event took place at this distance at this time starting, correct?
No, you're using the wrong words. It says first distance.
I'm not using the wrong words.
Yes, sir, you said start distance. It's first distance.
Okay, fine.
Oh,
Okay, pick
that
the
matters.
word. First distance. Start time and first distance, correct?
Yes,
Then
those are on the record.
Right. Then Verizon gives you an end time, correct?
Yes,
And last distance, correct? And you created your arc based on the start time and first distance versus the end time and last distance, correct?
No, he ignored
no.
the start and end times.
The time weren't associated.
That's what you're
saying
getting
no
at.
is because that would require the device to travel at 135,000
He just
miles
used the
an hour.
distance. He
Objection.
ignored
If
the
the witness
start
could
and
please
end
answer the
time
question.
because it would
Let
require
him finish.
135,000 miles
And
an
then
hour.
the objection to that is sustained. You can ask it differently.
Go ahead.
The times were not part of the depiction of the range. While
It was just your
I will
testimony
suggest to
that
you
it
that
moved from arc to arc.
it is probably unbelievable that those are actually start and end times. What I'm saying is we don't know for certainty that that is the exact time, the first distance and the last distance. I'd have to look back at the records. But I also say that we have corroborating evidence to say that that is accurate.
So
You
have to
ignored
look
the
back at
times.
The records, correct?
Yes,
That is your record.
No,
That's what you looked at, isn't it?
the record's key.
And where's the records key?
They were provided by Verizon.
Where are they, sir?
I don't have them in front of me.
Right. That's all.
Okay,
May we approach this briefly?
okay. Don't leave yet, Detective.
What he's saying is he ignored the times. He just used the distance to calculate his two little arcs. He ignored the fact that there was a time discrepancy between them, because when you account for the time discrepancy between them, you require the 135,000 miles an hour to get from one arc to the next arc, like he testified his depiction shows. Just a little selective, just a little selective, like not mapping out all of the towers in the area that the phone could have connected to, like not mapping out the ranges of those towers so that we can see where within that range of that tower could the cell phone be in order to connect to it. Could be 10 miles away, as far as we know. Could be more. Depends on how strong the tower is. Very imprecise location information, and yeah, just a common source of pseudoscience. So what is Lally trying to be able to get the key in? He wants to keep going down this road. He doesn't like how that ended. It's fine, Jackson. Just go ahead and bring your own guy on to tell us all what a bunch of bullshit it is. It's totally fine. We're going to be okay with that. I still want to see. I want to see where on these evidence bags does it show? Where does it show Lieutenant Tully here sealing the bag and logging it into evidence? Where is that on January 29th? He said he did that. Can't somebody show me? Because all I saw was David DeChico sealing it back up on 2-4. And I don't know why he did
Your Honor,
that.
I believe this defense counsel's as well.
Yep.
All right, your next witness, Mr. Lally.
Yes, Your Honor, the Commonwealth calls Sergeant Brian Gallerani to the stand.
Brian Galler, another Brian. No idea who this guy is. Did I get his name right? Better check.
You saw this with the evidence of the court and during the case now hearing for the truth, the whole truth, and nothing but the truth. So
Yes, I did. Oh, he's from Needham. He's the one that took the swabs from Proctor and Buchanan.
Whenever you're ready, Mr. Lally.
Thank you, Your Honor. Good afternoon.
You are unmuted.
Afternoon.
Could you please state your name and spell your last name for the jury?
Ryan Gallerani, Gallerani.
And what do you do for work, sir?
I'm currently employed as a sergeant for the Needham Police Department.
And how long in total have you been a member of the Needham Police Department?
I graduated the academy January of 2006.
And how long have you held the rank of sergeant?
Just under a year.
Now, prior to you holding the rank of sergeant, what was it that you did within the Needham Police Department?
I was a detective from September of 2014 to June of 2023.
Now, over the course of your work as a detective and sergeant with the Needham Police Department, what, if any, training have you received in regard to collection of biological samples?
As part of the sexual assault class I took in January of 2015, I was certified in DNA collection by the Mass State Police.
And can you explain a little bit to the jury about sort of what that certification process entailed or what it was that you did to become certified?
Was it 200 hours?
So I was specifically certified in buccal swabs, which is the process of collecting cells suitable for DNA comparison by swabbing inside of a person's cheek.
And that certification, is that up to date at this point?
Yes.
Now, at some point on January 16th, 2024, did you have occasion to collect buccal swabs or samples in relation to this case?
I did.
And fair to say, as far as your work with the Needham Police Department, you had no familiarity or work with the investigation on a Canton Police Department case?
Correct.
Or on a state police case involving incidents that occurred in the town?
Correct.
You didn't know any of the parties involved in the case?
I did not.
And so on January 16th, 2024, where did you go on that day?
I went to the Norfolk District Attorney's Office in Canton.
And who, if anyone, did you meet with, or who, if anyone, did you collect samples from on that day?
I collected samples from Sergeant Buchanan and Trooper Proctor.
And can you explain to the jury just briefly as far as the process of your collection, as far as what physically did you do?
So I physically swabbed the inside of their mouths with a cotton swab and collected the evidence, sealed it up in a buccal swab kit, photographed it, and brought it back to the Needham Police Department.
And when you brought it back to the police department, what did you do with it then?
I entered it into the evidence.
Same
and
day?
did you do that in conformity, both the collection and the securing of the item, did you do that in conformity with your training and certification on buccal swab collection?
I did.
Now, with reference to those items, at some point were you informed that those items were to be transferred or transported to a voting technology lab in Lorton, Virginia?
I was.
And were there specific instructions as far as shipping was concerned that were provided by the voting technology lab?
Yes.
And the shipping that occurred in this case, was that in conformity with what Bodie had provided as far as the policies or protocols for shipping
So
those
are we
types
getting
of
Bodie
It was.
next?
Thank you, sir. I have nothing further.
Anything?
We have no questions.
All right, you're all set, Sergeant.
Thank you.
Very
Have a
much.
good day.
Next witness?
Yes, Your Honor. The Commonwealth call Mr. Nicholas Bradford to the stand.
All right, and who is Nicholas Bradford? Is he the guy from Bodie? Indeed he is. Witness number 57 on the list.
Watch step forward.
You solemnly swear the evidence given to the court and jury in the case now and here and the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
Bodie is the private lab that they used for some of this DNA analysis. Not sure why they used them.
Forgive me, Your Honor. May I have just one moment?
Sure.
Good afternoon, sir.
Good afternoon.
Could you please state your name and spell your last name for the jury?
Yep, it's Nicholas Bradford, Bradford.
And sir, that microphone before you is adjustable. You can place it anywhere that's comfortable for yourself, okay? What is it that you do for work, sir?
I'm a DNA analyst for Bodie Technology in Lorton, Virginia.
Okay, you're definitely going to have to keep your voice up, sir, okay?
Sorry about that.
You?
Now, sir, if I could,
Sorry. It's Bodie Technology in
Okay, I
Lorton,
love
Virginia.
how the
and for the record, Bodie is
Closed
just spelled
captioning
as
is
far as
getting it.
B-O-D-E, is that correct?
Correct.
not Bodhisattva.
Now, sir, if I could just ask you some questions about your educational background,
Not
starting with your
Bodhidharma.
undergraduates. Where did you go for your
BODE.
undergraduate, and what, if any, degree did you receive from there?
I have a Bachelor of Science in Forensic Biology from Mercyhurst College in Erie, Pennsylvania.
And then following your graduation with that degree, where did you go from?
I have a Master of Forensic Science in Forensic Molecular Biology from the George Washington University in Washington, D.C.
And when about was it that you received that master's?
It was around about 2011.
And with relation to your graduate work and your work at Bodie, when did your work at Bodie begin with relation to your graduate work?
I started at Bodie at about 2009.
So during the course of your graduate school?
Yes.
And when you started with the Bodie lab, what was the sort of position or what did you start doing when you began?
I was a DNA technician. We assisted the analysts with their case files, and we primarily operated the different robotics and the different processes in the lab.
And at some point
You were
over
a
the course of your
centrifuge
work there,
jockey.
you
You
then
can just
became
say
an
that.
analyst, is that
It's
correct?
okay.
Yes.
And about how much time elapsed or how much time did you spend as a, excuse me, as a technician prior to becoming an analyst?
I was a technician for about a year, maybe two. And then I was in the data banking section as an analyst. And since then, I've worked in the high throughput casework group and the customized casework group.
Now, as far as your work within this particular field, have you had occasion to work in any other sort of labs or facilities?
Yes, for about 3 years, I worked at the Pennsylvania State Police DNA lab.
Now, Bodie Technology, as far as that lab is concerned, can you describe for the jury sort of what kind of lab that is? And let me ask you first by just about how many analysts work at Bodie Technology?
Somewhere in the neighborhood of maybe 100 analysts, give or take. We're a small private lab in Lorton, Virginia, and we do DNA work contracted through different police agencies throughout the country.
Now, in addition to police agencies, are there other types of entities that would that you would accept or that would send submissions for DNA casework?
Yes, we do some international work with human identification and that sort of thing as well.
So not defense
Now,
lawyers is what we're getting
as far
at.
as the lab at Bodie Technologies, is that lab accredited?
Yes, we are accredited through the National Standards Institute.
And can you speak a little bit about that sort of accreditation process and what it means to be an accredited lab?
Yes, so that the National Standards Institute has a set of criteria for DNA labs doing forensic work. And we are audited against those criteria every year, sometimes internal audits and sometimes external audits.
Is that accreditation at the lab, is that up to, the accreditation, is it current as of now?
Yes.
Now, with reference to your work as a DNA analyst, can you describe just in general terms for the jury what it is that you do in reference, what is it that you do in reference to your work as a DNA analyst?
Yes, so we take in evidence that's submitted to us. We process it through the DNA processing. So there are 4 basic steps to DNA. There's extraction, so that's where we separate out the DNA. And then there's quantification, and that is basically just us determining how much DNA we have to work with. The next step is amplification. So depending on the case and the different processes that we're going to use, we're targeting a number of different locations in the genome, and we're going to make millions of copies of each of those locations. And in each one of those copies, there's a little fluorescent tag that we can then detect in the detection step, and that's the 4th step. And then that, from there, we have the DNA profile for that sample.
Now, with reference to the lab as far as training is concerned, you mentioned that you spent at least a year or 2 as a technician prior to becoming an analyst. What are some of the training, specialized training in this area that you wanted to go as an employee at this lab?
Yes, so the training program involves a lot of scientific literature reading. There's a practical aspect to it where we're given known samples that we're to treat as if they were casework samples. So we process those as if they were casework. We have written and verbal exams, and we have a moot court exam at the end.
And you successfully completed each of those training sort of portions of, over the course of work with the lab?
Yes.
Are you familiar with a term known as a proficiency test?
Yes.
And can you explain to the jury what that is and how it relates to your work as a DNA analyst at Bodie Technology?
Yes. So part of our accreditation is we have to do proficiency testing twice a year. And that is when an outside company sends us known samples and we process them, again, as if they were casework. And then those results are sent to that outside company, and then we get the results back to see if we are proficient in those technologies or not.
And with respect to yourself, as far as the proficiency testing that you've undergone, what, if any, issues have you had with proficiency testing that you've undertaken?
I've passed all my proficiency tests.
Now, what is DNA?
So DNA is essentially
What is
the
DNA?
blueprint for a living thing. It's in most of our cells, and it's unique to an individual with the exception of identical twins.
Now, at some point in January of 2024, did you receive a particular assignment in regard to DNA analysis from a number of items that you received from Massachusetts?
Yes.
And specifically, can you describe the process as far as like when that item comes into the lab at Bodie Technology, how it's sort of processed, or how from the time of receipt to the time that the item gets to you? Can you explain a little bit about that process?
Yes, so the item is generally sent via UPS or FedEx. It arrives in our secure evidence room. That room has limited access to only certain individuals. And from that point on, when it's received, a chain of custody is started for that shipment. And anytime anyone touches or uses that item, we need to check it out from the secure evidence room. And then that's all logged on the chain of custody.
Now, when something comes in, is it assigned a sample name or a case number or an ID number in some way, shape, or form?
Yes.
And is it also identified by sort of the corresponding numbers from the external vendor where it came?
Yes.
Now, in reference to Bodie case number CCA 2416-0023, did you perform work in relation to that case?
Yes.
And there was a corresponding agency case number of 22-02184, is that correct?
Yes.
And that would have been from the outside vendor, or at least one of them, as far as the Massachusetts State Police crime lab, correct?
Correct.
So there were a number of items that you received. If you could identify them for the jury, what you received and specifically sort of what you looked at.
Yes, so we received an apparent hair. We received an extract from a taillight from a vehicle, and we received 2 reference samples from 2 troopers from the Massachusetts State Police.
And in addition, was there a sample ID as far as a known standard?
Yes. So Bodie gives it our own our own item number. So in this case, the 2 reference samples were CCA 2416-0023, R03, and the same number R04 for the 2 reference
from the
samples.
crime lab.
Now, if I could just ask you to further expound upon as far as the CCA 2416-0023, which is E01. There was an agency sample ID, is that correct, that was attached to that?
Yes.
And what was that, sir?
So that was 3-6.1.
Is there a description that comes from the external vendor as well as to sort of what that item is?
Yes. In this case, the sample was a shaft end of hair from exterior passenger side rear panel.
There's a specific mass registration plate that's associated with that hair as well, is that correct?
Yes.
And that was 3GC684, is that correct?
Correct.
Now, with reference to the RO3 and RO4,
We'll talk about
those were vehicle
this.
samples, is that correct?
Yes, we will.
And RO3 specifically,
What the
as far as
statistics
agency
mean.
description, what, if anything, was provided as far as that?
For RO3, that was the buccal swab from Yuri Begedic.
And as far as RO4?
That was the buccal swab from Michael Proctor.
Buckle swab from
Now,
this
with
guy.
reference to
Not buccal?
The extract portion, that was EO2, was that correct?
Yes.
And if you know when you say extract, can you explain to the jury sort of what you understand that term to mean, or what is an extract as far as what you looked at?
Yes. So when I described the 4-step process earlier, so the extraction was already done prior to us receiving the item. So essentially, the extract comes to us in a tube, and it's a liquid. And provided with that would be the negative control that was associated with it. So from that point, we have the quantification information from the lab that did the extraction. So then we would amplify and then detect the profile from there.
And just to be clear, as far as the EO2 that you were talking about, as far as the extract that you had received, what was the agency description on that extract?
So that was the sample from passenger side taillight with the same registration number, and that was labeled as an extract.
Now, in addition to that, there was a known blood standard, which you indicated was item or agency sample ID 8-1.1.1.
Yes.
And what was the agency description on the known blood standard?
That would be from, excuse me, sorry, that was the sample from John O'Keefe, the profile, I should say.
And so when you say the profile as what do you mean by that?
Yes, so the profile was generated by the Massachusetts State Police Lab, and then that profile was given to us to do a comparison.
Now, as far as the profile that was provided, as far as your observations of that, what, if any, issues did you observe in your observations of the profile that was provided by the State Police Crime Lab in Massachusetts?
It looked like a standard single source profile.
Now, starting with, as far as there was a STR processing that was conducted, correct?
Yes.
What does STR stand for?
It stands for short tandem repeats. And essentially what we're doing with that is it's the DNA process that we use in forensic testing, where the areas that we're amplifying are short repeats of the genetic sequence that repeat multiple times, and we're just measuring the number of times that sequence repeats. And those numbers together are the profile.
Now, as far as the profile from the, excuse me, the profile from the extract that you received as far as EO2, excuse me, from the passenger side taillight of the vehicle, what, if anything, were you able to determine based on your analysis and STR processing of that?
Yes, so we determined that it was consistent with a mixture of 3 individuals, including at least 1 male contributor.
Mixture of 3 means
if you could just walk
trash.
Jury through as far as the process, as far as the testing, what is it that you're actually doing in the lab? What are you looking at, and how are you making a comparison?
So once we have the DNA profile, like I said, we're measuring the number of times the sequence repeats at a given location. So we have a series of those, and then we compare that to the reference profile that we were provided, or that we generated for the 2 reference samples that we actually processed. And then we determine if it's possible that the individual whose reference profile it is could be a possible contributor to that mixture profile that we got from the evidence. And then we need to do a statistical calculation to determine the strength of that possibility of an inclusion.
Let me ask you a little bit about, as far as that statistical calculation, how is that done, or where does that come from?
So in this case, we did what's called a likelihood ratio. Essentially, what we're doing is comparing 2 explanations for the DNA profile that we observed. So if we have, say, person A, one explanation would be that the DNA profile is a mixture of person A and 2 unknown individuals. And then the other explanation would be that it's simply 3 unknown individuals and it's not person A. So then we compare those 2 explanations of the profile and determine which one is more likely.
Now, as far as the sort of reference samples that you had the DNA profile of John O'Keefe, correct?
Correct.
And I'm sorry, or starting that, you had the extract with the DNA profile with multiple contributors from the tail.
Yes.
So then you have the known blood standards with DNA profile from John O'Keefe, correct?
Yes.
And then you have the buccal samples from Uri Buchanan and Michael Proctor, correct?
Yes.
And so
What about
with
the other
reference
10
to
or so people
those
in the
specifically
Sully
as far as the
port?
reference samples, is that what you're generating the DNA profiles from?
So we're comparing those
What
references
about
to
the
the mixture
cars
that we
team and
obtained
the crime
from
lab
the
people?
taillight. Yeah.
And so in your comparison, let me start with the known one as far as John O'Keefe. What, if anything, did you find from your comparison of the John O'Keefe DNA profile to the DNA profile from the taillight?
Yes. So in this case, when comparing the John O'Keefe profile, assuming a mixture of 3 individuals, it is at least 749 million times more likely to be observed if it originated from John O'Keefe and 2 unknown unrelated individuals than if from 3 unknown unrelated individuals. And we provide a sort of verbal qualifier to that because most people probably don't have a lot of experience with non-alien. So in this case, that would be very strong support for inclusion.
If you know non-alien, how many zeros are we talking?
So that would be the number with 30 zeros.
And so that would be a strong support for inclusion, correct?
Yes.
Now, with
Yeah, we're
regard
gonna
to your
talk about all
comparison,
this.
with regard to your work as a DNA analyst, is there any kind of software that you use in the course of your analysis with regard to an SDR mix?
Yes, when there's a mixture profile, we often use what's called StarMix, and it's essentially a computer program that we input the DNA profile, and it allows us to use a series of mathematical equations to help us interpret that mixture.
Mm-hmm.
Was that done in this case as well?
Yes, and then we use that same program to run the statistics.
Now, with regard to the sample, the buccal sample attributed from Uri Buchanan, did you run that for a comparison as well?
Yes.
And what, if anything, were your findings in relation to your analysis of that?
So in that case, assuming a mixture of 3 individuals, the DNA profile obtained is at least 46 million times more likely to be observed if it originated from 3 unknown, unrelated individuals than if from Uri Buchanan and 2 unknown, unrelated individuals. So that sounds confusing given what I just said. So the verbal qualifier for that would be very strong support for exclusion.
I'm sorry, very strong support for exclusion, is that correct?
Correct.
And then similarly, as you were testifying, what, if anything, did you find from your analysis comparison of the buccal sample or DNA profile from Michael Proctor?
Yes, so in that case, assuming a mixture of 3 individuals, it is at least 76,000 times more likely to be observed from 3 unknown unrelated individuals than if from Michael Proctor and 2 unknown unrelated individuals. So that would be strong support for exclusion.
So correct me if I'm wrong, but your findings with regard to the 3 samples is strong inclusion or strong support for inclusion of John O'Keefe, is that correct?
It would be very strong support for inclusion.
And strong support for exclusion of both Uri Buchanan and Michael Proctor, correct?
Correct.
Now, sir, in addition to that, you had mentioned that there was an E01 sample that was shaft end of a hair from the exterior passenger side rear panel of that same vehicle with the same Massachusetts license plate, correct?
Correct.
Now, with regard to DNA as it pertains to hair samples, can you describe for the jury sort of that process and so what is it that you're looking when you receive a hair sample as far as an extraction is concerned? How does that process work, or what are you getting that extraction from?
Yes, so when we have a hair, generally we'll take a look at it, and a forensic biologist will give their opinion on if it's likely that we'll obtain a profile from that hair, because hairs can be a little tricky. So in this case, The forensic biologist determined that the hair would likely not provide a great profile from STR testing, but we went ahead with it anyway, just because sometimes it does work. But in this case, we extract it, and that involves dissolving the hair and forming an extract like the other samples. And then we quantified the hair in this case, and the quantification that I used targets what is called autosomal DNA or nuclear DNA. And in that case, the results were below the limit of detection. So we did not process that sample forward for STRs because we would not have obtained a useful DNA profile from it.
Sir, if I could just take you back a little bit in that. Earlier in your statement right there, you just indicated that hair samples or DNA from hair can be a little tricky. Can you expound upon that and explain to the jury sort of what you mean by that?
Yes. A lot of times, hairs are, unless they have a root attached, they're not a great sample for nuclear STR testing. They can be, but it's sometimes hit or miss.
As far as what's actually being tested as far as STR when it comes to hair, it's not the actual hair, is that correct?
I'm not sure I follow. Can you?
Let me ask you this. You're familiar with the term follicular tissue?
Yes.
Can you explain to the jury what that means in relation to a hair sample and DNA testing?
Yes. So when there's a follicle attached, that's generally where you will get the nuclear DNA from, not the hair itself.
And the follicle would necessarily be attached to the root end and not to the shaft, correct?
Correct.
Now, as far as autosomal DNA, can you explain what is autosomal DNA and sort of where does that come from within DNA testing?
Yeah, so you can think about that more as nuclear DNA. So that would be DNA that's in the nucleus of the cell. So that's what most people think of when they think of DNA. But there are there's other forms of DNA. So like, for example, mitochondrial DNA that exists outside the nucleus.
And as far as the testing that you performed in regard to this hair sample, that was STR testing, is that correct?
Yes.
And I'm sorry, what were the findings again with relation to the STR test?
Yes, so like I said, we quantified
enough.
the hair and it was below the limit of detection. So we did not process that hair forward for STR.
Now, as far as that terminology, below the limit of detection, can you explain a little bit to the jury sort of what that means as it applies to...
How much of the hair did you dissolve for this?
Yes, so the instrumentation has a limit of detection. So there could be potentially small amounts of DNA there, but it's below the limit that we are confident to say that there is DNA present. So we would normally not process those samples forward.
Now, that hair sample, as far as the one that you tested, you mentioned that it was not initially advisable, I guess, for STR testing, and you just went ahead and did it anyway, because sometimes it works. Is that correct?
Yes, it's usually worth a try.
And then beyond that, that hair sample within your lab, as far as Bodhi Technology, was that given to a different analyst for a different type of testing?
Yes, we decided it was worth a try to do mitochondrial DNA testing on the hair.
And is that a type of testing that you yourself perform?
No, that would not be me.
And why would it not be?
I was not trained in mitochondrial testing.
That's sort of a specialized subset as far as different training and different type of testing that occurs?
Yes.
Just in general terms, if you know, could you explain to the jury sort of the difference between what you've termed as nuclear or autosomal DNA versus mitochondrial DNA?
Yes, so very basically, the nuclear DNA is the DNA that exists in the nucleus. The mitochondrial DNA is the DNA that exists outside the nucleus in the mitochondria. And the mitochondrial DNA is inherited directly from the mother. So if you were to test maternally related individuals, they would have the same mitochondrial profile.
And that other analyst that conducted the mitochondrial DNA, you familiar with who that person is?
Yes, that was test chart.
Okay, one moment, Sean.
Sure.
And we're going to go to lunch.
Thank you very much, sir. I have no further questions.
Okay,
We have no questions.
great. So you are all set, Mr. Bradford?
Thank you.
Thank you very much.
Okay, so jurors, we will take our luncheon break and we'll have more witnesses here for you this afternoon. So let's say 40, 45 minutes.
All rise to the court, please.
Your Honor, may we approach the speaker?
Sure.
Counsel, follow me.
Give me a second here, guys. I'm going to pop out and pop right back because okay. Am I back? Something was glitching there. It was being super weird. Wasn't letting me come back. But I think I'm back now. Can you guys hear me okay? Am I here? Yay. Hello. Thank you. Glad to be back. Glad we didn't lose the whole stream here. Well, so now we are on lunch. Let me go ahead and get my banner updated here. Let's talk about some of this DNA stuff, guys. Let's talk about it. Okay, a mixture of 3 is a mess. This is a messy profile, very, very messy profile. Whenever you have a mixture, you start having to get into assumptions about who contributed how much and so forth to the mixture. So there is much, 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 much more subjectivity and just judgment that goes into interpreting a mixed profile than there is interpreting just a straightforward single source profile. When he describes what they're doing with the short tandem repeats, I'm gonna try to explain very quickly how these statistics work and what they mean. So conventionally, you were looking at 13 different points on a DNA genome, where what happens is the code, it stutters. And these are places where this is not coding information. This doesn't give information to your body about how to generate proteins. It's just basically what's considered, kind of excess genetic data. We don't really know what it does or why it's there. But so it stutters. It's like it skips like a record. And so what they do is they count the number of skips at each given point. I believe that the FBI at least is up to looking at 20 locus points now where there are short tandem repeats, these stutters that take place. So they have then figured out from just different database studies where, all across the world, people have databases for collecting genetic information from people who have been convicted of crimes, from unidentified human remains and things like that. And from that, they have ascertained out in the world how many different variations of these stutters have we observed throughout these databases. So At this, first location, for example, we might have observed from 1 to 10. You see 1 repeat versus up to 10 repeats, or you might see sometimes it skips 3 times, sometimes it skips 7 times. There's a fixed number of times that they have observed the repeat at each particular location. That is what this statistic is based off of. When they tell you 1 in a, however, astronomically large number with however many zeros we want to put behind it, probability calculation. What they are saying is that if a human genome existed in a vacuum, if you had all of these combinations of the STRs and it existed in a vacuum, and you were able to shake those up like a bingo container and roll out a human genome, what is the probability that you would get this exact combination? And so it's not actually a complicated math problem. It's just 1 in 10 likelihood for sample number 1, where we said there's 10 possible repeats. So that first one would be 1 in 10. The second one, maybe there's 15 possible repeats. So it would be 1 in 15. You do this over, depending on which standard they're applying, 13 or 20 different locations, then what you're doing is you're multiplying, 1 by 10 times 1 by 20 times 1 by, however many repeats there are at each location. So that's how you get to pretty astronomically large numbers pretty quickly. And then the idea is, the larger the number is, the more it indicates there are that the person's profile that you're looking at is matching the number of repeats that are being seen in this sample that you're comparing it to. So the problem with this from kind of a usefulness standpoint is that it is a vacuum. It is a vacuum-based statistic. That's why they say compared to unrelated individuals, somebody who shares no DNA whatsoever, a universe that is empty of people that share similar genetic profiles. And of course, that is not reflective of the real world, because in the real world, people are related. And the way that genes get passed down, by generation through decisions, to mate with each other and combine genes into offspring that share various amounts of that DNA. Of course, people share like over 99% of all their DNA, but between each other, I mean, we share something like 99%, 98 or 99% of our DNA with chimpanzees. So the points where these individual differences can be identified are pretty specific. And so these STR ones are used for a couple reasons. One, because they don't contain coding information. This is very important from the Supreme Court privacy standpoint, when they're looking at, like, is this the kind of intrusion into people's privacy that we're okay with? One of the things that they took into consideration was it doesn't include personal, private things like medical information or ancestry or things like that. Doesn't give you that type of information about somebody. It's literally just good for identification, because we don't know what else these STRs do within the genetic profile. So that's very different from what we've been looking at in Koberger with the genetic genealogy and the SNP testing. That is getting into that personal identifying information, which is fascinating from a legal standpoint, but I am not going to digress into that. We're focusing on the STRs. So the problem is that people share a massive amount of that DNA, and people out in the world are related. And so you expect in a real world type of simulation that there is a certain prevalence of these STR repeats. We know that they exist, and that's the math is done based on we've observed that it exists, but we don't actually know how prevalent they are. We don't know if, at location 1, is that something that 20% of the population shares? Is that something that 80% of the population shares? And that could potentially make a really big difference when it comes down to putting a meaningful sort of real world number to what these statistical calculations mean, because telling you, how likelihood it is to generate this genetic profile in a vacuum doesn't give you helpful information about how likely is it that you will find this genetic sample randomly throughout the existing population in the world. That is not the information that this statistic gives you, and yet people often misconstrue it as that, misunderstand it as that. Prosecutors will occasionally argue that. We're going to be keeping a very close eye on you, Mr. Lally, and what sort of claims are you going to make about this SDR profile? Some other concerns that I have with this testing: the extract was provided to them from the MSP Crime Lab. Okay, well, we're going to learn more about that from the MSP Crime Lab when we get to it. But here's the concern that I have: quantity and source. So typically with testing for DNA or something like that, the first thing you're going to do is you're going to use a test to try to look for biological evidence. You're going to use a test that will detect the presence of blood, saliva, semen, something like that. See if there is a biological source for something on that item. If there's not that, good chance we're talking about trace DNA. And quantity is also a very good indicator of whether you're dealing with something like blood, semen, very high quality, rich source of DNA versus trace DNA. Trace DNA is everywhere. It's everywhere. Cooties are real. In that sense, that our DNA, it is like suspended in the air all around us. Just there have been starting to be now tons and tons of studies about this. Not so much in the United States. We haven't been that interested in it for some reason. A lot of this study is going on in Australia. But these studies are revealing that trace DNA, it's kind of like we have an aura, kind of like we have an aura. We move around, and the actual, physical edge of our bodies on our skin, that's not at all where our DNA ends. Our DNA is like a cloud around us pretty much at all times. And so because of this, trace DNA is very easily transferred. It's very easily, left in a certain location. There's no real way to give it attribution as far as how did it get deposited there. Studies have shown you can be having a conversation with somebody in the same room, no physical contact whatsoever. You will walk out, their DNA will be on you, your DNA will be on them. And not only that, but the DNA of the people that are on you that you walked in with, that'll get transferred around too. It's a big genetic soup. When you're talking about trace DNA, this is just very low quality evidence in terms of being able to establish proximity to an item or contact with an item or something like that. Often gets miscalled touch DNA. It's not touch DNA. It is not an indication that somebody touched a thing. It could be, somebody could have touched it, but it is absolutely not necessary to have physical contact, direct physical contact with an item in order for your trace DNA to be deposited on it. So this is a big deal in the Koberger case. If you haven't followed my stuff on that, I go into a lot more detail about this kind of thing there. And I've been meaning to do more because that's the biggest question I get about that case. All right, Andrea, if the pings fall apart, what about the DNA? Doesn't that have him nailed? Small amount of trace DNA on the knife sheath does not give you very good information about why it's there, how it got there. So I'm going to have questions about this extract from the Massachusetts State Police Lab. Did they test for biological samples? Because if John's blood is there, if John's sweat is there, if John's saliva is there, that is a much better indicator of how that DNA got there than if just it's some random trace DNA, which you would kind of expect to be all over the car. By the way, not just from John, but also his niece and nephew, anybody else who rides in that car, Karen, all of those people. I keep coming back to all those people that were milling about in the Sally Port. Okay, they wanted to rule out Proctor and Yuri because they're probably trying to They're probably trying to rule out some like touch DNA theory that the mixture came from them in the course of trying to plant the taillight evidence or something like that. But that's not really valid. It's really not, because not only, okay, you can put on your gloves. I mean, we've seen they know how to put on the gloves to do something like that. Doesn't rule out that they touched it. Absence of evidence is not evidence of absence. But also you haven't ruled out all the other people that were potentially contributors to that DNA sample. We saw all of them in the video. We know the cars team was there looking at the car. We know that Maureen Hartnett was there. We know that everybody in the crime lab that touched this plastic, was messing around with the plastic. Everybody who collected it from the scene, everybody involved in the SERT search, everybody involved in the packaging and the documentation. All of these people are potential contributors to that sample. So at least in terms of if we're trying to identify what is the most likely configuration of people to create this 3-person mixture, and if it includes any of the law enforcement officers, we haven't even come close to ruling that out. So yeah, okay. Sounds like maybe there's some trace DNA from John on the taillight. Like, who cares? Who cares? Three unknown individuals, 2 others, at least 1 male. So that could mean 2 females, could mean Karen, could mean Jen, could mean Denise, could mean any of those people. We don't know. And that would all make sense with these are people who regularly ride in this vehicle, are in the garage where this vehicle is stored. None of this is an indication of, John's DNA is on the taillight because the taillight struck him in the head on this accident. That is not a conclusion that anybody is going to be able to draw from this particular evidence. So then we get into the mitochondrial DNA testing. Don't know where that's going to go yet. Don't know where that's going to go. But John's niece and nephew, they're going to share a mitochondrial DNA profile with John through their maternal grandmother, John's mother, who is also the mother of John's sister, who is the mother of John's children, or of her children, of John's niece and nephew. They're going to have the same mitochondrial DNA profile. So even if this is able to be a match, which I don't know, we'll see. Even if this is able to be a match, it's not going to establish that it's John's hair. And there's just mitochondrial DNA. It is a much more specialized type of test. Just different process, different statistics, things like that go into it. So what I've seen so far from these results through the discovery stuff is just that it's consistent. Well, consistent just means you can't rule out, and not being able to rule out doesn't really tell you anything unless you know how likely it is you should be able to rule that person out. And I don't know if any of that information is available. So we're going to have to wait and see what we get with the mitochondrial. But yeah, the mystery hair, the hair that somehow clung to that car through the miles on the toe, and the blizzard conditions and the heavy wind and the feet of snow. Yeah, well, we'll see what we get out of that. Guys, I am going to take my quick break right now. I do have to check on some stuff. It's already up to 71 degrees. I got to check the trees. I didn't water them this morning, so they're probably getting a little thirsty, and grab myself something quick to eat. So I will be back after that. We'll get back into your chats and see what kind of questions and stuff, observations you guys have had. Fun stuff in the chat this morning, guys. I always enjoy when I get to kind of peek over and see what's going on. So I've enjoyed it a lot. Appreciate your contributions, and I will be right back, guys. Okay, guys, I am back. Trying not to jump scare. Well, that took me a little bit longer than usual today, guys. Sorry about that. Had a lot of things to kind of have to sort out in my little moment of free time. But I did want to try to get back in time to take a look at some of your comments and chats because I'm not sure how long we're getting for lunch today. And like to try to stay timely on stuff as much as I can. So Christina Jarvis says, thank you for the great coverage. Your hair is on point today, by the way. Well, thank you so much. I do occasionally work a little curling iron. Does happen from time to time. So thank you for that. Appreciate it. John Duncan, would have been better for Proctor. This is where we started. Would it have been better for Proctor to plead the fifth for the prosecution? Less of a disaster. There was no way for them to get around the jury wondering why he would do that, right? Why is he not here? Why is he not testifying? There's sort of two pieces to this. One would be, does he plead in front of the jury or does he just not get called? Normally, it's not preferred for a witness to invoke the fifth in front of the jury, but it does happen sometimes. We've seen it. It just happened in the Young Thug trial not that long ago. I told a little war story of my own, not too many streams back, where the witness invoked in the presence of the jury. So it does happen, and if that happens, then at least the jury knows why they're not getting an answer. But then they're absolutely going to be like, so exactly what crime are you worried about getting caught for having committed here? It's just a very damaging thing for them to know. But is that better than not knowing at all if he just doesn't get called? And then the jury is left there to wonder, the lead investigator, why is he not participating in this case? You've heard so much about him and the stuff that he did and the role that he played. I don't know how you don't give the jury that explanation. And then, the final problem here is that he's a link in the chain of custody for so many of these items, for John's phone, for the plastic pieces that went into that taillight reconstruction and so forth. So it's kind of hard for him not to be there. Kind of hard. Potentially affects, the ability of that evidence to have enough of a foundation to be able to come in. So, I mean, I personally, I don't think the prosecution really had much of a choice here. I think they had to. From their standpoint, yeah, I think this was still better, even though he looks like trash. Not clear that the defense couldn't have got it in any way. His text out of court are hearsay, but there's all kinds of exception to the hearsay rule. And state of mind, effect on a person's state of mind. You're not there to show the statements themselves are true. You're there to show the bias of the investigator who was running it and his antipathy towards the subject of his investigation. It doesn't matter if Karen Reed actually has a leaky balloon knot. That's not why we're putting him on. So the text wouldn't be admitted for the truth of the matter asserted anyway. They're not hearsay for that particular purpose. So I don't know that it would, if they didn't call him, that it would save them from that evidence coming in anyway. So given that, I don't think they really had any choice. They had to put him on the stand. Now, is it better? Would it have been better for him personally to take the fifth? Well, that will remain to be seen, won't it? Hard to imagine his attorney not counseling him to do that. Hard to imagine that. American Dreamer, appreciate you. Thank you. I appreciate all of you. I really appreciate you guys being here, sharing this experience of this trial with me. Timothy Torigian, Andrea, can you kindly instruct my wife, Allie, to get back to work? Love your content despite you being an obnoxious Philly sports ball fan. Hashtag FKR. Allie, get back to work. There you go. I know work is a relative thing, right? Allie could be a very effective multitasker. I'm not going to tell Allie you can't be at work and also watching the Karen Reed trial. Just speaking from personal experience, written a few briefs with some stuff going on in the background. And as far as being an obnoxious Philly sports ball fan, is there another kind of Philly sports ball fan? You know, I just, you know, you gotta lean into the culture of your team. It's just how it is. Rhonda, Iowa girl. There had to be eye rolling from the jury connecting that one piece of clear plastic with obvious claw or bite marks. I mean, they didn't let him go there, right? Bev actually found a limit to what she will allow a law enforcement officer to testify to about what he thinks caused injuries, you know? So he didn't actually get to go there, but yeah, he was all ready to offer a blunt force explanation for John's arm. Yeah. Very properly sustained objection. He's so clearly not the guy to be offering that yes, of course the jury is rolling their eye. There's a reason why the medical examiner didn't agree with your theory of the case. Okay, you had every opportunity to present your theory of the blunt force causing the marks, right? And she could adopt that. Oh yes, these bolts under the undercarriage absolutely could have. In fact, that changes my determination that yes, he probably was killed by the car. That makes it a homicide. Yeah, none of that happened. None of that happened. So we'll get that info from the medical examiner where it belongs. We'll get it from defense biomechanical people where it belongs. And I suspect the jury will appreciate that more than they will appreciate these efforts to try to shoehorn some opinion on guilt under the guise of being somehow based in experience or science or something like that from these law enforcement officers. Britt Cormier, modern Lexus Plus, her smartphone should be super easy to figure out her movements with electronic devices, should not have to do any guessing. Yeah, if they're relying on ping data, it's you need to explain to me why the GPS didn't work, because in this day and age, yes, GPS is going to be available. It's going to be way better than ping data, particularly this hit off of a single tower type of stuff. It is the lowest quality cell site location information that you can really get. So I have to think there's a reason why they're not using GPS, and it makes me wonder if the defense is going to be using GPS. Nicola Maxwell. Thank you, Andrea. You're so smart, but make this easy to understand. I appreciate your hard work. 100K subs by July 1st, calling it love from Scotland. Well, thank you so much. Thank you for your support. I appreciate it. That's just kind of my goal, is to try to make things accessible. I've had to learn so much of this stuff, like DNA stuff and cell tower stuff, you know, so much on my own, and put it into terms that I understand. I didn't study any of this stuff in college. I didn't even take science in college. I went to a school that you had to take like either one science or one math. And I took genes, genetic engineering, and society. It was, basically a class about Monsanto, you know, Roundup Ready wheat was like kind of the new thing at that point in time. That was my science background. I've had a lot of catching up to do since then. And I fortunately have a husband who is very well educated on a lot of this kind of stuff and very smart and enjoys filling me in on these gaps. I love picking his brain about things like electromagnetics. I've learned pretty much everything I know about how electromagnetics work from Jeff. So I've had to learn it for myself in ways that I can understand, and then in ways that I can communicate to a jury. So appreciate your feedback. I'm glad to know that you're finding that helpful. It means I'm doing something right here. Steve F. Lally's pathetic attempts to get Tully to give medical forensic testimony are the agonal gasps of a dead case. Yeah. Wonder if he even knows what an agonal gasp is. Yeah, he does. He does. But that would be kind of funny to ask. Fighting Usyk, all grass at that time. This is that library video at 12:30. All grass. No snow accumulated on that grass. Nothing like that. So court is back, guys. And let's go ahead and bring it up. I think she's still quiet.
All right, Mr. Lally, your next witness, please.
Yes, Your Honor.
Commonwealth call Ms. Tess Sharps is there.
Why this isn't full screen? Try that again. Okay. The audio, you're saying audio's low. Let me try something else here, guys.
Sure, my name is Tess Sharp. I'm a forensic DNA analyst at ADA Technology.
I'm going to switch to a different screen, guys. I think this is going back to when it was being annoying before. Okay. Sorry, let me get her sound on.
What, if any, degree did you receive in relation to your undergraduate?
Sure, I have my bachelor's in science in molecular biology from Millersville University in Pennsylvania. And then I have my master's of science in forensic science from Towson University in Maryland.
So, Ms. Chard, I'm going to ask you to keep your voice up really loud, okay? Thank you.
Ms. Sharp, if it's at all helpful, that microphone is adjustable. You can move it anywhere. Now, with reference to your master's in forensic science, when about was that you received?
So I got my degree at the end of 2019.
And following grad school, where did you go from there?
I was hired directly by ADA Technology.
And when was that?
That was in July of 2019.
Now, when you started in July of 2019 with ADA Technology, what was your position at that time, and sort of what were your duties and responsibilities when you initially began work?
So I started as a technologist. So that's someone that will do all of the lab portion of the work in a laboratory. And I helped out with our humanitarian team, so helping identify human remains. From there, I also helped with our criminal cases as well.
And when you started your work there, what, if any, sort of training did you undergo in relation to your work at ADA?
So when you first start at ADA Technology, you actually go through a series of lectures and you have a series of readings to go through all of the science that you're going to learn and the background of all of the technologies you're going to use. From there, you will observe a qualified analyst or a qualified person in the lab, go through everything that you're going to be trained in. And from there, you'll get a series of sets. So there'll be mock samples that you will take through the lab and do all of the testing on that you're going to be trained in. And it starts out with having that qualified analyst there with you, and you're able to ask questions and troubleshoot as you go. From there, you'll get a second set that'll be no analyst with you, but you're still allowed to ask questions at that point. And then your final set is something that we call a competency set. So you take it through the lab and treat it just like you would any other case. And you're not allowed to ask questions, and then you're graded at the end. If you pass that test, you can go through a written exam and then a verbal exam. And then you take your results from your testing and you defend it in a mock court sample. If you pass all of those qualifications, you can become an analyst or become qualified in whatever lab technique you're being trained in.
And as far as that sort of training process went, how long was it from the time that you joined ADA Technology to the time that you started doing the work that you do now?
It's been a rolling process of all the different trainings that I've had to go through. I'd say it took me about 9 months from when I started to be qualified in everything that I do for mitochondrial DNA testing. And then for analysis training, I think it was another 6 months or so.
Chart is kind of a
As far
funny name for a
as
scientist.
The lab at Bodie
You got her for a
Technology, is
nurse,
that
but
an accredited lab?
not bad.
Yes, it is.
And do you know from whom the lab receives its accreditation?
Yes, we receive
So we need to repeat all this again.
International accreditation from an
Lally
association
really
called
wants us
ANAB,
in our post-lunch
which is just
lull.
a national standards organization. We're also accredited by the FBI at their quality standards as well.
If you could just keep your voice up.
Would you like me to repeat that? Okay.
Ms. Chart, as far as your lab being accredited, can you explain to the jury sort of what that means, sort of what the process is for a lab to be accredited?
Sure. So all of our testing, all of the things that we report are basically guidelined by an outside body. So everything we do is established and gone through before or as we go through the testing procedures. So we're able to make sure that everything that we do is standardized for the country, all the testing that we perform.
And the lab that you work at Bodie Technology, is that accreditation up to grade at this point?
It is.
Yes, we know.
Now, with
We've
reference
already
to
been
your own
told
work
that.
within the lab, is there sort of standards of procedure or protocols that you follow in conformity with that accreditation?
There are. We're under the same standards as all other DNA testing at Bodie for mitochondrial DNA testing.
Now, with regard to your specific work, are you familiar with what's called a proficiency test?
Yes, I am.
Explain to the jury what that is.
She wasn't. I thought she was talking about
What your
proficiency tests
experience
before
has
when
been
she was
with
going on and on and
proficiency testing
on.
as far as how
She was just
often
talking about basic qualification.
So a proficiency
my
test
Lord.
is how we stay qualified in what we do in the laboratory.
I don't see it.
So we get an outside test
I don't
that
see
we
it.
treat just like a
I'm gonna drown in
regular
some more,
criminal case. We
some
take it
more
all the way through
forensic
the
science
laboratory
people.
and have it reviewed, report our findings, and then it's sent out and we're graded on that performance.
And with reference to yourself, what, if any, issues have you had with regard to proficiency testing over the course of your years of work with Bodie Technology?
I've had none.
Now, as far as, am I correct in that Bodie Technology, as far as the lab is concerned, essentially deals with being contracted for
The Lally
external
Lull.
vendors?
Yes.
By that, I mean as far as you get your work or samples that are submitted from outside of your lab, correct?
We do.
And what are some of the types of organizations that, as far as the casework that you deal with, like where does it typically come from? What type of agents?
It can come from anywhere across the United States, and we also have international clients as well.
Now, if I could turn your attention to a specific case that you worked on. When items come into Bodie Technology, as far as the lab, they go through sort of a check-in process and a chain of custody process. Is that correct?
Yes, that's correct.
And with that, is there sort of a number or something that's assigned to a specific sample that follows it throughout the time that it's at your lab?
Yes, we'll call that the evidence item number, or E- whatever number it's assigned.
Is there also a case number that's assigned as far as different cases or different case submissions?
Yes, there is.
And turning your attention to a specific case that was submitted in January or partially submitted in January and then partially submitted in March of 2024. That came from the Norfolk District Attorney's Office. Are you familiar with that?
Yes, I am.
And the Bodie case number on that was CCA 2416-0023. Is that correct?
That is correct.
Now walk us through the entire
Now,
science
with
of
reference
mitochondrial
to
DNA again, because we didn't
your
hear
work
enough from the first
on this
guy.
specific case number. What were the items that you received and sort
Make
of
sure
what,
to revisit the
what were
chain
the
of
items that you
custody and the
received that you
secure evidence
eventually did
room
some
and how they
testing
get
or
there by
analysis?
FedEx and yada yada.
So I continued testing for one of the hair samples.
And specifically, again, that's given a specific name as far as in the hair sample in this case was EO1, is that correct?
That is correct.
And then as far as for comparison purposes, what, if anything, did you receive in regard to comparison if you were able to generate a profile from EO1?
we received a reference profile from the victim, John O'Keefe.
Now, your specialty within the lab is mitochondrial DNA testing, is that correct?
Yes.
Could you explain to the jury, as far as mitochondrial DNA, let me ask you this first.
My audio is
Are you
low.
also
Let
familiar
me
with the term
try to
known as
adjust
autosomal
it.
DNA?
I am, yes.
If you could, Ms. Chart, explain to the jury
Well, that's because
first
it
what
reset
autosomal
my
DNA
settings
is,
after it started
and then what
acting weird and
mitochondrial
boosted
DNA
me
is,
off.
and then I'll
So
have another question.
Of course. So
hopefully
what
that's
many
a little
people
better.
are familiar with is what we call autosomal DNA.
Yes, we
so
need
that's
to
the
revisit
DNA that's
autosomal
actually
versus
stored in the
mitochondrial.
nucleus of your cell. You get half from your mother and half from your father, and it's what makes you unique. And it's what people call the blueprint of a person. But what might be a new concept is that there's actually a second form of DNA that is stored within the mitochondria of a DNA of a cell. So if you can remember maybe back to any science classes that you had, the mitochondria is the powerhouse of that cell.
The powerhouse
and
of the cell.
Because of
Isn't that
that,
like a
you can have
Schoolhouse
upwards
Rocks or
of
something about
hundreds to thousands of mitochondria within just one single cell. And within each of those mitochondria, you may have thousands of copies of that mitochondrial DNA. So in cases just like this one, where there may not be enough nuclear or autosomal DNA to find, you can go back and try to test for that mitochondrial DNA.
And so if you could explain to the jury some, I think you've alluded to it already, but sort of the difference between autosomal DNA versus mitochondria.
So mitochondrial DNA, in contrast, is inherited directly from your mother. So you will have the same mitochondrial DNA profile as your mother, and then you will also have the same mitochondrial DNA profile as any of your siblings. And it has that maternal inheritance that we call it, that makes it actually a great source for helping identify people, but it can also be used for criminal cases as well.
Used to identify the Romanovs.
First, with respect to the autosomal DNA, can you explain to the jury sort of the process as far as, just in general terms, what is the process as far as the testing goes or generation of profile?
Sure, so we share similar processing methods. So we will start out by taking a small portion of whatever is sent to the lab, and we'll call that sampling. We'll take notes on that and how much that we take forward through testing, and that will go into a small tube. From there, we will extract the DNA or take apart all of the cells by adding chemicals. And what we're left with is what we call a DNA extract. Mm-hmm. So that's actually where I came in this case. From there, the difference is we will go through what is still called amplification using the PCR method. That will make a bunch of copies of that DNA to be used later on. But for mitochondrial DNA, what we're targeting is specifically just the mitochondrial DNA in that extract. From there, we actually go to something that is completely different from autosomal testing, which is DNA sequencing. So DNA sequencing is really just a way that we're able to take those small strands of DNA that we've amplified, and we're able to read them almost like letters in a sentence.
Yeah, so this is not the STR type of comparison like they do with autosomal.
It's for both methods.
What does PCR stand for?
It's a polymerase chain reaction.
And when you say as far as
little smirk when she said that,
the sort of quantification, I'm sorry, is it quantification or quantitation?
Quantification works.
As far as the quantification step is concerned, how is that sort of physically done? What kind of instrumentality are you using to accomplish?
So for mitochondrial DNA, we will actually run the DNA after amplification on a gel, so a long, really what it sounds like, slab of gel, where we're able to visualize if we obtained any mitochondrial DNA as a band that shows up under a camera.
So with reference to this sample, this EO1, the hair sample, you received it at what stage again, or what step?
I received it as a DNA extract, so it was a amount of liquid in a tube at that point.
And as far as, in general terms, again, if you could explain to the jury, so what are the steps that go into the processing or analysis prior to that step where you received it on the quantifications?
So it went through sampling, it was received, it was inventoried by the person that opened up the evidence, and a small portion or the hair was put into a tube. And then it went through that DNA extraction. So the hair was dissolved and all of the DNA inside of that hair was released and isolated to just be then that DNA extract.
So from that point where you pick it up as sort of the extract, what is it that you're doing with that as far as your analysis goes from there, and what type of instrumentality are you using to perform that analysis?
So from there, I am targeting and just trying to find if there is any mitochondrial DNA in that sample. So we'll use the PCR method to amplify to see if there is any mitochondrial DNA we can target. And then I will take it through and visualize it on that gel to make sure to see if we got anything. That is our quantification step. And then after that, I will take it through our sequencing step. And we do load that on an instrument called the 3130 genetic analyzer.
And the 3130 genetic analyzer, how does that work?
So it actually runs and separates each of the fragments of DNA that we have amplified and visualizes it through a program. So we're able to read each letter of your DNA sequence.
I could take you back just a step. Are you familiar with a term within your field called a D-loop?
Yes.
Can you explain to the jury what a D-loop is and how that factors into your analysis testing for mitochondria?
So the D-loop is actually the region of the mitochondrial genome that we target. It is targeted because it does not contain any useful areas for the actual function of a mitochondria. So it can change over time, and those changes are what actually are recorded as your mitochondrial DNA profile.
Now, as far as the D-loop, what, if any, relationship does that have with respect to certain variables within the human population?
Would you be able to word that?
Very poorly. Let me rephrase. The D-loop, as far as the region is concerned, what, if anything, does that have to do with certain variabilities within the human population?
Oh, yes. So because there is this variability in that region, it can change over time. And from that, there are different mitochondrial DNA profiles that are developed across the world.
Now, in addition to the extract from the hair sample EO1, what, if any, other items did you receive in regards to?
Nothing to do with race, by the way.
So we also received that reference sample from
Recent
the victim,
geographic origin,
and that was taken forward for mitochondrial DNA testing as well.
And just for clarity purposes, when you say reference sample from the victim, you're referring to John O'Keefe, is that correct?
Yes.
And the reference sample that you received in regards to John O'Keefe, was that already an extract as well, or what, if anything, did you have to do with that in order to obtain a mitochondrial DNA profile?
So that sample was received, if I can refer to my notes. I did not.
This chat is so awesome. Okay, so
I was
explain
not
this
the
to me,
person
Quokka, because
to
I thought
actually do the
mitochondrial
sampling for
DNA
this
was not
sample.
a double-stranded double helix. It looks more like bacterial DNA or something like that. It's like looped strands or something.
It was received as a small cutting of a swab.
And so, as far as the small cutting from the swab, what is sort of, as far as creating a profile from that, creating a profile from the extract from the hair sample as well. Was there any difference in sort of how those two mitochondrial DNA profiles were created?
No,
There we
they were
have it.
tested the same way.
And well, let me ask this. As far as with regard to the hair sample EO1, were you
Arguable.
able to obtain a mitochondrial DNA profile for the hair?
We were.
And with respect to Mr. O'Keefe's sample, were you also able to obtain a mitochondrial DNA profile from Mr. O'Keefe's sample?
Yes, we were.
Now, as far as for comparison purposes, what, if anything, did you look at, and what, if any, comparison or opinions or conclusions did you draw from that comparative analysis?
Sure, I can state directly from my report if that's all right.
Okay.
So the mitochondrial DNA profile that was obtained from the sample, the hair sample, was consistent with the mitochondrial DNA profile obtained from John O'Keefe. So therefore, John O'Keefe cannot be excluded as a possible contributor of that hair.
Now, Ms. Chart, are you also
Well, that's
familiar
not
with
very
something
certain,
called
is it?
MPOP, and for the record, that's EM.
How many white men of
I
recent
am.
European
Can you explain to the
ancestry,
jury,
recent
what
European
that is
origin?
and how that's used as far as any sort
would be
of
included?
statistical analysis in reference to comparative comparison?
So it's a international populations database that houses different mitochondrial DNA profiles.
And how is it sort of used within your field, and how did you use it in this specific instance in relation to the consistency opinion between the hair sample and Mr. O'Keefe's?
So we were able to upload the profile from the hair and see if it was found at all within the population database. We test populations that are popular within the United States to narrow it down, and within the African American, US Caucasian, and US Hispanic databases that they have, it was not seen.
And what, if any, conclusions or opinions are you then able to formulate?
So it wasn't a white
with
person's
reference
hair.
to, the consistency of the hair
Is that
sample
what he just said?
versus Mr. O'Keefe's sample with relation to that MPOP data?
Sure, so by not seeing it in the database, this means that we're able to exclude at least 99.895% of the population from being a source of that evidence.
And is there a certain level or percentage of confidence statistically that comes along with that exclusion of 99.895% of the U.S. population?
Yes, we use what is called the 95% confidence interval. It's actually a rule that is used for making statistical statements about populations. It's because there are always outliers that we don't include. We take the 95% majority of a population when we run those statistics.
And so, again, as far as your opinion or conclusions based on the comparison, is that the mitochondrial DNA profile from the hair sample was consistent with the mitochondrial DNA profile from Mr. O'Keefe's, correct?
Correct.
And that's with a 95% confidence, is that correct?
That is correct.
And that's the exclusion of at least 99.895% of the population of the United States, correct?
Correct.
Thank you, ma'am. I have nothing further.
We have no questions, Your Honor.
Okay.
You are awesome. Thank you very much.
Thank you, Your Honor.
Your next witness, Mr. Lally?
Yes, Your Honor. The Commonwealth call Mr. Andre Porto to the stand.
So yeah, he's another crime lab guy. I'm just doing some quick math here. No, that's 12. Okay, I gotta do this over. Hang on, let me move my calculator.
Look right this way. Just watch your step.
Raise your right hand. You solemnly swear the evidence you give the court and jury in the case down here and the truth, the whole truth, and nothing but the truth, so help you God. You can take a seat.
Whenever you're ready, Mr. Lally.
Porto. P-O-R-T-O.
Good afternoon.
Good afternoon.
First, let me just say that, just for clarification, that microphone in front of you is adjustable. You can move it up and
Okay,
down.
cool.
Good afternoon, sir. Could you please state your name and spell your last name?
Yeah, my name is Andre Porto, last name spelled Porto.
And what do you do for work, sir?
I'm a forensic scientist too at the Massachusetts State Police Crime Lab in the DNA unit.
And sir, if I could ask you just a few questions about your educational background, starting with your undergraduate work. Where did you go to school and what, if any, degrees did you receive?
I received a Bachelor of Science in Microbiology at the University of Massachusetts in Amherst. And then,
And where did you go from there?
I went to the Boston University School of Medicine and I got a Master of Science in Biomedical Forensic Sciences.
And about what year was that you received that master's?
I graduated 2019.
And then following receipt of your master's, where did you go?
I went to the DNA unit in the Massachusetts State Police Crime Lab.
And when you joined the Massachusetts State Police Crime Lab initially, what was your title and sort of what was your duties and responsibilities with relation to that time?
So I joined as a Forensic Scientist 1, and that's a training position where I underwent a training program that consisted of a bibliography with multiple journal articles and textbooks, as well as conducting the lab processing on training samples.
So I just did the math.
And that sort of
And if
initial work that you did as
99.895% of the
FS1,
population
is
is,
that correct?
is
And
excluded,
that initial work that
that
you
means
did as an FS1, how long
approximately
did you do that before you
0.001% of the
became
population is included.
Approximately, the training
And that's
itself was approximately
300,000
6 to 8
people in
months.
the United
And
States.
then within a year, I
that
was
sample could
promoted
be
to an
from.
FS2.
That's why they're saying it's
And when you were
consistent with John.
promoted to work as an
Not
FS2,
that it is John.
what, if any, specific unit were you assigned to?
300,000
the
people
DNA
that
unit.
could be.
And have you essentially been with the DNA unit since that assignment initially occurred?
Yes.
Now, just a few questions about the lab at the State Police Crime Laboratory. Is that lab accredited by anybody?
Yes, we are accredited by ANAB, and that stands for ANSI, National Accreditation Board, and the ANSI stands for American National Standards Institute.
And with
Yeah, so
reference
about
to
300
that
300 million
accreditation,
population
describe
right
to the
now,
jury just
I
a
think
little
is
bit
about right.
Generally in terms of what goes into an accreditation
It's
of
a little
a
over
lab.
that, actually.
Yeah, so
So
this
we're more like
organization, ANAB, they came
330,000
into our
people
lab
it could be.
and they reviewed all of our protocols, ranging from facility security to
Then
the
you can look
protocols
at
that we do in the
population
lab to
clusters,
staff
right?
education and
People from
training,
which
and to make sure that
origin,
we
clustered
were
in
meeting
which
all the
area.
standards that we are being accredited to.
And you would expect to find more
And the
prevalence
lab at,
of certain
MSP
types
Lt,
like
its
that in
accreditation,
areas
is it,
where,
Is it up to date at this point?
you know,
Yes.
similar
With reference to yourself personally, sir,
recent geographic
in
origin
regard to your casework,
people
in regard to your
originated,
training,
where they
are
ended
you
up.
familiar with the term proficiency testing?
Yes.
And can you explain to the jury what that is and sort
For
of
example,
how often
you'll
and
find a
what
lot of Native American
consists of the
ancestry out here where I
proficiency testing
am.
that
You
you
won't find nearly as
Yeah,
much
so
of
a
that in
proficiency test
Massachusetts.
is given on a semi-annual basis, so twice a year, by an outside agency, and we don't know what the results are, and we treat it as a regular case. So we take it through the regular DNA processing, and we have to pass that proficiency test to show that we maintain our competency in whatever work that we are doing in casework.
And sir, as far as the proficiency testing that you've undergone, what have been the results of your proficiency testing?
I've passed all of mine.
Now, sir, it may be a term that's pretty well understood, but if you could explain to the jury, at least based on your training experience, what your understanding is of a couple of different terms. And first one, I'm going to start with DNA itself. What is DNA?
Yeah, so DNA stands for deoxyribonucleic acid.
Oh my God.
And that is basically the genetic
Really?
blueprint
We're
that makes
going
us
here.
who we are. And we
'Cause for
each
like
have
the
2
eighth
copies of it.
time, we need to
inherited
hear
one
it's the
from our mom
blueprint.
and one from our dad. And that combination makes us unique. And with the exception of identical twins, everybody has a different DNA.
And is DNA the same in every cell of a person's body?
Yes, barring any rare mutations, DNA is the same. So if you take a blood sample and a saliva sample from the same person, the DNA should be the same.
And what I'm going to ask you now is just a little bit about the process of DNA and how it's tested within your lab. Am I correct in saying that there's essentially 4 steps? Is that correct?
Correct.
And approaching sort of chronologically, one of the steps is called extraction, correct?
Yes.
Can you explain to the jury how it is specifically that DNA is extracted by yourself in general terms when you're testing?
I can't
Yes,
wait
so
for Bev
this
to lecture the
extraction step,
defense about how long this is
so
taking.
I received the samples. They're in like small tubes. They're closed. I will add a set of reagents to it, apply heat to that
Mr.
sample, and that
Jackson,
will
aren't
actually
you
burst
about
open the cells
finished
to make
yet?
the
If he
DNA
has like
available for
one
use.
question.
When you are extracting from a sample, do you know, or is there a way to sort of measure how much DNA you're extracting from a sample?
Yes.
And can you explain sort of how it is that you know that?
Yeah, so that's the second step that we call quantitation. And we take a small portion of that DNA that we extracted, and we'll apply a different set of reagents and run it through an instrument that heats and cools down the sample, goes through a cycle, and allows us to estimate how much DNA is extracted.
Now, sir, what is PCR?
PCR is stands for polymerase chain reaction, and it's basically known as molecular xeroxing, where it's making millions of copies of specific areas that you can target of the DNA.
I'm sorry, I didn't mean to step over.
Sorry.
Is that essentially the third step that you undergo?
Correct.
Now, what is a STR?
It stands for short tandem repeat, and these are locations in the DNA that change each person. So it's comprised of small
The
little
DNA
repeats.
equivalent of the
And each
firehouse
person,
apron.
however
We gotta
repeats you
hear it
have
from
at that location
everybody.
is sort of
The
what will
same
show up in
thing
your DNA
over and
profile.
over again.
Now, how is it with your work in the lab that you identify DNA fragments?
It's the fourth step where we call detection, where after we amplified the specific areas that we are looking at in the DNA, we'll run it through an instrument that will separate them out and generate the DNA profile.
Now, within your work in the lab, are you familiar with terminology as far as the known
They're
item versus
explaining the
question
exact
item?
themes,
Yes.
the same things
Can
to
you explain what each
substitute
of those mean in
volume
reference
of
to your field of
information,
your work and
quantity
what
of
is it?
information for the quality
Yeah,
of it.
so a known
Because
item
none
is
of
an
this is
item
any
that's collected
good.
directly from an individual.
So we're trying to distract the
it's
jury
to be
into
used for
thinking we have a
comparison
case
purposes,
by having
whereas a
people on
questioned
the
item is
stand who
collected
say lots of
from, let's say, like a crime
words.
scene where we don't know
That's
the source.
literally what Lally told us in opening
Now,
a
as
case
far
was
as
going to
your,
be.
lab,
We're going to
your
call
unit within the
Mr.
lab,
X and
their,
Mr. Z, and this
the DNA
person
unit
is a
itself, does it
witness
follow,
from the crime
the
lab, and they're going to
standardized
testify
policies,
about their
protocols?
observations.
Yes, we do.
And
That's what he
who
told
approves
us
of
we were
those
going to get.
particular policies, protocols, and procedures?
Our technical leader.
Now, could you explain the process used to analyze the evidence in this case?
Yeah, so the evidence in this case underwent that four-step process I just described, and which was extraction to quantitation to amplification, detection, and then interpretation of the profile that was generated.
Now, what are some of the controls or what do you use when you're during the course of your testing?
Yeah, so there are two types of controls, positive and negative controls. So a positive control is a sample with a known DNA profile that we use to show that each step in the process worked as expected. And a negative control is a sample that has no DNA in it and that only receives the reagents that we are using. And that is to show that there's no inherent contamination of the reagents that we use.
Let me ask you, sir, if you know, what are some of the ways to prevent sort of DNA transfer from yourself or from someone else working on the case or from other samples that you may be working on?
Yeah, so there are many ways. One way is to clean the workspace before we start working and after, just to make sure that it's constantly being cleaned. Another way is to wear lab PPE, so personal protective equipment like lab coats, face masks, and hairnets. And another one is to make sure that we only have one tube open at a time so that we don't have any cross-contamination between samples.
You should only have one tube out at a time,
does it
really.
undergo some sort of review process?
It does.
And specifically your work in this case, did it undergo that same sort of general review process pursuant to the policies and procedures you were speaking about before?
Yes, it did.
Now, when a case comes into the Massachusetts State Police Crime Lab, it's assigned a specific case number, correct?
Correct.
And in this instance, I'm referring to a case number entitled 22-02184. Familiar with that case?
I am.
And you did tested a number of different items within that case, correct?
Correct.
Now, as far as the items are concerned, similar to how the items from a specific investigation or case are assigned a case number, are those different items assigned different item numbers as well?
Yes, they are.
And if there is something that is taken, swabbed, or cut or something from a specific item, how is that labeled in relation to the item that it was taken from?
So basically, so let's say we have a parent item that's numbered 2-1. And then if we take a cutting of that item, it would be called, if it's the first cutting, it would be called 2-1.1.
Now, in this case, sir, was a known standard process?
Yes, it was.
And can you explain to the jury sort of how that process occurs in regard to processing a known standard?
Yeah, so the lab processing is the same, where it undergoes the same 4-step process. And a qualified analyst then looked at the DNA profile that was generated to make sure that it was a single source profile, meaning at each location that we looked at, there were only 1 or 2 peaks. And after that, it underwent the technical and administrative review process before it was closed out and ready for use for comparison.
Do you know whose known DNA standard was processed in this case?
Yes.
And who was it?
Known blood standard from John O'Keefe.
Now, as far as your involvement in this case, what was your involvement in this case?
I performed the testing of the questioned items.
And did you have occasion to perform DNA analysis on certain items submitted to your lab in connection with this case?
Yes, I did.
And let me ask you about some specific items. Were you asked to perform some analysis on a item labeled 3-1.1?
Yes, I was.
And if you know, what was that a sample from?
Would I be able to refer to my notes? Thank you. So that was a sample from passenger side tail light.
And with respect to that, there was a sample that was, or DNA profile that was generated from that swab from the tail light, correct?
Correct.
And what, if anything, were the findings, or what kind of, what was the conclusion of the analysis of the profile from the swab taken from the tail light of the vehicle?
The DNA profile was interpreted as a 3-person mixture, including male DNA.
And to be more specific, when an item comes in, it's assigned an item number. There's also a description that's provided along with sort of where the item came from.
Correct.
And so specifically, item 3-1.1 is a sample from passenger side tail light, and it gives a specific Massachusetts registration plate of 3GC684, correct?
Correct.
And so
we weren't sure which
from
taillight it was
the
supposed to be.
analysis of the swab or profile that was obtained from the swab from the taillight, what, if anything, was that compared to?
John O'Keefe, standard.
For the sample from Mr. O'Keefe?
Correct.
And with regard to that, was that a comparative analysis that you conducted yourself?
Yes.
And what, if any, opinions or conclusions come from as far as the comparative analysis between the swab from the taillight from that vehicle and the profile from Mr. O'Keefe?
Yeah. The DNA profile from this item is at least 510 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals, and this provides support for an inclusion.
And now, sir, with reference to that item in that comparative analysis, you said 510 non-alien times, is that correct?
Correct.
And non-alien, just for clarification.
So let's
purposes,
compare
do you know how
that
many
to the
zeros
last
that is?
girl's math.
It's a 1 followed by 27 zeros.
And
Or the
with
guy's
regard to
math,
that
I mean.
item coming from, or the profile containing the comparative analysis consistent with the DNA
They
profile.
got 749 non-alien more
Is that correct?
likely.
Correct.
Now, with regard to
So,
that, are you familiar with that
You
item or
know,
the
just goes
profile
to
from
show
that
how the
item
parameters you
submitted along
choose
with
can
other
change the
samples from
outcome
an
you
outside
get.
vendor called Bodhi Technology?
Correct.
Now, with reference to another item contained within that, are you familiar with an item 3-6?
Yes.
And what is item 3-6?
That is the root end of hair from exterior passenger side rear panel.
Now, sir, as far as hair is concerned, try for the jury a little bit about sort of DNA and how that works between, well, let me ask you this. There's essentially, when it comes to a hair sample, there's typically going to be a root end and a shaft end, correct?
Correct.
And where from the DNA, as your lab is concerned, where is that, where are you able to sort of test from, or where would you be looking to extract a sample from in order to perform testing?
Yes, so our testing for hairs, the DNA will be coming from any tissue that might be attached to the root end of the hair.
And so you're looking for specifically sort of follicular tissue, is that correct?
Tissues attached to the hair, yes.
Now, as far as, you familiar with the terms sort of autosomal DNA versus mitochondrial DNA?
Yes, I am.
And can you explain to the jury briefly just sort of what your understanding is of each of those two terms and what, if any, differences there are between the two?
Yeah, so autosomal DNA is present in the nucleus of the cell. That is, we inherited that from one copy from our dad, one copy from our mom. As mitochondrial DNA is present within the mitochondria, and that is inherited via the mother.
Now, your lab at the Massachusetts State Police Crime Laboratory, is the lab equipped or does your lab do mitochondrial DNA testing?
She's letting him do what he wants with the time he has.
And so when you say that the lab is
So I think the question is going to be,
so we don't
how much
have
leeway
the
does she
instruments
give
or the
him on
facilities to do that
props
testing.
when we're in the
we
defense
don't
case?
get that testing requested very often, so it makes more sense to send it out to an approved vendor to do that testing.
And one of those approved vendors would be the Boda Technology Lab in Lowton, Virginia that you were discussing previously.
Correct.
And as far as your understanding is that Boda Technology is equipped and does do mitochondrial DNA testing, correct?
Correct.
Now, with respect to your testing, you did some testing with regard to item 3-6 of the hair, is that correct?
Correct.
And can you explain to the jury sort of what that testing was and what, if any, opinions or conclusions you were able to draw from the testing that you were able to do in the lab?
Yes, so that testing began the same way as the 4-step process. I extracted the hair and then went to quantitation. After quantitation, I determined that there was no human DNA detected. So then testing was halted at that step.
And so what, if anything, was the results of that testing that you conducted with regard to that?
That no human DNA was detected, so STR analysis was not performed.
Now, that phraseology there as far as no human DNA detected, what does that mean?
So quantitation is looking specifically for human DNA, and we couldn't detect that with our instruments. It's not speaking to the hair itself. It's just that we could not detect any human DNA.
That's not so much to say that there is no DNA on the hair, it's just that it is below the level of detection that you're qualified to look for. Is that fair to say?
You're correct.
Now, with regard to the taillight sample, if I could step back to that for a second, the 510 non-alien times, what, if any, relationship does that have to sort of the overall world human population?
So the world population, I think, currently is about 8 billion, which is an 8 followed by 9 zeros. And 510 non-alien has
that's
27.
Cute. That's cute to make it sound like it's a population level statistic, which it's not.
Larger.
Significantly more. Right?
Significantly larger, sir. Yes.
Yeah, nothing misleading about that. That's always a major red flag
other items that you tested
when they misrepresent what their statistics mean.
This case. And just to be clear, sir, you conducted or issued about 6 different DNA reports in regard to the testing that you conducted in this case. Is that correct?
Correct.
So if I could direct your attention now to the 6 reported DNA testing report number 6. That involved an item called 3-3.1. Is that correct?
Correct.
And what is the description of that item?
Wait, I'm sorry. Got the wrong report. That is a sample from apparent glass on rear bumper.
With the same mass registration plate as the taillight, is that correct?
Correct.
And what, if any, conclusions or opinions were you able to draw from your analysis of the testing on that particular item?
So at the quantitation step for this item, insufficient human DNA was detected and STR analysis was not performed.
And again, just as far as that statement is concerned, can you explain a little bit to the jury what that means as far as what your opinions or what you're seeing in regard to insufficient human DNA?
Not enough DNA on the glass bumper sprinkles.
Yes, so we do have, at the quantitation step, we do have a cutoff,
So supposedly
a certain
enough
value
transfer
where
onto
if we
the
detect
taillight
human DNA that's below this cutoff,
from
we
striking
validated that
John
it's
to
not
transfer DNA, but
going to,
not on the
most
bumper
likely
glass,
not going to
not on
provide
the
a
bumper
profile that can be
sprinkles.
used. So we halt testing at that step.
Now, sir, if I could direct your attention to the fifth report that you issued in this case, DNA testing report number 5. And does that sort of contain the totality of the items that you analyzed in this particular case?
It does.
Now, sir, if I could direct your attention to an item labeled
Would you
as
say
number,
it's sort of
3-2.1.
like the powerhouse of the cell, or kind of like
And, what is the
the
description for
energy
that particular
section,
item?
or how would you
That is
describe
a sample
it?
from
The
exterior of
mitochondria.
broken drinking glass.
And with reference, were you able to generate a DNA profile from the swab or the sampling from that item?
Yes.
And what, if any, comparison were you able to do in regards to the DNA profile of Mr. O'Keefe?
Yes, so the sample was interpreted as a mixture of 3 contributors, and the DNA profile for this item is at least 530 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown unrelated individuals, and this provides support for an inclusion.
And so the sample from the exterior of the broken drinking glass is at least 530 non-alien times
Weird
more
mixture.
likely if it originated from John O'Keefe, correct?
Correct.
Just almost goes to show this whole thing is bullshit.
Now, if I could turn your attention to item 7-1.2.1. And what is the description associated with that item?
That is a sample from stain A on upper right leg of jeans.
And were you able to generate a DNA profile from the sample from what's labeled as stain A on the upper right leg of Mr. O'Keefe's jeans?
I was.
And what, if any, comparison were you able to do with relation to that profile from that sample to Mr. O'Keefe's DNA profile?
Yes, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. Contributor 1 was suitable for comparison, and due to limited information, contributors 2 and 3 were not suitable for comparisons. And the DNA profile from this item is at least 570 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown individuals. And
The
this
blood
provides
sample
support
is
for
a
the
mixture
inclusion.
of 3. Well, where's
So when
Brian
you
Albert and
say
Brian
as far
Higgins
as,
in this comparison?
Due to limited information, contributors 2 and 3 are not suitable for comparison. What does that mean?
So that just means that those contributors are very low and that any comparisons that would be done to them could not be reliable based on our protocols and validations.
And so from your comparative analysis, you came to the opinion or conclusion that the sample from the upper right leg of Mr. O'Keefe's jeans was 570 non-alien times more likely than it originated from Mr. O'Keefe, correct?
Could you rephrase that?
With respect to your comparative analysis of the profile from the sample from stain A on the upper right leg of Mr. O'Keefe's jeans, your opinion is that it was at least 570 non-alien times more likely that it originated from John O'Keefe, correct?
From then,
Sorry.
What was your conclusion as it came to item 7-1.2?
so the DNA profile from this item is at least 570 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals, and this provides support for an inclusion.
He said that DNA recovered from the blood sample was a mixture of 3.
Transfer DNA. You familiar with that term?
Yes.
Can you explain to the jury?
Now he's going to talk about transfer
So
DNA.
transfer DNA just means DNA that sort of transfers based on just some activity that can happen. Like if somebody touches a water bottle, they might transfer some DNA onto that water bottle.
Now, from the fact that DNA is on something or on an item and it matches the profile from an individual, is there anything from that that you can opine or conclude as to how that DNA was deposited or when?
No, I cannot.
Now, with reference
Well, way to undermine the significance of everything you just told us.
factors that may cause a degradation of a DNA sample or a touch DNA sample that's left. What, if any, are some of the factors that may affect that as far as causing degradation of a sample or you're causing an inability for you to be able to generate a DNA profile from another?
Some factors include being exposed to heat for a prolonged time and ultraviolet rays from the sun, as well as just time. It might eventually lead to some degradation.
Now, as far as items that are outside, you indicated that being hot or warm temperatures might have some effect on it. What, if any, impact with cold temperatures?
So we store our DNA extracts in a cold room. So cold temperatures could be very good to help preserve any DNA that's on there.
What about when you ship them by
Now, if I could turn
by
your attention
FedEx?
back to your report number 5.
Is that
and
refrigerated?
ask you with reference to item 7-1.3.1. And can you, what is the description for that item, sir?
That is a sample from stain B on upper right leg of jeans.
And again, those would be the jeans of Mr. O'Keefe, is that right?
Correct.
And you were able to generate a DNA profile from that sample as well?
Correct.
And what, if any, comparison were you able to do between the profile from that DNA on the upper right leg of Mr. O'Keefe's jeans and Mr. O'Keefe's?
Yeah, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least 660 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. And this provides support for an inclusion.
Second blood sample, also a
Next, I'd like to turn your
mixture.
attention to,
Did you compare them
item
to each other? Are they consistent with
7-1.4.1,
being
and,
the
what
same
is that
3 individuals?
Sample, what is that item or sample from?
Betty did.
That is a sample from stain C on upper right leg of jeans.
And those genes would be Mr. O'Keefe's genes as well?
Correct.
And were you able to then generate a DNA profile from that sample?
Yes.
And what, if any, comparison or what, if any, conclusions or opinions did you draw from a comparative analysis of the DNA profile from that sample from the upper right leg of Mr. O'Keefe's genes and Mr. O'Keefe's DNA profile?
So the DNA profile is a mixture of at least 2 contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributor 2 is not suitable for comparison. The DNA profile was interpreted as a mixture of 2 contributors, and the DNA profile of this item is at least 830 non-alien times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals, and this provides support for an inclusion.
Now, sir, if I could turn your attention to item 7-1.5.1, and where did that come from?
He does look
That
like
is sample
Samuel
from stain D
Tarly.
on upper right leg of jeans.
And
Yeah,
again,
he
were you able
does,
to
doesn't
generate
he?
a
He's
DNA
like the
profile
Clark
for that?
Kent of Samuel Tarly.
Yes.
And what, if anything, were your findings in
Good
relation to
eye.
comparative analysis?
Very good
between
eye.
That and that DNA profile from that sample and the DNA profile of Mr. O'Keefe?
I was
The
trying to
DNA
place who I
profile was
thought he looked
interpreted as a
like.
mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least 670 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. And this provides support for an inclusion.
Sir, if I could turn your attention to item 7-1.6.1. And what is the description for that item?
That is sample from stain E on upper right leg of jeans.
And were you able to also generate a DNA profile from that sample?
Yes.
And did you then
Did
do,
they look anywhere
conduct a
besides his
comparative analysis
legs?
between the DNA profile from that sample and the
How
DNA
about that
profile
stuff
from
all
Mr.
over his bib?
Yes.
And what, if any, conclusions or opinions or findings did you have in regards to that comparative analysis?
Yeah, so the DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 1 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals, and this provides support for an inclusion.
Now, as far as that decillion, again, similar to the non-alien, how many zeros are we talking about?
That's a 1 followed by 33 zeros.
Now, if I could turn your attention to item 7-1.7.1. Familiar with that item, sir?
Yes.
And what is the description for that item?
That is sample from unstained areas of exterior of jeans.
And were you able to generate a DNA profile from that sample?
Yes.
And similarly, were you able to then do a comparative analysis between the DNA profile from that sample and the DNA profile of Mr. O'Keefe?
Yes.
And what, if anything, were your findings in regard to that comparative analysis?
Yep. The DNA profile was interpreted as a mixture of 4 contributors, including male DNA. The DNA profile from this item is at least 553 septillion times more likely if it originated from John O'Keefe and 3 unknown individuals than if it originated from 4 unknown, unrelated individuals. This provides support for an inclusion.
And similarly,
John and
sir,
3
with regard to
unknowns.
that number, septillion, how many zeros is that?
That is a 1 followed by 24 zeros.
I'm going to ask some questions about a number of different items from 7-17. These are samples taken from an orange t-shirts, as well as a gray long sleeve shirt. Is that correct?
Correct.
And if you could, essentially you did testing on those items as well as some fingernail clippings along with Mr. O'Keefe,
Correct.
or samples from the fingernail clippings.
Yes.
Now, with regard to those items, swabbings taken from the stains from various areas of the orange t-shirt, and just in general, where were those areas on the t-shirts, the orange t-shirt to start with, that the swabbings were taken from?
The top front left of orange shirt and front bottom right of the shirt as well, and just the back left shoulder of the orange shirt.
Now, with regard to the gray long sleeve shirt, where are the areas on the shirt where those swabbings were taken?
The right sleeve, the center front, the back left, the back right, and the back bottom of right.
And were you able to generate DNA profiles from each of those items?
I was.
And were you then able to do a comparative analysis between the DNA profile from each of those items with relation to the DNA profile from Mr. O'Keefe?
I was.
And what, if any, conclusions were you able to draw from that comparative analysis?
So the male DNA profile was interpreted as originating from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
As far as that number is concerned, octillion, how many zeros is in our octillion?
That's a 1 followed by 27 zeros.
And with regard to each of those items, from the orange t-shirt, the gray long sleeve t-shirt, the fingernail clippings, so they were taken from both the right and left hands of Mr. O'Keefe, is that correct?
Correct.
So that's 490 followed by 27 zeros. That would be from a single contributor, correct?
Correct.
Now, sir, if I could turn your attention to item 7-18, I'm sorry, 7-18.4.1. You're familiar with that item?
Yes.
And what is the description associated with that item?
Sample from stain C on top front gray long sleeve shirt.
And were you able to generate a DNA profile with respect to that?
Yes.
And were you able to then do a comparative analysis between that DNA profile from that item and the DNA profile of Mr. O'Keefe?
Yes, I was.
And what, if any, conclusions did you come to with regard to that?
The male DNA profile was interpreted as originating from a single contributor. The DNA profile from this item is at least 58 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And with regard to that stain from the gray long sleeve t-shirt, again, that was determined by you through your testing to be DNA from a single contributor matched John O'Keefe, correct?
It was determined to be from a single contributor, yes.
Yeah, he didn't say
Now,
match.
sir, if I could turn your attention to item 7.
Well, I tried to slip that in there. Match, John. Well, no, it didn't. You can't say that.
Yes.
And what is the description associated with that item, sir?
A sample from stain L on back bottom right of gray long sleeve shirt.
And were you able to generate a DNA profile from that, sample from that item as well?
Yes, I was.
Were you able to then do a comparative analysis between the sample and the profile from that sample versus the profile from Mr. O'Keefe?
Yes, I was.
And what, if anything, were your findings in relation to?
So the DNA profile was interpreted as a mixture of two contributors, including male DNA. The DNA profile from this item is at least 1 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from two unknown, unrelated individuals. This provides support for an inclusion.
Interesting.
And sir, I'm going to ask you, or draw your attention to item 7-18.17.1. Familiar with that item?
Yes.
And what is the description associated with the sample from that item?
Sample from unstained areas of exterior of gray long sleeve shirt.
And were you able to also generate a DNA profile from that sample?
Yes.
And what, if any, were you able to then do a comparative analysis between the sample profile from that sample and the profile from Mr. O'Keefe?
I was.
And what, if any, conclusions did you come to with reference to that comparative analysis?
The DNA profile was interpreted as a mixture of two contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 960 non-million times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Quite interesting.
So there are some other items from which you conducted testing, but were not able to generate a profile from, correct?
Correct.
And specifically, I'm going to ask about item 7-3.1. That's a sample from the right instep of Mr. O'Keefe's sneaker, is that correct?
Could you repeat that number again, please?
Sir, if I could direct your attention within your DNA report number 5, I'm talking about item number 9.
The right instep of the sneaker where blood falls on your foot, down the front, on the front of your pants and onto your foot
And so,
when you're in a
with
fight.
reference to that, what if any,
Your face starts bleeding.
there's an indication as far as the mixture not being suitable for comparison due to the quality of the profile, correct?
Correct. It was a mixture of at least 5 contributors.
And so from that, as far as
Interesting.
not suitable for comparison, can you explain to the jury what that means?
Yes, so during our validations, we've only validated mixtures up to 4 contributors because we've determined that once you get more than 4, like at least 5 contributors into a mixture, it becomes too complex to be able to make any reliable comparisons to that mixture.
Sir, if I could direct you to item number 11 or item number 7-18.3.1 within your report.
Right.
Did you do any
That's stained
YSTR
from
to
the
just
gray
focus
long
on the
sleeve,
males?
T-shirt top front, is that correct?
Exclude any
Now
female
that is
DNA?
indicated as not suitable for comparison due to the quality of the profile, correct?
Correct.
And can you explain to the jury what that means as far as not being suitable due to the quality of the profile?
Yes, so during our, bringing it back to our 3rd step of amplification where we're making millions of copies of specific locations, sometimes there might not be a lot of DNA there. And that amplification set might not amplify all the information that could be present, and the profile that's generated won't have all the information to be able to reliably make a comparison. So the information that we are able to look at is very limited. So we just do not do any comparisons because they would not be reliable.
And with that saying, as far as not suitable for comparison due to the quality of the profile, was that the same for 2 other areas that you tested in regard to the front of, or sample from the front of the gray long sleeve shirt and a sample from the back left sleeve of the gray long sleeve shirt?
Yes.
So more than 5 contributors on those parts of the shirt.
May I have a moment?
Yes.
I'll tell you why I find that interesting when we get to a quiet point.
Let me ask you just briefly, you're familiar with the term called SDR mix?
Yes.
And can you explain to the jury what that is and how that is involved or how it's implicated within your testing?
Yeah, so StarMix is a tool that we use to basically break down complex mixtures into its individual contributors and into like a way that it would best describe that mixture. And once it does that, it'll then do comparisons and calculate a likelihood ratio, which is a statistical weight to that comparison.
And how does that relate to the testing that you did?
I used StarMix on all the samples that had comparisons done to them.
Thanks. Thank you, sir. I have no further questions, Your Honor.
Ms. Lull? No questions, thank you. All right, Mr. Porto, you are all set, so
Thank you.
Could I see counsel regarding scheduling, please?
Yes, Your Honor.
Oh, are we stopping early today? Well, okay, I'll tell you why I found this interesting. So from the gray long sleeve shirt, we had stain C, which is a single source male sample, stain L, which is a mix of 2. From the unstained areas, it was a mix of 2. And then the other parts that he just described, the front of the shirt and the back of the sleeve, there was more than 5. There were so many contributors, it was unsuitable for comparison. The reason I find this interesting is because one of the sources of contamination for a piece of clothing is laundry. You can, like if you use a laundromat or even just, wash your clothes in the same washer as somebody else, DNA and in fact, like whole cellular material.
So we're actually going to send you home today.
Yeah, they're done early.
We're
He's out of
on
witnesses.
schedule. It's beautiful out. Rather than start with the witness that we'll start with tomorrow morning, it makes sense. I'm going to talk to the lawyers for a few minutes. So we'll send you home. Do not discuss this case with anyone. And
Wonder
just
if we're
so that
doing the
I'm
voir
clear,
dire.
That means each other. That means any aspect of this case, any observations, anything at all. Do not do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. We expect a full day tomorrow.
All rise for the court, please.
So I find it interesting that they were able to get the single source DNA profile from the shirt at the same time that they're getting all these mixed profiles, right? Mixed profiles might suggest, well, it's been in the wash, you know, with somebody else's clothing, somebody else's dirty socks. I mean, whatever. It's been in a locker with other people. I mean, a lot of ways that you know, obviously DNA can get transferred around. But the fact they had a clean spot on that shirt where it was just his DNA, compared to these other spots where some it's just him, some it's two, some it's 5.
All right, so I'll see counsel at sidebar about a couple of issues.
Now, so what does this mean? What are we to take away from this? Well, it's certainly consistent with a bunch of people touching him up in a fight, isn't it? It's consistent. You can't rule that out. You can't rule that out, that's the way that DNA got there. But you can't say definitively that's how it happened either. I mean, that's really the problem with this evidence. And that's why Lally had to come out and say, he had to disclaim his own results with the transfer DNA. Yeah, sometimes basically this is all bullshit because it doesn't tell you anything about when or how it got there. And that's kind of the whole point, isn't it? That also applies to your taillight stuff, doesn't it, Mr. Lally? It also applies to these other items that you collected. If you can't associate it with a biological source, like this came from a blood sample, this came from a semen sample, whatever, it tells you very little about the manner of how it got deposited there. So, yeah, it's consistent with being in a fight, but it's also consistent with just kind of being a person alive in the world who's out there, you know, getting exposed to other people, out there in bars with people around, out there, you know, you giving hugs with people and stuff like that. I mean, all of these things are potential contributors of trace DNA. Being in the same room with a bunch of people at the bar can get trace DNA all over your clothes. So, to the extent the Commonwealth might have liked to try to rule out a fight, even though, of course, absence of evidence is not evidence of absence. If they had no other DNA on these clothes but John's, it still doesn't prove there wasn't a fight. They would have liked to have ruled that out, but they can't because there's a ton of DNA on here. Now, I would have been interested to see them go back and do a YSTR analysis. YSTR is just focusing on the Y chromosome, so you can take any female contributors to the sample out of it altogether. All he said is that these are mixtures that include male DNA, but he hasn't specified, are they exclusively male DNA? I don't know. I would like to know that. You could potentially go and look at the YSTR and see if you could exclude any of those mixtures. Maybe. Don't know. Because obviously, you know, Karen and him live together. Children live with them, including a female, you know. Potential contributors to DNA on his clothing. So you would think, yeah, if they wanted to rule out a fight, they would, that's what they would be looking at. They would be looking to see, well, is this John in females? Because, you know, that's not consistent with the defense theory. Again, doesn't rule it out, but, you know, doesn't look right. Doesn't look right. This that he's given us, it looks, passes the eye test. Passes the eye test as being consistent with the defense theory. On his legs, On his legs, like, you know, when you grapple, do takedowns, stuff like that. Where do you tend to be touching each other? Kind of right there in the front of your center of gravity. Right there around top of your leg, around your waist. The places on the shirt. Back of the sleeve, like, I don't know, where you might grab somebody. Mixtures. It's not inconsistent with any of that. Nothing on the fingernails doesn't really mean much to me because where's my fingernails? They're touching myself. If I'm in a fist fight, I'm not using my fingernails. It could be from the emergency services. It could be from the floor of the ambulance. It could be from the floor of the hospital. It could be on whatever Proctor and Buchanan had touched before they stuffed these things in a bag. It could have been from people in the evidence room, the unsecured evidence room where this was sitting out on the butcher paper. It could have been from the last person that was near the butcher paper. You know, anybody walking by where these clothes are out. Could have been from DeChico before he bagged them up and sealed them and put them in the evidence locker. Could have been from all these people. It's not impossible it comes from the people on the lab too. I mean, yeah, they take a lot more steps to prevent contamination than just any random person out in the real world. But these are not foolproof systems. These are not foolproof systems. Again, there's been more testing on this, validation type of testing where folks have gone into these laboratory settings and tested their equipment, their supposedly sterile equipment, and find DNA all over it. So you can't rule out some of the stuff's from the lab too. Now, the lab, they will, again, just like they did with Proctor and Buchanan, they'll typically have reference samples and frankly just have them on file so that they can look for that. They can test for contamination by their own staff. But that doesn't tell you anything about cross-contamination, right? That's somebody depositing their own DNA onto an item. Has nothing to do with that transfer like Lally described. He didn't even get into secondary transfer, right? You touch something and pick up DNA, and then you touch a second thing and you transfer that DNA you touched to the second thing. Very common. And in a study done of that, something like 30% of the time where that happened, it's only that secondary DNA that gets transferred. It's not your own. You can transfer it to from point A to point B without leaving any indication of your own DNA there. It's not uncommon at all. So this is kind of the problem with the modern era and where we're at with DNA technology is it's so good. It's become so sensitive. We're so able to detect its presence that it's kind of started to become meaningless. It's everywhere. And the more you pick up, the really less explanation you have for the story of how it all got there. You know, how do you account for all this DNA? Well, you can't. So for me, that's why, you know, trace DNA is just really, really inherently problematic. If it's not something that you can attribute to a specific biological source, hard to evaluate it, hard to understand what it means. A biological source will at least give you some kind of idea of how it got there. You know, blood drips, saliva, you know, near someone's mouth or someone's, you know, grubby, spitty hands or something like that. It gives you a little bit more of a story of the process of the deposition. But just DNA out there really doesn't tell you much of anything at all. Well, waiting to see if we get any kind of updates here. But yeah, notice no comparison to any Alberts, no comparison to any Higgins. It's another one you could you need probable cause to get a warrant, but you can also always ask. You can also always ask, get consent, do a comparison for rule out purposes. Police ever come to you and ask you to give them your DNA for rule out purposes? Don't believe them. Don't do it. Make them get the warrant. Make them get the warrant. And this that we're seeing here should be a really good illustration why. Because you have no idea where your DNA could be or how it got there. You cannot take it on faith that your DNA is only on things that you have touched or been near. No, your DNA can exist within a whole network of people that you have contact with, the things and other people that they have contact with. It's the whole 7 degrees of separation thing is where your DNA can be found.
Tori. So I totally blew off the exhibits.
She totally blew off the exhibits. Was that a hot mic? All right. Guess that's all we get. Now it's fan time. So no voir dire today. After all that stink she made about making sure we had to get those witnesses in on Wednesday. No, we're going home early instead. Well, it's Thursday, but you know what I meant. You guys know what I meant. So, boy, what did this tell us? It told us the hair could match thousands of people. And it told us that there's all kinds of DNA all over John's clothes. This is the Commonwealth's case. This is the Commonwealth's case. I mean, it's comical. If it weren't tragic, you know, it would be comical. This is their case. This is what Karen Reed has spent probably hundreds of thousands of dollars, years of her life, all of that. All of this being dragged through the press. This is why. This is why. I mean, just kind of crazy. So many contributors to blood on his shoe, on his right shoe. I'm glad they said, well, they didn't say. He didn't say the right sneaker. He said it must be. He must mean, yes, the right instep of sneaker. He must mean the right sneaker. I was waiting to kind of hear that. Although the right instep would be, the instep on the left shoe would be on the right side of the shoe. But the instep on the right shoe would be on the left side. I don't know what that description means. I'm gonna assume he meant the right sneaker just because that's consistent with the blood dribbling, you know, down his face, dripping from his forehead and stuff, down his front onto his shoes. And because if blood were on that left sneaker, I mean, surely we would have pointed that out, right? If it's on the left sneaker, that was supposed to be knocked off of his feet. He was supposed to be knocked out of that sneaker with such force that, you know, he ended up on the lawn and died, just like the Reddit meme, you know, no longer has his shoe. So if any blood was on his left shoe, that would be a big problem. That would be a big problem for that theory. Unless it's old blood, then I'd wait to hear how it's old blood. It's not brand new blood. So I will assume that it's the right sneaker based on that description, although it's a little bit ambiguous because surely Ms. Little would have clarified that for me on cross-examination if that weren't the case. I'm going to be inclined to think that. So, all in all, how was this day for the Commonwealth? Mr. Tully did not do all that fantastic. Got a bunch of surveillance video that shows some taillights on blob-shaped vehicles. At least they didn't actually try to tell us, yes, I matched that to be Karen's car. I mean, maybe they recognize there is a limit to how stupid they think we can be. We can see it with our own eyes. We can see it. We can tell that that could be any make and model and year of black SUV. There's no way to attribute that to be Karen Reed's vehicle with any kind of definitive identification. So lo and behold, they found black SUVs in the areas where they were looking for black SUVs, where they were looking for Karens. I wonder how many black SUVs there are in Canton. How many people you think drive black SUVs in Canton? So we got that surveillance video because I guess what? There's only one route she could have taken? I don't know. And then we got that that ping stuff. Oh man. Oh man. Didn't he get picked apart on that ping stuff? He was trying to spar. He was trying to spar with his little cutesy language games. No, that's not right. It's not first location, or it's not present location. It's first location and last location. I'm going to get you on that. Oh, okay. Okay. But the real takeaway from that whole presentation was how police can create a misleading perception of what the evidence establishes by cherry picking what parts of it they choose to show you, and they leave out the parts that don't support their analysis. So the towers that were closer to her that she should have connected to if she was at 34 Fairview under your theory, didn't connect to them. And if you'd have stuck them on the map, well, gee, the jury would have seen that, huh? So better not stick that on the map because it makes it a little bit problematic trying to figure out how to make your point. Left Country Lane off your map, the whole place where she was ostensibly going that morning to Jen McCabe's. I mean, ostensibly, we know she got there. We just don't know, when and what route she took. But you left that off the map entirely because weren't you trying to say she must have gone to 34 Fairview instead of Jen's, right? Just because of the time frame. Maybe she, I don't know, pulled over and tried to call people. Maybe she did that. Maybe she did that. Saw, didn't see a broken taillight on any of these black SUVs that the Commonwealth is showing me. So let's say they are her car. Let's say these are her car that the Commonwealth showed us. What does that establish? Didn't look like she had a broken taillight. Not a completely busted out right rear passenger taillight. And she's driving pretty good. She's driving pretty good for having a 0.19 or 0.27 or whatever the Commonwealth is trying to say her blood alcohol level was, right? With the nine drinks in the 2 hours, and it's now, a few hours after that. 5 hours after midnight. So she's still, if you process out about 1 drink an hour, she's still, got about 5 drinks in her. And it's, that's assuming singles here. Looked like she was driving pretty good to me. Didn't see any veering. Didn't see any starting and stopping. Didn't see weird speed variations. Nothing. Real common one is to forget to turn the headlights on. It's real common source for the DUI stop. Forgot to put the headlights on. No, nothing like that. Of course, this is a modern Lexus. The lights are probably automatic. I bet the cops hate those modern headlight, automatic little ambient light detectors that go ahead and turn your headlights on for you. I bet they hate that. That was a very, very common source of DUI stops. Headlights weren't on. So yeah, that didn't really help. Lally didn't really help. Trying to get out of his lane there with the abrasions and the caused by the blunt force. No, nobody is impressed with you trying to play doctor on the stand. Absolutely nobody is impressed with that, because we already know the medical examiner disagrees with you. The person with the training and the actual expertise in how to interpret things like injuries, causation of injuries and stuff like that, she doesn't agree with you. So yeah, she's the one who's qualified to give that opinion. And then just walked him through that whole mistake he made. Yeah. And he's trying to qualify this. Well, I didn't rely on the distance. Well, no. Or I didn't rely on the time. I only relied on the distance. You mapped the distance. Well, no, but your explanation for why there are two things here for this one procedure anyway is because she would have had to have gone from one to the other. That's why the time is relevant. Of course, you didn't include the time on your map, because the time on your map requires the 135,000 mile an hour speed that her phone was moving at in order for your theory to work. She could not have moved from arc A to arc B over the time of the distance of that process, because that's not possible. That's not possible. That was not a good moment for him. Not a good moment for him at all. And then of course he's got to tell us all about the problems with Mr. Laughlin's statements. According to him, they did the whole review of his veracity. They found it inconsistent. But then when he described it, yeah, no, these don't sound inconsistent. These sound like he's providing more detail as he's getting asked more questions. That's what it sounds like. And then, well, you questioned his ability to perceive it, because he's up high and he's down the road and he's colorblind. What, he can't see a car because he's colorblind? Yeah, I don't know about that. But really the whole problem with this to me is that it just highlights the difference with how you treated this guy, with how you treated Jen McCabe and Matt McCabe and Brian Albert. Didn't do any investigation into their veracity, did ya? No. You took their words at face value and you went to go ahead and seize Karen's car based on that information. And you already knew before you went and talked to them from the medical examiner. Looks like you're not the medical examiner, but from the hospital. You're investigating. He's been in a fight. He's been in a physical altercation. He might have got struck in the face with the cocktail glass. That might be the explanation for how all this went down. Somebody bashed him in the face with a cocktail glass hard enough to break it. You knew that's what you were looking at. But then you went ahead and just took their word for it. No, it couldn't have been that, because he never came inside. Did nothing to investigate their veracity, did you? Look at their phone. Look inside the house. Even just ask for permission to do those things if you can't get a warrant. Did you even ask? Bet you didn't. Bet you didn't. So yeah, not a real strong showing from Lally today, because Tully really didn't help him. And then the rest of the stuff is either neutral or a net negative. It's either neutral or a net negative. I mean, the only people you tried to rule out as contributors to this other DNA is Proctor and Buchanan. Okay. And you only compared him to the tail light. These are all mixtures. We're going to hear, I mean, I'm assuming we're going to hear from the defense expert about the limitations of the fact that these are mixtures, because you heard the way that he testified. It's a very qualified conclusion that he can reach. He can't say these guys are excluded as contributors. He can just say, well, there's strong support for excluding them. But again, there's just a lot of interpretation, a lot of just different parameters that you can look at when you're trying to evaluate mixed samples. There's a lot more room for subjective interpretation in there, and for the effect to be magnified. The effect of those decisions can be magnified. And so it like makes your decision, the effect of that more significant, like makes the result look like it's more significant than it would be if you made a different decision and looked at some different parameters. So they didn't say these guys can be excluded. They just said, oh, strong support for it. Strong support for exclusion. You can't say definitively because you got a mixture. If you just have a one-on-one sample, it's very simple. I look at your profile. I look at this other profile. Do they match? Then I can't exclude you. Do they not match? I can exclude you. I can exclude you if my test sample has STR combinations at one of the locus points that are different from yours, different number of repeats, then it's not your DNA. You can be excluded. So you can't do that with a mix. You can't do that. You can't do that one-on-one comparison to say, well, obviously this isn't you because it doesn't match, because you're trying to interpret who contributed what, right? And so it gets complicated because what locus points are you dealing with? Do we have 3 copies of one locus point, or do we have 1 copy of all of these different locus points? How much of each profile was contributed by each individual? Are these entire profiles? Are these partial profiles that are mixed together? It's just all, mixtures are a problem. Mixtures are a problem. So yeah, I expect we're going to hear more from a defense expert on this, and that's probably why they didn't bother to do any cross with these witnesses, because they'll just go ahead and elicit it from their own people. I'm going to look at their witness list real quick just to see who they have on it. I don't know. I don't know if I would even recognize, who a DNA expert would be if it's just by name. They got a lot of the same people on there. Andre Porto, that was the guy that just testified. The guy who really did look like Clark Kent, Sam Tarwell. What a good call that was. Yeah, they just got a bunch of names. I don't know if they have a DNA expert on their list. I don't know that they do. So I don't know. We'll see. Maybe they're just relying on the fact that the DNA evidence in and of itself maybe isn't really that important. Maybe it's just not really that important because it doesn't tell you anything definitive anyway. The defense can argue that this supports their theory. Mixture of all these individuals, and how come they didn't go rule out the Alberts as being contributors? Why didn't they do that? Good question. Good question. I don't know where we're going tomorrow. I don't even know what to expect tomorrow. Where are we going? Are we going to finally get the medical examiner? Do you think there's a chance we could finally get the medical examiner tomorrow? My thought process about the schedule here, she was very firm about, making them commit to time frames so that she can tell the jury you're going to have this case by the end of June. So that gives us what? That gives us how many more weeks to work with here? We are on June 13th. So after this week, we got two more full weeks that they can spend on this case. And that's assuming they have every day. So the Commonwealth has had since the end of April, right? Beginning of May. I don't even remember the date they first started taking the evidence. They did openings on April 29th. So that's when we started with the evidence, right at the end of April. So the Commonwealth has had, I'm just going to go ahead and count them. 1, 2, 3, 4, 5, 6. We're on week 7 of the Commonwealth's case. Okay. And we got 2 weeks left before the jury is supposed to get this thing. So my theory is that to be able to give them that schedule, she's basically made them to commit to how much time is it going to take? How much time is their case going to take? How much more time is the Commonwealth going to get here to do their case in chief? Now, I will grant there's a lot of overlap between the defense witness list and the Commonwealth's witness list. So a lot of the people on the defense witness list, they probably don't need to call. They've already been called. Yeah, it's possible they could recall some of them, but it's just, if you don't have to, you don't really necessarily do that. You had your opportunity when they were there for cross-examination. So a lot of people that were already on the list, you can just cross them off. But then there's still quite a few people on the list. No, they were not on the Commonwealth's witness list. So if they need to and want to call all of those people, yeah, we still got quite a few people that the defense is going to want to put on, and that's not even counting. Are we putting Karen on the stand? Is Karen going to testify? Because that's going to take some time. Okay, if Karen is going to testify between direct and cross-examination, that is going to take some time. That's going to be more than a day, I would think. That's going to be more than a day. Well, so we got 2 weeks left after tomorrow. How much of that is the Commonwealth going to take up? I don't know. They still got 20 plus witnesses on their list. We still haven't gotten to the medical examiner. This is why I'm wondering if she's put a hard limit. If the Commonwealth said, for example, we'll be done, by X date, she needs to hold them to that if the jury is going to get the case within her timeline, right? And so my working assumption has been that while she's not exactly running the time clock with the sort of rigor that Judge Escarati did in Depp v. Heard, they've been allocated a certain amount of time to be able to get things done. And they can use their allocated time however they see fit. But when the clock runs out, the clock is out, and it's time to move on. One of the reasons why I'm sort of intrigued to watch how this happens once we get into the defense case is because she, as we have seen, she's given the defense a hard time for doing stuff on cross, but she's letting Lally tell us for the 8th time that the mitochondria is the powerhouse of the cell. We hear all this repetitive stuff over and over and over again from Mr. Lally, and it was only like the 8th time that we heard about the fire department apron that she was finally like, we can go ahead and move along from this. Well, the reason why is because when you, as the attorney, you're estimating how long it's going to take you to present your case, you're just giving a best guess for how long they're going to spend cross-examining your witnesses, right? I don't have any control over that. I have control over how long I think it will take for me to elicit the information I want from them on direct. But I don't know how much time you're going to spend with them on cross. And I just don't have a good feeling about how Mr. Lally is going to do on cross. I just have a sinking feeling that if we think his direct examination with the friendly witnesses is meandering and bad and ineffective, is it possible cross could be even worse? Could it be even worse? Yeah, it maybe could. It maybe could. Very common I don't even want to say technique. It's not a technique. Prosecutors, I've said many times, they're not used to doing cross-examination. A lot of their cases go through, there's no defense case at all. They just don't have the experience with it that the defense lawyers do. The defense lawyers, that's the majority of your job, is cross-examining the state's witnesses. So the prosecution just doesn't have the practice with it, and it's not their wheelhouse. It's not what they're used to. And so a really common way for somebody who is unskilled with cross-examination to conduct it, they treat it kind of like a deposition where we just go back over everything you just said on direct. And I hope maybe I can catch you in something that sounds like an inconsistency or like quibble with the words that you used this time versus the last time. Very common way for an inexperienced or just unskilled person to conduct a cross-examination. And that's not how to do it. That's not what it's for. You go into cross already armed with the facts that you are going to elicit from this witness. And you're pre-armed because you know you can back it up. If they deny it, you can impeach them. You got their prior testimony. You got the photograph. You got whatever you need to be able to nail them down and point out to the jury, this is my fact. This is the fact, and I can prove it. Doesn't matter if this witness, is friendly about giving it to me or not. You don't go in and invite people to tell you whatever they want on cross-examination. It's got to be targeted and focused to specifically what you're trying to elicit. And that's why when you don't have something specific, something good that you need to elicit, you don't ask any questions. You do what this defense team is doing and you sit down. You don't ask them anything. So I have a sinking feeling, I just do, that we could get even more meandering, obnoxious, terrible time management from Mr. Lally when he's doing cross-examination. And that's going to be very unfair to the defense, isn't it? If that's not accounted for, if Judge Bev doesn't move him along the same way that she has been eager to move the defense team along here during their cross-examination, they should be having their fixed amount of time. They should be accommodating a reasonable amount of time for Commonwealth to do its cross-examination of those witnesses. And they should get the full benefit of that. The Commonwealth should not be able to go around and around and around on with pointless stuff on cross-examination to run out the clock. And so I'm going to be watching Judge Bev very closely to see how she does her clock management once we're finally done with the Commonwealth here and we're getting into the defense case. And yeah, I'll just say again, I do think there's going to be a defense case. This is not going to be thrown out at halftime. It's just not. The standard is far too permissive. It's far too permissive. It's basically under any sort of interpretation of what the Commonwealth has put forward. If you believe absolutely everything their witnesses said and practice his interpretations, you accept his interpretations. If that's enough to convict, then it's going to go to the jury. It's going to go. So it's going to go here. It's going to go. We know that it seems pretty unlikely the jury is going to buy a lot of this stuff. But that's not the standard. That's not the standard. So, well, guys, let's go ahead and check back in on some of your comments and chats here. Well, very timely, pretty much what we were just talking about here. Callie Intus Mortuus. If there is a world in which she is convicted, could an appellate court see a reasonable jury could not convict her on the evidence like here in Australia? Nope. Nope. They will not substitute their judgment of what is reasonable for the judgment of the jury. The jury is pretty much sacrosanct when it comes to deciding credibility of witnesses, how to resolve conflicts of evidence. They are the sole determiners of fact in the case. And so, no, the courts will not second guess that. The only thing that they will look at is there sufficient evidence? Considering this standard, you look at everything everything that the Commonwealth has presented, everything that's come out from the defense case that could favor the Commonwealth. You look at all of that, you draw all inferences from it in favor of the Commonwealth, you assume all of those people are credible and believable, and if based on that you could find her guilty, then it will be affirmed. It will be affirmed because they will assume that that is what in fact the jury did. So no reasonable jury type of exception to that. Horror Vibe 666. I see no signs of impaired driving by Karen. Exactly what I said. If those videos are her, how did this help? How did this help the Commonwealth? I mean, yeah, she looks like she's driving just fine. Kyle Cowden, 3 towers, 250-foot radius, 2 is 500 foot plus, 1 is 1/2 mile. Okay, so that's I think the range of what we're talking about of these particular towers that were mapped up. So yeah, what does that tell you if her phone pings off of one of those towers? Here's how close she was. Lauren Boborin. Issue with this is how they use it and discredit it, prosecution in general, to benefit their case. The data is either reliable or not. Yeah, notice it's both the cell site data and the DNA data, right? They really want it both ways. They really want it both ways because he wants to be able to rely on that DNA to say John's head hit the taillight. Okay, but you can't rely on the DNA to say John's head hit the taillight without saying a bunch of people had their hands all over John's pants. Okay? If your reasoning is going to be consistent and your logic is going to be consistent, you got to take the bitter with the sweet. And yeah, same thing with the cell site data. How many cases have they gone out and they've prosecuted based on these pings? These are great evidence. These are great evidence, very precise. They will tell you right where a person can be located, et cetera, et cetera. How often do they do that? No, I don't know, but I bet they've done it before. Bet this guy has done it before. So yeah, totally agree. Suits them when it benefits their case, and then we disregard it when it doesn't. Silvermane, if the car has smart sat nav, Lexus themselves will have tracking info on the car. Yeah, makes perfect sense. You know, late model car like this, pretty new, got all the fancy bells and whistles of the modern technology, which my car does not have. I have the little stripped down sports car with like no features whatsoever. Doesn't have anything like that, but yes, I would expect hers. It's a luxury vehicle, for heaven's sakes. It's going to have everything cutting edge. Roseanne McDonald with a super sticker. Thank you so much. Appreciate that. Thank you for your support for the channel. SV, will Proctor be placed on a Brady list based on all his proven lies? He'd be fired for sure. Then yes. Ha ha ha. Well, I don't expect him to be placed on a Brady list based on his proven lies. And the reason why is because just because you and I think the lies are proven and think that it's really obvious doesn't mean that the prosecution would ever concede that. It doesn't mean they would ever concede that unless there is some type of adjudication, which could be internal affairs. It doesn't require like, oh, he gets prosecuted for perjury and convicted or something like that, because, you know, then he wouldn't be a cop anymore. He wouldn't be being put on the stand as a witness and his credibility on the line. But it could be an IA thing, and sometimes, you know, that is how somebody ends up on the Brady list, is because they get disciplined by internal affairs. They were found to have falsified a report or something along those lines. So that's what it's going to take. Not just you and I looking at this trial and having, you know, the common sense to be able to tell there's some big problems here. That's what it would take. So some type of formal adjudication. At least I would expect that. If they didn't, you know, maybe defense will litigate that. Maybe they'll litigate that. There's such a good public record of this trial now. One of the big advantages of having these things televised, it's out there on the internet now. You guys can all come straight to my channel. I mean, I didn't start at the very beginning, right? I started on like day 8 or something. I don't even remember now. But it's all on crime, you know, it's on Court TV, whatever. It's on NBC 10, all these different channels where you can go back and watch the entire thing for yourselves. So maybe they would litigate it. You know, the things that he left out of his report, you know, no real explanation. Colin not there in his report, but it's in his notes. Weird how the ring video is missing, but DeChico had notes about it. That's kind of weird. Yeah, but it's not proof definitive. He hasn't been adjudicated of doing anything wrong. So this is just, you know, part of how cops get protected. Part of how they get protected. We don't go looking for their wrongdoing because, yeah, then that might cause us a problem and we'd have to disclose that to people in other cases and then they might be able to use that against us. So we'll just la 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 la. Don't know anything about police misconduct. Floral from Under a Rock. This is only either evil or gross negligence. We are kind of ruling out alternatives, aren't we? It's getting harder and harder to look at this as a good faith prosecution, just with all of these discrepancies that are coming up and the way things seem to be starting to point to Mr. Lally. I'm just going to go ahead and say that. I don't know why Tully was looking at what sounded like the defense exhibit when he's supposed to be under a sequestration order. Don't know why that would be. You're really not supposed to do that. Sentient Dreamer. These LEOs think their hatred of defendant matters. Yeah. It's so arrogant, isn't it? They think that because they say something and they believe something and they perceive things a certain way, that's how it is. That's how it is. It's a tendency. It's a narcissistic tendency. I've mentioned before that it's just one of these fascinating theories that I came across in a psychological piece. It was just an article that was written by I think he's a psychiatrist, but he's also got a PhD in philosophy or something like that. And he wrote about the epistemology of narcissism. And it's basically just because narcissism is self-referential, right? Everything everybody wants to know is, do they believe their own lies? You know, does Amber Heard, does she believe her own lies? Does she actually believe that stuff? That when she's up there on the stand making up these fabulous stories that are completely contradicted by the evidence, does she believe that? Or does she know that it's false and she's lying? This guy has the whole theory that with narcissism, because it's so based around this grandiosity and this enormous self-regard, it's a self-centered worldview. And so reality is defined by what that narcissistic person thinks and believes, what they want it to be. If they say it is, then yes, you must accept that. And that's why then there's so much emotional and cognitive pressure that they will bring to bear on getting you to agree with that, right? Because proof to the contrary, that's going to trigger cognitive dissonance. How do we reconcile that? Well, we're going to make a bunch of excuses. We're going to pretend, we're going to gaslight. We're going to pretend like the photograph that we're looking at actually does show you with a broken nose and two black eyes and so on and so forth, busted lip. I bring this up just because, there's obviously narcissism as a clinical diagnosis, which is not necessarily what I'm talking about here. I'm just talking about a worldview, a form of undue self-regard, a form of arrogance. And it's so similar to what I see in the way that these police officers, these law enforcement officers are testifying. They say so, therefore it must be so. And how dare you not agree? We're gonna gaslight you into, don't believe your eyes when you look at John O'Keefe's injuries. We're gonna actually say those injuries were compelling evidence that Karen Reed hit him with a car. It's like they think that if they say it, that makes it true. That makes it true. So it reminded me very much of that article that I read that I've mentioned before. Got a couple new members here, KB and Mags. Welcome, guys. Thank you so much for joining the crew. Kevin Costello, couldn't they have gone in with exigent circumstances in this case? I mean, the thing with exigent circumstances is, again, it's going to kind of require a link to the inside, right? How exigent the circumstances are depends on how likely is it that there's something in there and that something could happen to it, you know, that it would be destroyed or something like that. And I think just the fact that it's outside of law enforcement control, in and of itself, I don't think that that's necessarily going to create exigent circumstances, because under the Fourth Amendment, they have the ability to seize property, to detain it while they go and get a warrant. So they can hang on to it for, you know, however long, a reasonable length of time, whatever the case law tells you that means for any particular thing. As long as, you know, they detain it, they go get the warrant, and then they execute their warrant. So, you know, that's feasible to do. And the reasonableness of how long they can hold on to it, it kind of depends on what the thing is. You know, a house, you're going to probably have to move pretty fast. Something like a car, you know, maybe not so much. Maybe not so much. So I'm not sure the exigent circumstances would have really helped them here. It just doesn't really fit the fact pattern, I don't think. It's either a question of if they had probable cause at all, or if they didn't, why didn't you ask for consent? Very easy to ask for consent. But I am getting a lot closer. I don't rush to find probable cause in situations. You know, I am skeptical of it. And for all that, when it's convenient for him, Lieutenant Tully tries to inflate that standard as a more likely than not. It clearly is not. I read you the case law that makes it clear it's not. It's not really that high a standard, but it should be, right? It should be a higher standard than that. They should have a pretty good reason to have to be able to invade your privacy without your permission. So I've been very skeptical of the probable cause to get into the house just because of their own decisions not to develop certain information. But yeah, I'm getting a lot closer today after that presentation from Alan Jackson. I continue to have problems. The big problem for me with this is the broken cocktail glass. It really is, because you never compared it to the waterfall, and we don't know where the rest of the broken glass is. Where's the rest of the broken glass? It should be right there. If it's not there, where is it? Where is it? By the time you got Karen's SUV, you knew it wasn't in there. So where is it? You didn't go look in the house. You didn't do any investigation on that. I'm getting closer. Rube at Zoe Sia on X did an exquisite deep dive on reconstructed taillight evidence photos, who, when collected, mapped in a diagram to reconstruction. Very clear and very sus. I did see this. What folks have done, I mean, it's the sleuthing on this case is phenomenal. Like, it's amazing. I'm amazed at the stuff that people are able to do anyway. You know, that's just the level of detail that people can break things down with some of this trial evidence. But I did see this because what I believe this person did is went back over the photos that were introduced from the SERT search, and so was able to then identify the shapes of the pieces of plastic depicted in those photographs, then went and compared those to the evidence bags. And from the evidence bags, then we saw, you know, who collected what at what particular point in time. So this user was then able to find, okay, these shapes of the plastic from the SERT search match these pieces of plastic, which were in numbers 7.7-5 and 7-6. And then the rest of the ones, you could identify which ones were found by, I think, Trooper DeChico? I don't remember. There was somebody else, and then Buchanan. Some were attributed to Buchanan, and some were attributed to Proctor. And so he was able to identify all of these individual pieces and then match them up to the pieces on the reconstructed taillight, so that we know this one from this bag went here, this one from this bag went here. And the interesting thing about it was that you would expect, if the taillight got hit and got shattered, that the pieces that got collected would be sort of random, right? They would be, just whatever you happen to get to at that point in your search by that person, would have found it. But what you found is that the pieces perfectly match these clusters. Proctor found all of the pieces in this chunk of the tail light. Buchanan found all the pieces in this chunk of the tail light. The SERT search found all the pieces in this chunk of the tail light. So that's sus. Okay, that's pretty sus, because it just seems like out of all of these pieces, you guys just, there was no mixing, like all the pieces, landed perfectly uniform in accordance with these chunks that you then later were able to go back and find. No, it looks very, very sus. So yeah, go check that out on X if you haven't seen it. I found it quite compelling, quite interesting. Roubaix, 2 red and 1 clear from 129 SERT fit reconstruction. Yeah, so 3 pieces from the SERT fit, 3 pieces in Tully's original report, right? But then somehow it turned into 5. Somehow it turned into 5 pieces in the bags. How'd you like how he tried to blame the crime lab for that? Oh, well, they were out of our chain of custody at the crime lab. What chain of custody? They're the only ones that maintained a chain of custody. They did so much of a better job documenting what they had, when they got it, what they did with it, where they put it, where it ended up, than you guys ever did. I mean, the balls on that guy to blame the crime lab for that. Oh, I can't see the jury being impressed with that. Aunt Betty, I can't let this stream go by without stopping to appreciate how great your hair looks today. Well, thank you. Thank you so much. I really appreciate it. I'll have to get the curling iron out more often. Guess it really works. Bobby Walter, didn't expect Jackson to calculate the speed of light. That's a good one to have at the tips of your fingers, right? I don't have that one. 187,000 miles per second. Did I get that right? 187,000 miles per second. I think it's somewhere in that ballpark. But yeah, pretty good piece. And then he did the math just like I did. He did the math on those. Let's get this 0.004 seconds over the 0.15 miles. Let's go ahead and do the math on that and break that down into 135,000 miles an hour. Yeah, I liked it. I liked it a lot. Beach Rando, was it established J.O. left waterfall with jacket on? No, nobody has seen a jacket at all. There's been no testimony from anybody that saw him in a jacket, with the exception of who was that first firefighter? It was not Flamati. Natali. Firefighter Natali. He is the one that remembered the puffy coat, and he remembered it so clearly because they couldn't cut it off. It would create, a whole mess in the back of the ambulance. So they had to work it over John O'Keefe's cold fingers and wrists and stuff like that. And he remembered it so clearly because, according to him, that's how they noticed that his fingers and hands were very stiff. And then it turned out he wasn't wearing that at all. They got the photographs. Alan Jackson showed him the photographs of what John was wearing, and he had that great moment of the memory is a funny thing. Memory is a funny thing. It is a funny thing. And that's how you see you don't have to have a whole bunch of knowing conspirators involved for something like this to happen. You don't need that. You just need memory being a funny thing and just the right set of incentives, the right set of alignments, the right opportunities for extraneous information to be introduced. That's all you need, and this stuff will take care of itself. It'll happen on its own. Jack Rabbit with just a super chat, no comment. Thank you so much. Appreciate that support. Jana Bell, in Canton, if one can go the speed of light, would that make them a witch? We all know what happened to witches in Massachusetts. FKR, thank you for your coverage, Andrea. Yeah, wasn't there actually an Elizabeth Proctor? Wasn't there a John Proctor and an Elizabeth Proctor back in Old Salem? Kind of remember those names. Not sure I remember who the original Lizzie Proctor was, but I might have to go check that out. Have a little reminder of that little piece of history. Kay Coco became a YouTube member. Welcome. Appreciate having you on the crew. Anton Ivanov, currently drafting an SPA and still watching. Yeah, see, we can what's the word I'm looking for? We can multitask. We can do more than one thing at once. I swear I can talk and think at the same time. Really, really good at it. I can watch TV and take notes. My limit is at reading the chat while doing all those things. I have a hard time with dividing my attention 3 ways. But yeah, watch a trial, produce a written document. Not really that difficult. Michelle, people keep testifying John's body was wet. Being out in the snow wouldn't make someone wet. 34 Fairview has a pool and probably a walkout basement to the pool. This is an interesting point. A pool will not freeze over in the winter, at least if it's, if it's below the frost line, because it will stay the constant temperature of the center of the earth is approximately 50 some degrees, like 55 degrees. The earth is a ginormous heat sink. So yeah, things that are buried in the ground are going to stay above freezing if they are, below the frost line. So, however, his body temperature is going to be warm from the point of his death until, as his body cools, through both hypothermia and potentially body temperature falls after you die. It's all complicated. It's going to be complicated sorting that out in this situation, I think, because of the hypothermia. Might one of the ways to calculate a time of death ordinarily is just the rate at which the body temperature falls, and so you can take their present body temperature, when you find them, and kind of calculate that backwards at the rate of loss to be able to estimate, well, then when did they die? At some point they're going to reach equilibrium, and the body is going to be the same temperature as the ambient environment. So he's going to be warm, and as long as he's warm and snow is falling on him, the snow is going to melt, and that is going to make him wet. So I would expect some of that. It's just that if he'd been lying out there since 12:30, and at 6 o'clock he's been out there for 5.5 hours in Helen Jackson today said 18 degrees. I'd looked at historical weather reports before for Canton. I was seeing like 25 degrees, somewhere in that ballpark. So I don't know exactly what it was, but it, significantly below freezing. It's cold. It's cold as hell out there, and you're wet. Okay, wet helps with the heat transfer. That's part of the problem with hypothermia. Hypothermia is going to happen a lot faster if you're wet than if you got dry clothes on. So it's going to fall on him. It's going to melt. That's gonna it's gonna make him wet, and that's gonna increase, his heat transfer out into the just the environment, out into the air, the atmosphere. So it's hard for me to see how, he's not like frozen solid by the time they get there at 6 a.m. If he's been out there since 12:30. 5.5 hours, and he's still alive. I don't know about that. I mean, I guess it's questionable whether he was still alive, right? Because we don't know, because he was hypothermic, and everything slows down with hypothermia. The lividity slows down, the rigor mortis slows. All of these processes get affected by the change of temperature. So I'm very interested in that from the medical examiner. I'm wondering if that's one of the reasons why she can't corroborate this law enforcement theory, is because she can't put the time of death at 12:30. I'm just wondering. We'll have to see. Alfredo 1234. Andrea Burkhart, I probably missed it. Was there a verdict on the previous KR trials? Is this a continuation of those or a brand new one? I'm not aware that there are any previous KR trials. This is, to my knowledge, the only trial that she's gone through. There's been all kinds of pre-trial hearings dealing with essentially the evidence that is going to be produced in the case or not produced in the case. And so through those hearings, a lot of information about the evidence has been elicited. But that wasn't a previous trial. That's just the attorneys giving an offer of proof to support, the information that they're trying to seek out. So for example, the defense was trying to get, the cell phone extractions from a lot of these witnesses. And in order to do that, they needed to present the evidence of the cover-up. So that's how a lot of that information came out and was made public through those pretrial processes. It wasn't a previous trial. Britt Cormier, sorry, all this accreditation testimony means nothing to me. Lally is an accredited lawyer and he sucks at his job, just saying. Yeah, it means you can pass a test, it means you can pass a test. It means you're part of the cabal. Part of the cabal, you pay your fee. How hard is it to be accredited? How common is it to lose accreditation or to have some kind of corrective measures, things like that? How are the standards set? It's one of these things too, where, again, fox guarding the hen house, that was an analogy that came up today. It's a little bit the fox guarding the hen house. You're collecting money from a bunch of labs who want accreditation. Is it in your interest to not take their money? No, of course not. It's always in their interest to set standards that labs can meet and to basically facilitate them being able to maintain their accreditation so that they continue to pay you money for that certification. WM Penguin, I'm starting to think all these people worked on the same case. I'm not sure what these people worked on here, if I'm being perfectly frank. Duncan, Idaho, I want Lally to ask him now, with respect to the rest of the cell, what, if any, would be the role of the mitochondria? Yeah, we played with this one while he was testifying. You got to make it leading. He won't ask the what, if any, until he's already tried to make it leading. And we need some sort ofs in there. Sort of, kind of, with respect to. You got the with respect to. All these verbal tics from Mr. Lally just because he doesn't know what point he's making. So he's got to meander around with his words until he can finally figure out what's he trying to get at. Like, you can watch him thinking as he's formulating this question. Joe Mendoza, just want to hug Lally at this point. Lally, you is kind, you is smart, you is important. Wonder if he pushed back to Morrissey to prosecute this case. I don't know. I'm not seeing any of that. I'm not seeing any of that at all. I'm not seeing smart for sure. Not seeing kind. Bringing this case on this evidence against this woman is not kind. Important. He's important enough to be able to do it, right? He's powerful enough to be able to do it. But I don't see any indication he pushed back on prosecuting the case. I mean, he's here. You want to push back? Get the hell out of the office. It's always an option. It's always an option. If you have a serious issue with something you're being ordered to do. No, it's easier to just follow orders. Duncan, Idaho. So this is kind of establishing extreme plausibility for the theory that he was beaten by 2 to 4 people and a dog, right? Why is Lally doing this? I pulled this up while the DNA testimony was going on. Because why Lally is doing it, he's got to. It's got to. This is all he has. This is all he has. And so he has to try to pretend that this is helpful to his case. This is the give us quantity, not quality kind of stuff. He's thinking if he gets us through 7 weeks here, we might mistake some of it for being good instead of just the absolute train wreck this case has turned out to be. It's a disaster. This case is a disaster. He is so far behind, and the defense hasn't put on a single witness. He's so far behind. So he doesn't have any choice. I mean, he knows the defense is going to put it out anyway, or they can put it out anyway. It's consistent with their theory. If I'm the defense, might I put this on? Yeah, maybe. If my theory is he was beat up on a bunch of people and there's multi-source DNA all over his clothes and the blood on his clothes, yeah, I might put that on anyway. Pretty sure they had that guy on their evidence list. Yeah, they did. They had Mr. Porto on their evidence list. So it's coming in anyway, so you might as well get out ahead of it and pretend like it really helps you. You know, offer these explanations for the transfer DNA so that you just drop that in so that you can suggest it only applies to the stuff you don't want the jury to be taking too seriously. You know, don't go back and apply that to the plastic taillight stuff. Don't think about it in that context. We'll just get past that. And then we'll talk about transfer DNA when we're onto the clothes. Horror Vibe 666. Where are the 2 missing bodies that Karen murdered? Yeah, right. Which other heads? Which other heads did she strike with that taillight? Gotta wonder. Track worker. They never bothered to get sample DNA from McCabe's Alberts. Nope, they sure didn't. Didn't even ask. And, again, have just done nothing to develop probable cause for the alternative suspects. They had their minds set on Karen. It was going to be her. She's fucked, as Mr. Trooper Proctor told us. Duncan, Idaho. That direct seemed almost as helpful to the Commonwealth's case as Lally going over Proctor's text with him. Just offering up facts for the defense, no narrative support any of the Commonwealth's claims. Why, Lally? Yeah, this is the DNA evidence again. He has to. I mean, this is what he has. But yeah, I mean, helpful? No, I mean, he thinks what's going to be helpful is these non-alien, the big numbers that are helpful. And yeah, go back to how we snuck in that, well, the world population is 8 billion and this is a lot more than that. Well, yeah, except the statistic has nothing to do with the population. It's not a prevalent statistic. Could I nitpick about not clarifying on that on cross? Of course I could nitpick that, but it's probably not really necessary. It doesn't matter that much. This is just me being particularly irritated by that because it's one of my pet peeves, because it's dishonest. It's dishonest and misleading. This is part of the problem with science in the courts. It isn't just that so many of these techniques are junk. It's that it's presented as something that it's not. So when you present something like this as a population level statistic, like you're saying, it's so much more likely if he's 1 in 8 billion people and this is 1 in so ever many non-alien, that those things are related to each other, and they're not. And this guy knows perfectly well that they're not. Damaris San Giuliano. Andrea, I so admire your smart mind, living my dream of being a criminal defense barrister lawyer through you. Greetings from England. Well, thank you very much. I have been able to live the dream. I never thought I was going to be there. I didn't plan on being a criminal defense lawyer. I really didn't. It's just funny how life takes you down past that way. When I first went to law school, I thought I was going to be an environmental lawyer or something like that. The reason why I went to law school in the first place, there were a couple things that factored into it. One, I had a temp job when I lived in Tahoe. I worked at the El Dorado County Superior Court. I was one of those court clerks in there for the criminal division. And, people would come up to the counter and they would have questions and stuff. And I was just always very frustrated at my ability to, I can't really help them a whole lot. You can't give legal advice, even though I've seen I've seen how it happens in all these other cases and stuff like that, but you can't tell people about that. So I wanted to be in a position where I could be a little bit more of a helper, and maybe a little bit less of a bureaucrat. Then the other thing that really factored into it was after I left the court, I worked in construction for quite some time, and I learned about the Tahoe Regional Planning Agency. This is a whole just zoning mess for without getting into all the complicated details, special zoning in Tahoe and all of these crazy rules and being able to navigate them in order to not just construct something, but like maintain what you have, you know, which trees you can cut down and stuff like that, all subject to all of these complicated rules. So I thought, hey, I really liked construction. I liked Tahoe. I was thinking I'm going to end up in construction or something like that. And I'm going to know all these zoning rules. Like, I'm not going to practice as a lawyer. I'm just going to have the education to be able to do that. Well, none of those things happened as it turned out. You know, I went through law school. I did an internship. I did actually a couple internships in environmental law. Realized quite quickly, yeah, I don't want to do that. Don't want to do that. Those are horror stories I'll tell another time. But just not my scene at all. So I ended up instead, my first job out of law school, I got a clerkship, worked for the Court of Appeals over in Tacoma. It's just a typical nerdy, you know, kind of research position. You research the judge's opinions. And that's where I got my first like real exposure to criminal law. I'd never done anything like that while I was in law school. And I liked it. I was interested in it. And so when my clerkship was up and it was time to get a job, I thought, hey, I've liked this criminal stuff. And, you know, it'd be really good to get trial experience. And I think trial attorneys, you know, public defenders get a lot of that type of experience. So why don't I try to get a public defender job? And here I am. The rest is history. Never planned it, but it's where I land. So, yeah, it's been quite a ride. And I'm glad that you're here to share it with me. James Casatelli, I feel like AJ leaves too much for the jury to figure out for themselves with how he asks questions. He's not spelling stuff out enough. Yeah, I mean, I'm of two minds about this. Number one, you can't always ask the witness the ultimate question, right? The final conclusion of the chain of facts that you've elicited, right? That's your interpretation. That's your conclusion that you've brought, that you've reached. But with a hostile witness, you can't accept them, you know, you can't expect them to accept your interpretation or to, you know, give that to you. They're almost certainly not going to. So a lot of times it is going to be better. It's going to be the best thing you can do is just elicit the facts you need to elicit from that witness, cold, clean, clinical. You get what you need to know. And you don't always have to ask that last question because the jury can also connect dots. They can see where this chain of inferences leads. But then you just come back to it in your closing argument. You remind them of what they heard from this witness, and then you tell them what it means. That's your opportunity in closing, is to tell them what it means. With a witness, it's a little bit risky if you try to tell the witness what it means. You know, it's cross-examination, so you're supposed to be able to lead like that. Bev doesn't seem to be allowing that. She's calling it argumentative or something. So she's not allowing him a lot of leeway to be able to do that anyway. But, you know, you can predict he's not going to accept it. So then the question is he dangerous enough to be able to counter? Is he going to be able to counterpunch on this suggestion that you've made and, like, you know, volunteer something that could be damaging, you know, his own interpretation, his own conclusion. You know, that's just a risk. That's the risk that you take when you ask one question too many. So, I feel like Mr. Jackson is kind of going back and forth with that. He doesn't have my approach to cross. My approach to cross is very surgical. It is very, very factual. I'm just there to get the facts. And I'm not there to argue about what they are or what they aren't, because they're either in your testimony or they're in some other item of evidence that I'm going to be able to, you know, put under your nose and get the jury to see how you respond to that, you know. But I have a way to establish my fact, and that's the only thing I'm using cross-examination for. Mr. Jackson does have a much more argumentative style than I do. But I do think that a lot of those limits are being imposed by the judge. She's just not letting him be himself. And so, yeah, he might be struggling a little bit with how to get to where he needs to be, given the fact that sometimes he's allowed to go there, sometimes he's not. It seems very unpredictable. And that makes it hard for him to have a cohesive, consistent strategy. Desert Cat, I predict the Commonwealth will use Karen Read's voicemails as the big finish. Want Yuri and Proctor back. Hope Karen Read does not take the stand. Would there be a benefit at this point? Yeah, I could see that. The voicemails is the big finish. That definitely makes a lot of sense. The last witness being probably Guarino, the guy that did the extraction. That could make sense. Would there be a benefit to Karen taking the stand? I've said before, you know, for me personally, everything else being equal, if it's not going to blow my client up, if there's not massively impeachable stuff out there or big problems, or they're just such an awful person that it's going to be hard for them to come across well to a jury, everything else being equal, if I don't have to deal with those things, I want them on the stand. I want them on the stand because the jury has been sitting now watching Karen for 7 weeks. They've been watching her. They've been evaluating her. They've been thinking about her. They've been trying to get a read on her. They want to know who she is. And I want so much to be able to give that to them. I have found personally that a lot of things that sometimes, I don't know, discourage people from putting a witness on the stand, juries often don't care. And I'll give you my classic example is the jury trial I won with the convicted sex offender that I put on the stand. It's a failure to register offense. He's arguing basically what happens, he gets out of jail, he's homeless, so they have these very specific registration requirements. You got to check in like once a week. He does this consistently for a certain length of time. And then according to him, he's told by the person, the officer who does the registration, look, we don't need you to come in every single time. We know where you are. We know where you're staying. You don't need to come keep giving us the same information. Just let us know if it changes. So he doesn't go back for quite some time. Well, DOC doesn't do anything about this for like months. And then they decide, because they see him at, somebody's house, basically a new girlfriend. He sees him at the new girlfriend's house a whole bunch of times. They decide, therefore, he's living there. He's not actually living in where he was homeless before. And so we're going to arrest him and charge him. I put him on the stand to testify to all this. I mean, yeah, he's a convicted sex offender and he's a homeless guy. You can imagine how he looks. He's been in jail the whole time. We're waiting for this to go to trial. This guy doesn't look like he walked off Wall Street or anything like that. You can imagine how he talks. Okay? Don't think he graduated high school. But he wasn't a bad guy. One of these people, he's convicted of a sex offense at like 14 years old or something like that. A kid with a very, very bad past. Didn't have serious problems as an adult. Most of his problems as an adult were drugs and failing to register. Getting into trouble with just the following the rules authority, like hoops you have to jump through once you've landed in that type of situation. So he wasn't a bad guy. I thought, he's not gonna. I can't do anything about a sex offense. The jury's already going to know he has that. He is who he is, but he's not an unlikable person, and he's entitled to be heard. He was hesitant. He didn't necessarily jump. He wasn't one of these people that's like, I'm going to testify no matter what. No, we had to talk it. We had to talk it through. And he was, kind of insecure about that. What are they going to think about me? I'm like, look, you're not a bad guy. You're, reasonably articulate, da, da, da. I think it's going to be okay. Yeah, he got acquitted. They believed him. So a lot of those things I think are not really good predictors of why you should or shouldn't put somebody on the stand. For me personally, the big limitation is there information out there that they can't get in that would hurt, that they can get in if you get on the stand. And those are typically going to be things like, did you make a bunch of prior inconsistent statements? Have you been on record before with things that are going to differ from what you're saying on the stand? It's not a deal breaker, but it means you're gonna have to have a really good explanation for why your situation changed, why your version of events has changed. And I know that Karen Read has done these interviews. I know that stuff is out there. That's potential impeachment stuff. I don't know what else there might be. Who she's talked to, who she's texted, what she said. To me, like I've said from pretty much the beginning here, it's really not, I don't have any problem with the idea that Karen may have initially thought that she did something to John, and maybe she had a little help in coming to that conclusion. Maybe she did, because by all accounts, she was distraught. She's in shock. She's behaving like she's in shock. She doesn't remember things that just happened. She thinks period blood is on her hands. I mean, she's not in a good place mentally. So yeah, she could in that state, I think, pretty easily think, yeah, maybe I did. I don't remember. It's possible. I can't come up with any other explanation for why he's here. You're not in a real rational state when you're under extreme stress like that. So to me, that's not really inconsistent. I'm totally okay with, yes, she thought she did it, and then the evidence came out and it proved she couldn't have, and then this evidence comes out that makes it a lot clearer, what the alternative explanation here is. So she just has to be able to articulate that in a way that, the jury can understand. And I'm sure that you got to practice, you got to prep a witness, you got to prep them for the kind of cross they're going to get, I would like her to testify. I think, everything else being equal, there's always a benefit, because the jury wants to know. The jury wants to know who you are. They want to see for themselves, oh, you're not some boogeyman monster. You're not a whack job. She's not a whack job. If she's not a whack job, it's a good thing for the jury to know. So I hope she does. I just don't, I don't know her. I don't know her. I don't know the information behind the scenes. So I don't know how to make that calculation in this particular situation. Patricia McLean, the blood on the front of the jeans, nose fight. Exactly my thought. Yep. I'm a little bit of a bloody shirt expert. I've mentioned before, I bleed in the ring. You look at me hard, and I will start to bleed. And so, yeah, I have dripped down so many shirts and shorts and onto my shoes and all over the ground in the ring, the floor of the ring. Yeah, real familiar with that pattern and know very well what that looks like. Oh, and by the way, when your shirt's wet, like if you're sweaty all over your shirt, yeah, the blood will like seep through, you get that capillary action. So it's not like necessarily nice, neat droplets. It looks, kind of like it looks on John's shirt, kind of like it looks like on his clothes, I mean, yeah, that's what it looks like to me. Makes a lot more sense to me than what's the alternative explanation from the CPR? Well, he has no pulse. Okay. So he's not actively bleeding at this point. The only blood that is coming out of him is from you doing compressions on him. That's what's going to cause active bleeding at this point. How is that getting on his shoes? How's that getting on his waist? You don't sit somebody up to do CPR. You're doing it flat on his back. You're doing it flat on his back. I don't know how you get the spatter pattern. Bottom side of his shirt, onto the pants, down onto the shoe. Looks like a fight to me. He was upright. That's what that spatter pattern looks like to me. Britt Cormier, I think we can agree if it was a civilian's house, they would have made an excuse to go to the bathroom in the house and got lost exiting the home to search for evidence in plain sight. LOL. Yeah. Very good point. You mind if I use your restroom real quick? Take a little look-see. Very good call here. Very good call there. Horror Vibe 666. Any mention in MSP reports of the Asian house? That was Matt McCabe's text. No, in fact, I kind of remember because his text. I saw somebody bring this up too. His text was February 1st. He says they're back out here, but we don't have a record of any search happening on February 1st. So I don't know what they were doing there. It was a gap in time between January 29th when the search team was out there, and then February 3rd was when Yuri went out there, I think with DeChico, and they did their little search. So I don't know that we even have a record of who would have been out there on February 1st and what they would have been doing. Kind of weird. Kyle Coden, Algar Mortis equals -2 degrees Fahrenheit at 7 degrees Fahrenheit air, faster from there. So yeah, the colder it gets, the more body temperature you're going to lose. He lost approximately 16 degrees, right? In much, much colder air. Yeah, don't know how long that's going to take, but it just seems like it's going to be a lot faster than 6 hours. 6 hours. Cow Palace Dave, today I learned that DNA spelled backwards is A-N-D. It's probably the most valuable thing that you learned today, too. Kyle Cowden, SUV would be 100 miles an hour plus for energy to send JO 10 feet. Interesting. Yeah, I know that there's a lot of these calculations that can be done. I have no doubt that the defense experts have done them. Don't know. Don't know what the Commonwealth has. Don't know what the Commonwealth has. They got some cops from cars. We know that. So that's, I think, their reconstruction team is the police officers versus, you know, these PhD guys on the defense side. Yeah, they can look at how much does John weigh, or technically what's his mass, what's John's mass, what's the mass of the vehicle, and yeah, what forces would need to act between those two things to create this outcome. They can do that math, and they're going to. They're going to. And we can assume that that's why, you know, the Commonwealth is having to present us with what seems like, to me, a pretty improbable theory of she reversed, you know, 60 feet at 24.4 miles an hour. Be interested in like the acceleration and the torque, you know, how much torque would it take to achieve that outcome, 24.5 miles an hour over 60 feet. And how fast can you do that? I'm going to be interested in all this math. They're capable of doing it, and I'm sure somebody's done it. Guys, I don't know what to expect for tomorrow. Really don't. I would love to think we're going to get the medical examiner, but I just don't know. Let's go ahead and pull up. I'm going to pull up the witness list and see where we're at here. We still got a whole bunch of cops on the list. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 just straight police officers, 2 people from the chief medical examiner's office, Wendell Robery from the Canton Fire Department, maybe they just won't call him, I don't know, 2 nurses from Good Samaritan, maybe they just won't call them, I don't know that either. Gretchen Voss, I think, is the journalist who's like been in court, so I don't think they're going to call her. That doesn't really make a whole lot of sense to me as a potential witness. Another witness from the crime lab, Lucky Loughran, Brian Loughran. Maybe they're going to call him. I don't know. Some other just appear to be sort of random civilian people. 5 of them. Don't know who they are or what they would have to say. So yeah, we got a lot of options here. It looks like, if I'm guessing, we're down to the last of the law enforcement witnesses and then the state police, then the medical examiner, the medical examiner's staff. Some of these other people seem like maybe they're just superfluous. I don't know. I don't know who Stephen Bernstein from Stoughton, Massachusetts is, you know, or why he would be on the list. I don't know who Jean Demulis from Canton is. Don't know why she's on the list. So some of these people, it's kind of hard to evaluate. But I think we are getting down to the nitty gritty here. So if the theory that they're going to close with the angry voicemails is correct, it would make sense that maybe we'd be getting into the maybe we'd be getting into the medical examiner next and finish with the rest of these police. Don't know. Guess we'll have to wait and see. All right, guys, one more chat from KB. I think there's a possibility KR was in a true alcohol blackout, which is temporary amnesia. If so, she simply may not remember. It is possible. I mean, we can't rule that out. There is, you know, whatever weight you want to give this retrograde extrapolation. We know she had been drinking the night before. I don't buy Trooper Buchanan's drink count. Don't buy it. Watched it with my own eyes. Didn't see what he saw. Didn't see it substantiated by the receipts. But yeah, it's possible. It's possible. Highly functional if she was in fact in an alcoholic blackout. You know, most people who are not chronic alcoholics, you know, by the time you get to a blackout stage, you're going to already, so many of the depressive effects are going to be acting on you. It's going to be really obvious you're super messed up. You know, your coordination is way off. Your eyes, you know, are going to be all wonky. You're going to have a hard time speaking. You're going to be slurring all over the place. It's going to be a mess. I don't think you're going to be driving a car all that well. But it's also very common for people who are chronic alcoholics, people who have real resistance to alcohol. They can be in a blackout state and still be pretty functional. You know, they can have crazy high levels of blood alcohol and still be functional. The highest one I've ever seen on a police report was like 0.43. I mean, nuts. Almost half of your entire blood volume is alcohol in that calculation. It's crazy. There was a guy I remember in Tahoe. He was always getting booked up for public intoxication. This is when I was working in the clerk's office, because the clerk's office was right next to the jail. We would have joined the jail. And this poor guy, he'd get booked in for public intoxication and they'd get him to blow and he'd be something like, you know, 0.36, 0.38, you know, very, very high levels. And we'd hear him go through the DTs over there in the clerk's office. We'd hear him screaming back there. No, so sad and tragic and very, very unpleasant for everybody. Not a good way to get somebody off of the alcohol, locking them in jail. So, yeah, I can see a situation where she's perfectly functional to, you know, the outside observer, doesn't seem to be impaired by the depressive effects of the alcohol if she's a chronic alcoholic. You know, and she has built up that level of tolerance. I don't know that we have proof of that. I mean, maybe her, if anything, her health problem seems like it might complicate things. I don't know. Yeah, I just don't know. Can't say it's not possible. You know, it is. Yeah, it's possible she was in an alcoholic blackout. Shy Gal 8. Andrea, you are a natural at this YouTube law stuff. These last two made my brain hurt, and I love how you summed it up. Basically, nothing burgers mostly. Well, good. Thank you. I appreciate it. I'm just, you know, I've had to deal with this cell stuff in my own cases. I had to deal with this DNA stuff in my own cases. Thank God there's no ballistics in this case, okay? I'd be like raging at the screen. It's like one particular, you know, junky science area that just really, really, really gets under my skin. Oh, the ballistics are so bad. We don't have to deal with that here, so you don't have to hear that particular rant. But I mean, yeah, I've had to learn a lot of this stuff, and I've had to be able to make sense out of it for myself, for my clients, for the juries, and I'm glad that you guys are finding that helpful. Just BKZ, just because the lead investigator was Officer Doofy doesn't mean car accidents work like in Scary Movie. I think Officer Doofy was a little bit more, I don't know, maybe just a little bit less malicious. I get quite a bit more malice from our lead investigator here than I get from old Officer Doofy. Yeah, he's a little more than just doofy with this investigation. Kevin Dorr, look into Louise Woodward, shaken baby case in Boston, 1997. Convicted of second-degree murder. Judge reduced to involuntary manslaughter with time served days after sentence. I'll check it out. I don't know anything about this case. Shaken baby syndrome, man, another one. Don't get me started. It's bad. It's bad. There's like not science behind this. And yet there's a whole bunch of doctors and other types of medical professionals that will happily take a grieving family member who has lost their child and blame that person for injuries to the child based on this shaken baby, aka, this alleged shaken baby syndrome. So I'll see what that has to say. Yeah, I don't know much about how the sentencing works in Massachusetts. I can take a peek into that. So one area where judges often have a lot more discretion. Now, reducing a charge. Yeah, that's typically going to be harder. That is that sufficiency of the evidence type of situation where the judge is basically saying, even if you look at all this evidence in the Commonwealth's favor, it doesn't establish all of the elements of murder. The weak link in this case really is the mental state, is the intent. I don't know how the Commonwealth is going to get there. I just don't know how they're going to get there, because you can get to hostility and anger and stuff like that, but that doesn't rise to intent to kill. To prove intent to kill is pretty hard. It's very specific. Not just I intended to scare him, not just I intended to express my anger, not just I intended to hit him and maybe hurt him with my car. Intent to kill, pretty specific. So that's the big weak link I see in their proof so far, and that's where, if there's any leeway here, any kind of wiggle room. Not that I really expect Judge Bev to be giving Karen Reed the benefit of the doubt here when it comes to the charges that go to the jury. But if she did, that's where I would see that wiggle room, is on the intent element, and that is kind of similar to this case. Second degree murder. There's different ways of committing it in Massachusetts, but I'm going to assume it's an intentional, just based on the theory, shook a baby. Reduced it to involuntary manslaughter. That's likely indicating you can't meet the mental state requirement. You can't show she intended to kill him. Maybe at best you can show some kind of reckless behavior that she did, not intending to kill him. Criminally negligent behavior, not intending to kill him. It just created a risk. And that ultimately resulted in the death. So I'll take a look at that. I'm making a note, Louise Woodward. Do it on my little pad here. All right, guys. Well, I guess we're going to see what we get tomorrow. Fingers crossed. What are the odds the Commonwealth is done tomorrow? Is it possible? Is the defense going to get 2 weeks? 2 weeks out of 9 to present their case? Does that seem like too big of an ask? Doesn't seem like too big of an ask to me. It seems like still overall a pretty small proportion of the total time. And how much is Lally going to want for redirect, for his rebuttal case? I got to assume he's going to want a rebuttal case. So even 2 weeks left, that can't all go to the defense. They'll allocate some of it for rebuttal. I'm just praying. I would like to be done with direct. I really would. I would like to be done with Mr. Lally's case in chief, because I don't feel like it's taken us anywhere fast. I'd like to just get to the point, get to the rest of the stuff we know is coming, get to the medical examiner. We want those details. Put the voicemails out there. We know what they are. That's fine. Go ahead and finish with that. It's fine. Give us the extraction, all that kind of stuff. And let's just move on. Let's just get to the point. I don't know what all these other people are going to have to say. We don't actually have to call every single person who set foot on the scene, or did something in the course of the case. Like I hope he is aware of that. Doesn't seem like he's necessarily aware of that so far, because like there's a reason why we heard from, was it 11 firefighters, 12 firefighters, something like that. We had to hear from every single one who had any involvement at any point there. You don't actually have to do that. You can just present the one that has the best evidence that you need to put forward, and if the defense thinks there should be more, they can call him. That's always possible. So I have my fingers crossed. Lally, trim your list. Get us down to the bare bones that we need to still finish. Let's be done tomorrow. Please, please. Let's be done tomorrow. Give us the medical examiner. Give us Guarino. I don't know if we could get both of those done in one day, but I'd sure love to see you try. And then be done. And then be done. I just don't know that we need the rest of this. But we'll see. Guys, it's been a good week. Been a good week. One more full day. These early mornings are not so bad anymore. Not so bad. I mean, I had time for the curling iron, for heaven's sake. I mean, you know. And now we got some more baseball, man. We got to close out this series. We got to close out these series. I'm going to sit back humbly and wait to see what we get. See if we get a good start from Nola. I could blame it on injuries. You know, we're losing a lot of guys here. We've lost Trey Turner for quite some time, our shortstop, and he was on a roll, man. He was on fire when he got hurt, got a hamstring injury. And we just lost JT Realmuto, our catcher. JT is my boy. Okay, JT is who's on my jersey. Lost JT the other day. We got a lot of these kind of second string people filling in some of the gaps. So, you know, I mean, it's pro baseball. You gotta have some basic skills, but I could blame it on that, but I'm not gonna, you know, it's just everybody's gotta lose sometimes. It's just how it goes. You can't win every single game, but I really want to win tonight. So I'll try not to be too irritating tomorrow if we do. So I'm off, guys. I'm gonna go watch myself some baseball. Enjoy this beautiful afternoon we have here. I think I might go mow my grass. It's a really nice day outside. In fact, nice balmy 89 degrees according to my weather station. It's perfect. So guys, take care of yourselves. Thank you so much for being here. Thank you for joining me. Thank you for all of your support. Thank you for having so much fun in the chat. It's such a pleasure to get to peek over and see all your clever comments and so many wise people with good information here. Quokka here dropping the cell site, the DNA data on us, the mitochondrial DNA, like how all this stuff works. Fascinating stuff. Very honored to have all you guys here and contributing to the conversation. So thank you so much. Really look forward to seeing you guys tomorrow. See what we get. Fingers crossed. Could this be it? Hate to get my hopes up, but I'm an optimist. So we'll see what we get tomorrow, guys. Look forward to seeing you bright and early. And do take care. Enjoy your evenings.